Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and enjoy the show.
That's okay. I'm gonna, I'm fine. Okay, we're gonna call the interpreter and,
Good afternoon, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
is that meant for me? Oh, both of those. Sorry, you gotta talk a little louder for me. All right, your name, please, sir?
Hola. Marco. Oh. Marco Salcedo Hernández.
Marcos Salcedo Hernandez.
Así es.
All right, Mr. Hernandez, sir, you are here on the following charges. They are possession of methamphetamine with intent to sell, possession of drug paraphernalia, possession of a controlled substance within 1,000 feet of a worship, possession of a controlled substance within 1,000 feet of a school, and then a second case under 2022 MO, I think it is, yes. 649 is prohibited activities in the park, alcoholic beverage open container, camping prohibited, and then it says state misdemeanors.
So,
It's usually a trespass, Your Honor.
oh, she's on. Your Honor, I would argue no PCS to the possession with intent to sell. I don't even see a,
Sorry,
There was a wait.
you don't
Much.
see what now?
I don't see the weight.
Some glasses on.
Don't you see?
Seems like
Weight, how much was it?
8.96 grams.
I still will argue that's not enough. He didn't have any large amounts of cash. No scales were found. I don't see anything mentioned about him carrying multiple individual baggies to sell the product in, Your Honor. Based on this arrest affidavit, all I see is possession of meth and possession of cannabis, not with intent to sell.
And the state's position on the, they're charged with possession of methamphetamine with intent to sell, not the coke, not the cannabis.
That is correct, Your Honor. Just for the record, the weight of the meth is 8.96 grams, and they were in 4 small plastic baggies each. The defense is correct. There would be no other indicia of intent to sell other than the packaging and possibly the weight.
Okay. And is the state's argument that is sufficient, or does the state agree? Because it still has the others set at the higher bond. Possession of controlled substance.
Well, Your Honor, if the issue is that it then removes those other 2 charges.
Correct. So what is the state's position? I need to know that.
To be honest, Your Honor, I agree with defense.
And that's all, right, that's what you're supposed to do. I mean, not necessarily agree with them, but to provide the court with information that you know in the case law that is also applicable. So at this time, is there any request for an additional time or agree that?
No, Your
actual
Honor.
facts?
No, Your Honor, I do not believe that this rises to the level of intent.
Okay, so at this time, the court finds PCS, possession of methamphetamine, possession of drug paraphernalia, the controlled substance within the 1,000 feet of worship, that does not have to be with intent to sell, correct? I'm just asking.
Your Honor, I'd have to double check, but I believe the statute specifically is with
Intent
intent.
to sell. Okay.
I apologize, Your Honor. Can you give me that case number, please?
Sure, the one that.
The 22 CF.
Sure, it's, oh, gosh, I barely read their writing, 10665AO, sorry. Some are typed in some are handwritten.
That's
Well, I'll appoint the public defender's office. In the meantime, you're not to possess any drugs without a valid prescription, drugs or controlled substance without a valid prescription. Do you understand that, Stone?
Sí.
Yes.
Your Honor, I would also ask that he not return to, I believe it's the park.
Correct. I'm going to require you not to return to the scene of where this occurred.
¿Me permiten tantito hablar?
I don't know.
Can I say something?
Your attorney may not want you
No.
to.
No, could you please advise the client, I recommend he not talk about the facts of the case. Everything is being recorded and it can be used against him later. I would recommend he wait until he gets one-on-one with his attorney to speak about any facts of the case.
Your Honor, it does not necessarily have to be with intent, but it does say person may not sell, manufacture, deliver, or possess with intent to sell,
Okay.
manufacture or deliver within the 1,000
It
feet.
might be the delivery that I'm recall seeing the majority of those under the 1,000 feet. So, it would not include mere possession.
Your Honor.
Okay. So, as to count one, the possession, court finds PC as possession of methamphetamine. I will set bond in the amount of $3,000. Possession of drug paraphernalia will remain the same at $500. State agrees to count 2 and 3 would be no PC and ROR.
3 and 4.
I'm sorry, 3 and 4. Yeah.
Agreed, Your Honor.
And per state, okay, I just don't know what you're used to, how much you're used to writing. And then as to the second case, all bonds will remain the same as previously listed. And I find PC 250, 250, 250, and 250. And once again, sir, you're not to return to the scene of where this occurred. No drugs or possessed without a valid prescription.
Your Honor, if you like, I can relay an offer for the city cases, which would be a withhold of adjudication and credit time served. For the city cases, which is the 22 MO, I believe you said 649.
I just don't speak Spanish, Your Honor. I was not able to relay the offer.
Right. And sometimes with the attached felonies, since they're so integral,
Yes,
but understanding that they're, you can always have that brought up early, if that's the resolution. All right.
Okay.
You have the public defense. Thank you, sir. All right. We have, I think, one more interpreter case. Sorry. So your name, please?
Joel Moreno Hernández.
Joel Moreno Hernandez.
Sir, you're here on a charge of aggravated assault with a firearm. I reviewed the charge and affidavit. I do find probable cause. I will appoint the public defender's office to represent you. And does everybody agree he's entitled to a bond on this matter?
Yes, Your Honor.
Okay. Is there anything else further requested from the state? Side, no weapon, no firearm, and no contact.
No, Your Honor.
At this time, sir, I'm going to set bond in the amount of $3,500 with the following conditions. You have no contact with the victim, sir, and you're not to possess any weapon or firearm. Do you understand that?
Sí, entiendo.
Yes, I understand.
All right. And the public defender's office has been appointed.
And Your Honor, can you also advise the defendant he has an immigration hold?
You have an immigration hold.
Perdón.
No.
Well, according to corrections, you do.
Oh, no, yo no tengo nada con migración.
No, I have nothing to do with immigration.
Could you please advise the client that immigration has placed, there's a hold placed on him by immigration. He's not going to be able to bond out until it's cleared.
Okay.
Thank you.
Okay.
All right.
And Your Honor, may the interpreter ask for this CF number?
Oh, yes, sorry about that. It's 2022 CF 106150.
Thank you, Your Honor.
You're welcome. And I believe that concludes that we're aware of the interpreter cases.
Thank you, Your Honor. Have a great day.
You do the same. Thanks a lot. Bye-bye. Right, I'm ready. Oh, I'm sorry.
We have the sign, but the interpreter, the translator not there, so we might.
Okay. Okay, we go to, you said call, and it says video conference, and then I hit call again, correct?
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
Okay. Okay. So we just, okay. Okay, let me get my, sorry, I've got to get everything in kind of an order here. All right, is Thompson the one that needs to sign? Okay. All right. Yeah. All right, there's your little list. All right. And I'm sorry, who is this? Or somebody was telling me about somebody else? Okay. That's who? Okay. Is this that gentleman? Okay.
Jose Morel Torres, Your Honor.
Okay, sir, you're here on a charge in case number 2022 CF 106328. The charge is burglary of a conveyance, and count 2 is petty theft. I've reviewed the charge and affidavit, sir. I do find probable cause. You do qualify for the public defender. I will appoint them to represent you on the case. And at this time, sir, the bond will remain the same at $3,500 under count 1, $100 under count 2. You're to have no contact with the victim, sir, and you're not returned to the scene of where this occurred. Okay?
I'll say, Your Honor.
All right, thank you. Was there anything further from the state on the matter or the defense?
Nothing from the state.
Nothing from defense.
Your name, please?
Lloyd Courtney Roberts, Jr.
Mr. Roberts, sir, you're here on a charge as follows, sir. It's arson to a structure known or believed to have been occupied, 2 counts of that, and criminal mischief, 2 counts, sir. I'm going to appoint the Public Defender's Office to represent you on the matter. And is there anything further from the state or the defense? He's out on, it's odd. It looks like there's a plea on it, then it looks like there was a slash through the plea sheet on the battery charge. I assume it was not taken. There's a J&S filed under the MM number.
I have it closed. What do you have?
There's a line through it,
I had it
so.
closed as well. I'm double checking the clerk's site, but I had it closed too, that he entered a plea on 7/25.
Right.
I do as well, Your Honor.
There's a J&S, but then there's a line through it, and I don't know if that was because, I don't know. Sometimes if they're typed incorrectly, you know, they'll put a line through and then file the next one, but I think it's just really an unknown variable. Don't you all agree?
Yeah, it's closed in our system
Is it?
on 7/25, stating that he pled.
There is an order to place him on pretrial release that was entered July 29th, which would be after the fact.
He's on county probation.
Doesn't make sense, though.
It doesn't make sense. Why would he on
I have-
pretrial release? What?
It says, from the plea, it looks like it says battery, 6 months supervised probation. So
Doesn't make sense.
I have no idea. This
I
is
don't
weird.
either.
Because it's still showing closed, just says 6 months probation.
Right. And then I show then it says PTR, and then it has a line through the plea form. I think somebody's gonna have to go back and listen to the record, to be honest. I don't know. Probation is pretty good about getting a warrant issued, coming in and,
And since we don't know, Your Honor, I just ask that you
yeah.
take no action on the out on bond, because
Right.
okay.
He might be on probation, but
Yes, Your Honor, I believe he is on probation.
why is that plea form marked through?
I have no idea.
I mean, the judge's order. I don't know, unless there's something in it. Okay, well, he's not out on bond. Let me rephrase that. We believe he is not out on bond based upon the information that everybody, both the defense and the state can tell. So at this time, as to the charge of arson, I've appointed the public defender, sir. You're to have no contact. You're not to return to the scene of where this occurred. Do you understand that, sir? Okay, sir. And bonds will remain the same. I won't take any action on that. They may, I guess, you can contact probation to see,
Yes, Your Honor.
but you're usually pretty quick. All right, thank you, sir. See that line through it? Oh, that would have been it then. That would have been it. Okay. Sir, your name, please? Sir, you're here on a charge of battery on a corrections officer, sir. At this time, I find probable cause. I'm going to appoint the public defender's office to represent you on the case, and the bond will remain at $3,500, okay? All right. Thank you, sir. I know.
I'm not doing what you.
Does not, okay.
Good afternoon, Your Honor.
Good afternoon, sir. Your name, can you tell me your name, please?
Ryan Fitzgerald Waterman.
All right, you're here on a charge of driving under the influence of alcohol, sir. And at this time, sir, I find probable cause. Can you just tell me one thing? Are you going to hire your own attorney, or you want me to look at getting you an attorney?
I'm going to hire my own attorney.
Okay,
If I could make one request, I've been at the psych ward since last night, so I could really, I haven't been able to notify my family or call my girlfriend or let my dog needs to go out.
okay. Well,
Um,
do you want me to,
Not at a risk to myself or others, I promise. I want to be able to contact them.
well, are you making 600 a week? You make that?
Yeah, you generally, it depends on the job. Like I do construction, so it depends, like if we finish on a Wednesday, we usually won't start a new project till Monday.
Okay, let me just ask you this one question. Is it ever below that? Is it
Yes,
sometimes?
yes,
So-
that's where it caps out.
Okay.
That would be if I had full days every day.
Okay, so could it be I'm not putting words in your mouth. I just don't, do you want me to look at appointing the public defender? Or are you sure you're gonna be able to hire your own? Because you would qualify, and you can always hire an attorney, and then they can file a notice, and the PDs can come out of the case.
Yeah, but if we could look into one, whatever you recommend.
That might be, well, it looks like, so your range is what? You range, what's the amount that you arrange each week? What's your?
400 to 600.
That's, okay, then you would qualify, my understanding, if you take that average, okay? And that's, oh, let me write per the defendant, because I wrote on that, per the defendant. Per defendant. And and the reason I asked you was it was just right there under it, and I know there might have been a range.
Yes.
So I wrote on there 400 to 600 per to the defendant, okay?
Okay, thank you so much.
You're welcome, sir. Let me just go ahead and finish this so I can
Okay.
got the PD appointed.
Excuse me? I haven't gotten any paperwork. I've been. Oh, I have my dad's, and then I was gonna use his number to get my girlfriend's number.
Okay.
You're 407 497 3373. And it's Ken Waterman. He's my father.
All right, let me just add one other thing. You're not to consume any alcohol, do you understand that?
Yes, yes, ma'am.
Bond will remain at $500, and no, you cannot possess or consume any drugs without a valid prescription.
Yes, of course, yes, ma'am. Also, so I'll be able to post bail now, right? Because,
You have a bond, yes.
okay, because I've been without my bipolar medication for over 24 hours now, and my doctor says that it can make me prone to seizures. I think that's why they locked me downstairs initially. I think there was a misunderstanding that,
Okay, well, I'm sure corrections will follow through on any type of medications, that is required, okay? Right, but no alcohol.
Yes.
And no drugs without a valid prescription. Your name, please?
Benjamin Contreras.
Mr. Contreras, sir, you're here on the following charge, sir. It's a charge of attempted lewd assault upon a child and indecent exposure.
I was walking down the
I
sidewalk.
would not talk about the
Yeah, she doesn't want you to say anything. Your attorney, that's your attorney. They don't want you to say, we're gonna get them appointed. Is there anything further from the state?
No, Your Honor.
Well, why I feel so
Obviously,
sad.
no return to the scene.
Yes, Your Honor.
Mr. Contreras, sir, at this time, the bonds are set at $2,500 and $100. You're not to go back to the scene of where this occurred, okay? But you've got an attorney now.
2,500 and 100. So how much I need to get out?
Oh, and no contact with any of the witnesses or the victim. Thank you. Should that put us like in a pattern? Okay. All right, and we're waiting on her. Yeah, let me just have them all. It's easier when I. Okay, thank you. Yeah, I'm more of a. Bless you.
Thank you.
I do, because I'm doing, she knows, because I'm already down at the bottom. All right, we have arraignments, I believe, is that what we're doing?
One moment.
Okay, let me get logged into the system here.
Step back down there.
Your name, please? Oh,
Bailey, Your Honor, is restricted medical.
okay.
Bailey.
He's on the arraignment docket.
I will waive and enter plea of not guilty, Your Honor.
Okay. This time under 2022 MM 5287AO, waiver of arraignment, plea of not guilty. Matter will be set for pretrial. I don't know who she's saying.
Cheney and Pew Sanchez, and go to Mr. Stokes, he's medicals also.
Okay, I think I need to kind of do an order. I'm sorry,
Okay.
because y'all, can you tell me what I'm doing? I mean, is it an arraignment or is it an IA or?
It's arraignment.
Arraignment. So
Yeah.
the next person I have is Damon Cheney. Is that,
He's coming around the corner, but
okay, then you would like me to skip that. The next person that I have after that is Pugh Sanchez. Oh, they're bringing, okay.
it's Cheney right here.
Around the corner, I don't know. All right, sir, your name, please.
Damian Cheney.
Mr. Cheney, sir, you're here on case number 2022 MM5299AO. It's a violation of domestic violence injunction. And at this time, the Public Defender's Office has been appointed to represent you, sir, on the matter.
We will enter a plea of not guilty, Your Honor.
We have not guilty is entered, and we'll get you a pretrial date, okay? Your name, please? Can you tell me your name?
Nestor.
I need,
Nestor Sanchez.
all right, Mr. Sanchez, sir, you're here in case number 2022 MM6154AO. The charge is petty theft. The Public Defender's Office has been appointed to represent you, and information has been filed. How is your client wishing to proceed?
The offer from the state, Your Honor, is an adjudication of guilt, credit time served, no return to 900 East Washington Street. There is a cost of investigation of $73.48 to the Orlando Police Department. There is also a cost of investigation, looks like of $57 to the UCF Police Department. There is restitution in the amount of $60 to Cavo's Bar, and Mr. Pug would like to accept and enter a plea of no contest.
Okay. And is this the agreement of the state?
Yes, Your Honor.
And you've advised your client of the enhancement provisions to this?
Yes, Your Honor.
Mr. Sanchez, sir, it's my understanding you wish to enter a plea of no contest to the charge of petty theft, a misdemeanor of the second degree that was occurred on or about the 18th day of June, 2022. This was a flag or flagpole from the Cavo's Bar and Kitchen, and enter a plea of no contest. Is that correct, sir? That you want to plead no contest?
No contest.
Is this your signature, sir, that is on this plea form? I got to have you talk a little louder.
Yes.
Did you read and understand the rights on the plea form? Did you understand the rights on the plea form?
Yeah, yeah.
And, yeah, did you have a full opportunity to discuss these rights that you're giving up by entering the plea with your attorney? Did you have an opportunity to do that?
Yes.
Do you need any further time to speak to your attorney on this matter?
No,
Yeah.
no.
Okay, yeah, I'm the one that I know they can hear you. I'm the one that's got to hear in the recording. Are you under the influence of any alcohol, drugs, or medication that could affect your thinking today?
No, I'm good.
He said, no, I'm good. Just say it a little louder.
I'm good. No, no.
Okay, and you understand this is an enhanceable offense, meaning that if you've committed another theft charge, the state can use that to enhance the next charge. I mean, let's hope there's not a next charge, but that this is an enhanceable offense. Do you understand that, sir?
Yes, I understand.
Do you further understand that by entering the plea today, it will subject you to deportation if you're not a U.S. citizen?
Yes, I am.
And at this time, now that I've asked all those questions, do you still wish to enter your plea of no contest to the charge of petty theft?
Yes, I am.
I'll accept your plea. I find freely, voluntarily doing so and understood the rights you're giving up. I have reviewed the affidavit. I'll adjudicate you guilty. I find sufficient facts to do so. I will sentence you to 32 days in jail with credit for 32 days' time served. You'll be released today. I will require you not to return to the scene of where this occurred at the Cabos Bar, the 900 East Washington Street in Orlando. There's $73.48 cost of investigation to Orlando Police Department, $57 cost of investigation to UCF, $60 restitution to Cabos Bar. Now, what will happen, sir, you don't pay them individually, everything gets added up. You will pay the clerk of court, and they will disperse the funds, so you don't go paying anybody individually. And the court cost and the $50 public defender lien, and I'll give you 1 year to pay that off, but you can go start a payment schedule in advance, okay? Do you have any other questions? And he has the right to appeal the sentence, must do so in writing. Within 30 days, can't afford an attorney, who won't be appointed to represent him.
He looks like an attorney.
Right.
He does.
I think it's an attorney.
It's an attorney. Yeah.
Yeah, he's not the sign
He's
interpreter.
not the sign.
He's a private attorney.
Yeah. No, it's not, you know, that's okay, I am used to a courtroom. Okay. What case are you on?
Afternoon, Your Honor. Jason Bankowitz. I have Jabarius Bush.
Who is out on bond
Yes, Judge.
on the same charges?
We were going to ask you not to take any action based on the fact that the state has had that old defense for about 2.5 months. and
We'll address it,
hasn't made
we'll
a
address
charging
it when he,
decision.
okay, we'll, yes. All right.
I understand, Judge.
I don't think they had, we thought, well, we had you pulled up. To be honest, we didn't even know to do this, except we were waiting on a Spanish interpreter. And so everybody looked up and we're like, that's not, you know, we knew who you were. And so we're trying to get the Spanish interpreter up, and so we have not. I mean, sign, I'm sorry, sign, thank you. So who do we have in here now?
We have one more arraignment, which is medical,
Thank you. Oh, okay.
Stokes.
So Stokes is not in here then. Okay, let's go ahead and do Stokes. This is a charge, this is in 2022 MM 191 AE. It's a charge of criminal mischief and resisting officer without violence.
And Your Honor, I will waive and enter a plea of not guilty.
Okay. And I'm showing one more arraignment. I'm showing a couple more arraignments. I've got Williams, Yasha Williams. Williams.
We have Kiasha Williams or Kiasha.
She wasn't in Orange County Jail. She hasn't been in the jail for some time.
Okay, I'll let them kind of explore this while they're,
It's because sometimes I'm wrong.
Maybe she's here. Okay.
okay. I just want to make sure she's not sitting in jail, you know, and doesn't get arraigned. All right, so who do we have?
We can do Mr. Bush, which is here.
We can do Mr. Bush, that's fine. Mr. Bush, if you want to come on up.
Your Honor, I'm going to step out and use the restroom while you do this.
Sorry, I'm like,
Too much water.
all right. Mr. Bankowitz, can you hear us okay?
Yes, Your Honor.
All right, let me turn you up a little bit. I'll try, but I don't want to lose you. Okay. Let me get the case, because we kind of had these. All right. Do I have this Bush pulled separately yet? Nope. Okay, let me find him. Yeah, he's. Thank you. All right, we're good. You got it. All right, sir, would you tell me your name, please?
The bar is Marquise Bush.
Mr. Bush, sir, you're here in case number 2022 CF 10652AO, and it is a charge of possession of cannabis greater than 20 grams, and possession of drug paraphernalia. And you are also out on bond, sir, on a case 2022 CF 7485AO. And at this time, I've reviewed the charge and affidavit. Under the new case, I do find probable cause. And at this time,
Your Honor, Mr. Bankowitz is correct. In 22 CF 7485, defendant was arrested June 28th. State has not filed formal charges. However, as these are almost identical charges, I would at least ask that you revoke and double as opposed to taking no action whatsoever, Your Honor.
Mr. Bankowitz?
Your Honor, if the court is so inclined as to do even that, it is revoke and then just set a new bond and double the amount, we would take that, Your Honor. Again, that was our main argument, was just that they still haven't made a charging decision on that existing case, and they've had it for a bit. So we would ask the court not to take action, but if the court is so inclined as to set a higher new bond, that would be great as well, Judge.
The court at this time is going to revoke the bond, but the court is going to set bond at none. Mr. Bankowitz, understanding the state hasn't charged the charge, but understanding that your client is out on bond and picked up similar charges, the court finds that revoking the bond is appropriate under 2022 CF 7485AO. And obviously, it doesn't prohibit you from filing a motion to set bond today. I mean, when I say set it today, but it doesn't prohibit you from taking those actions that are necessary to have that heard and further argument in front of that division assigned, okay?
Yes, Your Honor. Thank you.
Thank you.
Your Honor, what is the bond amount for the new offense?
I'm keeping those the same.
Thank
I'm
you.
not raising those. But I do need to advise Mr. Bush, sir, if you, under the new case, you are not to possess or consume any substance, controlled substance or drug without a valid prescription. Do you understand that, sir?
Yes, ma'am.
And you need to understand, sir, if a bond is granted on the one that I revoked the bond on today, you still have, on the new case, a bond with those conditions. And if you pick up another charge, the court could revoke that bond also. So you just need to understand the court's order, okay?
Yes, ma'am.
You've got excellent attorneys, but the court has made that decision based upon all the factors of the case, okay? All right, thank you. Thank you again, Mr. Banquist.
Thank you, Judge. Good to see you.
Great seeing
Or
you.
hear you, I guess, really, from this angle.
I can see you.
Have a good one.
All right, thanks a lot. Have a great one.
You too.
All right.
You are the only participant.
Okay, thank you. I think we're back in our orders of Mr. Dunlap, sir. Is that correct, sir?
Yes.
All right, Mr. Dunlap, sir, you're here on the following charge, sir, and it is let me grab these things and get these out of the way. I probably should let you hold that, shouldn't I, the signed case? All right. You're here, sir, on a charge of possession of drug paraphernalia in case number 2022 MM6249AO. And I do find probable cause, and at this time,
Your Honor, with regard to the case just mentioned, 22 MM 6249, possession of drug paraphernalia, state announces a no information.
okay.
And then as to the other two charges, Your Honor, 2022 MM6254AO.
Yes.
The offer is an adjudication of guilt, credit time served, and no return to 1436 22nd Street. I believe that's in Orlando, Florida. And Mr. Dunlap would like to accept it until plea of no contest.
Okay, so I've got the loitering and prowling and the resisting without violence. That's the 6254, and that's the one he wants to enter the plea of no contest. And the state has announced, did you say a no bill?
Yes, Your Honor.
No bill on 6249, so he'll be released under that case, under the no bill. And is this the agreement of the state?
Yes, Your Honor.
All right. Mr. Dunlap, sir, at this time, it's my understanding you wish to plead no contest to the loitering or prowling and also the resisting officer without violence. Is that correct, sir?
Yes.
Is this your signature that's on the plea form?
Yes.
And was the PD appointed? Did he fill out a paperwork?
Yes.
Oh, he did.
You didn't sign it.
I know.
Oh, sorry. I'm in court. I'm so used to
We're
walking
doing
up,
it,
so, and is that, you stated that was your signature, and did you understand the rights you're giving up by pleading here today, sir? Do you have any further questions regarding the rights that you're giving up?
No.
Are you on probation for any other charge?
No.
And are you satisfied with the services of your attorney?
Yes.
At this time, sir, I will accept your plea. I find sufficient facts to do so. I'll adjudicate you guilty on both of the counts. I will sentence you to, looks like 1 day, because it came in right after midnight, 12:01. 1 day in jail with credit for 1 day time served. You'll be released today on this charge. And I will require you not to return to the scene of where this occurred, and that was at the, I believe she said, 1436 22nd Street in Orlando.
Yes, Your Honor.
Okay? And you're not to return to that location. There's also the mandatory court costs in the public defender lien, and they're going to put you under, I'm going to give you 1 year to pay that. If you can't pay it off within the 1 year, make sure you go to the clerk's to try to get a payment structure. Okay? Do you have any other questions? Any questions? All right, sir, and the state's announced a no bill on the other case, and you have the right to appeal the sentence of the court. You must do so in writing within 30 days. If you can't afford an attorney, one will be appointed to represent you.
Your Honor, are you taking any action on his out on bond?
And since he's pled to the new case, is there a request? There's no request from the state on the out on bond, is there?
No, Your Honor.
Okay. No action. Pled to, and then we'll put the other case number on it. Okay? Sir, if you want to come on up, I just don't know who we have. Mr. DuPont?
Tyrone DuPont.
All right, Mr. DuPont, sir, you're here on a charge of trespass after warning, and at this time, the PD is appointed, or I think qualified, and at this time,
Your Honor, the offer from the state is an adjudication of guilt, credit time served, and no return to 4104 Millennia Boulevard. And Mr. DuPont would like to accept and enter a plea of no contest.
is this the agreement of the state?
Yes, Your Honor.
All right, Mr. DuPont, sir, it's my understanding that you wish to plead no contest to the charge of trespass on property after warning, and is this your signature, sir, that's on this plea form that you signed? Yeah, you can talk, thank you. All right, sir, did you understand the rights you're giving up by pleading here today? Did you understand those rights? Are you on probation for any other charge? And are you satisfied with the services of your attorney? Okay, and are you entering this plea on your own free will because this is what you want to do?
Yeah.
Okay, I mean, it's in your best interest to do that, is that correct? I'm sorry? Okay, do you still want to enter your plea of no contest to the charge then? Okay, do you still want to plead no contest, like your attorney said you wanted to do?
Yeah.
Okay, I know, no contest is a different kind of word. I'll accept your plea. I find sufficient facts to do so. I'll adjudicate you guilty, sentence you to 2 days in jail, credit for the 2 days you served, so you'll be released today on the charge, okay? You cannot return to 4104 Millennia Boulevard here in Orlando. You cannot go back there. And they're gonna give you the court cost and the PD lien, and I'll give you a year to pay that, okay? And if you can't pay it, go to the clerk's office to get a payment plan set up, all right? Okay. Thank you, sir. I previously advised you of your right to appeal the sentence. Yeah, but, Eric, that's all right.
Yes, Your Honor, could we reset for tomorrow? There is an offer on both cases, so.
Okay.
Mhm.
Do you want them to pull the other case up, on the one out on bond on?
I would just ask that you take no action until tomorrow.
Okay.
There's an offer to resolve both.
Okay, got it. All right. So we'll reset with sign interpreter tomorrow on Tyrone Thompson, 2022 MM 6235AO. Okay. And there's his, oh, you don't want that. All right. Can you tell me your name, sir?
Yeah, my name is Darius Hardaway.
Mr. Hardaway, sir, you're here on a charge of assault on a public transit employee. I'm going to appoint the Public Defender's Office to represent you, sir. This is in case number 2022 MM 541AW. And I suspect, is there an offer?
No, Your Honor, there is no offer.
All right, Mr. Hardaway, you cannot have any contact with the victim. Do you understand that? You can't go,
ma'am.
you can't have any contact. Bond will remain the same at $500, and you've got the Public Defender's Office appointed, okay?
Yeah, okay, so what's the deal then?
Your attorney's gonna write some information down and has given you that sheet there.
So
Yeah.
what, I gotta come back to court?
Yes.
Yes, sir. You'll come back to court, uh-huh.
But see, whole thing, I wasn't even on the bus. How can I saw somebody?
Your name, please?
Heather Essex.
Ma'am, you're here on a charge in case number 2022 MM 6232 AO. The charge is trespass on property other than a structure or conveyance. Public Defender's Office is appointed, and at this time,
The offer, Your Honor, is an adjudication of guilt, credit time served, no return to 1314-141 22nd Street in Orlando, Florida. And Ms. Essex would like to accept and enter plea of no contest.
all right, is this the agreement of the state?
Yes, Your Honor.
At this time, Ms. Isaacs, it's my understanding that you wish to plead no contest to the charge of trespass on property other than a structure or conveyance. Is that correct?
Yes.
Is this your signature on the plea form?
Yes, ma'am.
Did you read and understand the rights on the plea form and understand all the rights you're giving up?
Yes, ma'am.
All right. Are you on probation for any other charge?
No, ma'am.
And are you satisfied with the services of your attorney, with them helping you?
Yes.
Okay. And do you still wish to enter your plea of no contest?
Yes, ma'am.
Okay. Everybody shakes their head, but we're recording, so I know people can hear and responding, but it's just we have to have the record. And at this time, I'll accept the plea. I find sufficient facts to do so. I'll adjudicate you guilty, sentence you to the 2 days you served in jail with credit for the 2 days' time served. I will require you not to return to 1314-141 22nd Street in Orlando, Florida. You'll be able to get it off of that if you need it. Okay. And also, there's mandatory court cost and the public defender lien, and I'll give you a year to pay that. And if you haven't, if you aren't able to make the payment, go to the clerk's office and set up a payment schedule.
Okay.
Because then they can start doing it. You can do it monthly, okay?
Okay.
All right, I previously advised
So
you.
I
of
can
your
go
right
home
to
now.
appeal the sentence. You can.
I can go home.
This case you released on today, yes.
Judge Clark, just as an aside, do you spell your last name with an E at the end? No. Okay, thank you. And your first initial?
In.
Thank you.
Your name, please?
That's Jones, ma'am.
Mr. Jones, sir, you're here on a charge of trespass on property other than a structure or conveyance. And this is in case number 2022 MM6231AO. I will appoint the Public Defender's Office to represent you on the matter, and at this time,
The offer, Your Honor, from the state is an adjudication of guilt, credit time served, no return to 1314-141 22nd Street in Orlando, Florida. Mr. Jones would like to accept the plea of no contest.
all right, and is this the agreement of the state?
Yes, Your Honor.
All right, Mr. Jones, sir, it's my understanding you wish to plead no contest to this charge of trespass on property other than a structure or a conveyance and plead no contest. Is that correct, sir?
Ma'am,
Is this your signature that you signed on the plea form?
ma'am,
And did you understand the rights that you're giving up by pleading here today?
yes, ma'am,
And are you on probation for any other charge?
ma'am,
And are you you're not on any probation?
ma'am,
Okay, and are you satisfied with the services of your attorney?
yes, ma'am,
All right, sir. And do you still wish to continue with your plea of no contest?
yes, ma'am,
I'll accept your plea. I'll find facts to do so on what they charged you with. I'll adjudicate you guilty, 2 days in jail with credit for 2 days' time served. You'll be released today on this charge. I'm going to require you not to return to 1314-141 22nd Street in Orlando. Do you understand? You can't go back there.
yes, ma'am,
All right, sir. There's also the mandatory court cost and the public defender lien. They're going to add them together. I'll give you 1 year to pay those, court costs and PD lien. And you can go to the clerk's office to start a payment plan to pay monthly instead of waiting to pay it all in 1 year or to pay it with that, okay?
yes, ma'am,
Do you have any other questions, sir?
ma'am.
All right, sir. I previously advised you of your right to appeal the sentence. Thank you, sir. And if you all print, I'll sign. That's all right. When you do, though, I don't mind. Sir, your name, please?
John Jordan.
Mr. Jordan, you're here in case number 2022 MM6246AO. It's a charge of trespass on property after warning, and I'll appoint the Public Defender's Office to represent you.
And the offer, Your Honor, from the state is an adjudication of guilt, credit time served, no return to 7900 South Orange Blossom Trail. Mr. Jordan would like to accept and enter plea of no contest.
Can the attorneys please approach? Any objection to going off the record? Now, Mr. Jordan, you need to understand, sir, you've been trespassed from there. You cannot go back there.
Okay, I was getting fed there a few times.
Sorry, I just can't hear you. It's not
He
you.
stated he was getting food there.
Okay.
I guess people were giving him food.
Somebody I knew there was.
Somebody he knew there was providing him food to eat.
You know, there's a lot of resources in the community to help you with food. You know, I mean, there's different resources within the community that will help you, but you can't go back here, whether you're going to have some other option when somebody's offering some food for you or services for you. You can't go back there. Do you understand, sir?
Yes, Your Honor.
Okay, sir. Because I suspect next time it's going to be a lot longer sentence. Okay? At this time, is this your signature, though? We'll go back to the plea form. Is that your signature that you signed on the plea form?
Yes, Your Honor.
Okay. Do you have any other questions regarding the rights that you're giving up by pleading here today? Do you have any other questions? Okay. Are you on probation for any other charge?
No.
Okay. And are you satisfied with the services of your attorney? Are you satisfied with her services? Okay, sir. And do you still wish to plead no contest to this charge of trespass on property after warning? I'll accept your plea, I'll adjudicate you guilty. I'll sentence you to the 2 days you served in jail with the credit for the 2 days, so you'll be released today. And at this time, sir, I will require you not to return to 7900 South Orange Blossom Trail here in Orlando. You cannot go back there. There's court cost and the PD lien, and I'll give you a year to pay that. And if you want, you can start a payment plan with the clerk's office, okay? But do not go back there, Mr. Jordan, okay? Thank you, sir. I previously advised you. All right,
Your Honor, Ms. Lampo refused.
okay,
And I will waive, Your Honor.
okay. She's out on bond, I believe, or ROR.
Yes, I believe they had, there was actually court today. I did at 1:30.
Okay.
I did advise the attorney, as well, Your Honor, that she is currently incarcerated, so. There was an offer given by the state to resolve the case, so they'll have to reset that.
Do you want to?
I will waive, sorry.
Okay, that's okay. No, I'm just, was it behavior or
Just refused.
she just, oh, okay. I thought maybe tomorrow if she was in court or something downtown.
There was
Okay.
no offer, Your Honor.
Yeah, she's not, yeah. All right, so, 500, court fines PC, 500, 500, and 500. At this time, no return to the scene of where this occurred, no contact with the victim. And, is there anything requested on behalf of the state on the possession of cocaine? I think there was one charge. I think there was only one
That is correct, Your
charge.
Honor. And formal charges have been filed. Generally, when charges have been filed, the court will generally revoke, Your Honor. But possession of cocaine is not related to, not even remotely related to what it is that Ms. Lampo is charged with today. However, she is out ROR and is accused of committing new crimes.
I'll revoke the ROR, set bond at none, and they can get her, hopefully you'll be able to get the answer on what occurred in court today. You know, if it was a move up or something like that, all right?
Ms. Quisenberry,
Yes,
security bond.
she bonded, okay. Jennifer Sheehan,
She is medical. Quarantine, so.
you want to reset for tomorrow to see?
She's not coming.
Oh,
Online? Oh,
okay, that's okay.
well, I will waive, Your Honor.
So,
There, I would just ask that you, stay the bond, because that's all we can do at this point.
right. 'Cause
She's
I
not gonna be
just-
able to come.
Yeah. All right, at this time I'll stay the bond at, what was it, 250? I think it was 250. 2022 MM 224 AE,
I ask for a no return, Your Honor.
and no return. Okay. Your name, please?
Anthony Tompkins.
Mr. Tompkins, sir, you're here on the charge, sir, of providing false identification to a law enforcement officer and resisting officer without violence. I'll appoint the public defender's office to represent you on the matter.
And the offer from the state is an adjudication of guilt, credit time served. Mr. Tompkins would like, is that right? That's right? Oh, you moved, so I didn't know. Mr. Tompkins would like to accept and enter a plea of no contest, Your Honor.
Is that to both counts or?
Yes, Your Honor.
Okay. And Mr. Thompson, you're not on probation, are you? Okay. And is this the agreement of the state?
Yes, Your Honor.
Okay. At this time, sir, it's my understanding you wish to enter a plea of no contest to providing false identification to a law enforcement officer and resisting officer without violence. providing false identification to the law enforcement officer, can I just inquire?
Your Honor, if you, this looks really bad.
Don't think I think he just wouldn't answer.
Exactly, Your Honor.
Right.
So, Your Honor,
If you all agree,
well, Your Honor, if you ROR him because you find no PC, it's still out there. So
right,
I would
I don't, yeah.
have to drop that charge and then just go forward on the resisting without. I can do that, Your Honor.
Thank you. I mean, I think thank you. I'm sure the defense thanks you too.
Yes, I do.
Okay. So there's gonna be a no bill as to count one?
It's as to count one, Your Honor, providing
And-
false ID to the law enforcement.
Okay. And a plea as charged to the resisting officer without violence. All right, as to the resisting officer without violence, it's my understanding you wish to plead no contest. Is that correct, sir?
Yes, ma'am.
And is this your signature on the plea form? Did you read and understand the rights on the plea form?
Yes, ma'am.
And do you have any other questions regarding the rights you're giving up here by doing so? Any other questions? All right, and you stated you're not on probation for anything, is that correct? All right, sir. And at this time, are you satisfied with the services of your attorney?
Oh, yes.
All right, sir. And you want to maintain your plea or enter your plea, you said of no contest to count two, resisting officer without violence, is that correct? I'll accept your plea, I'll adjudicate you guilty, I'll sentence you to 1 day in the Orange County Jail with 1 day credit for time served. You'll be released under this case today. There's mandatory court cost, and I will give you 1 year to pay that. I think you were in here when I announced that before. When you do that, or else start your payment schedule with the clerk's office, go to them, and they can establish a payment structure, okay? I previously advised you of your right to appeal the sentence. I will take no action on the out on bond case.
Would you mind appointing us? I don't see that he has an attorney. I just don't want it to get lost if they do,
Okay.
the state does decide to file.
They did, I think they filed today.
They did?
They filed
did.
today.
Okay, so could you appoint us, Your Honor?
Sure. It's 2022 CF 5993AO. I will appoint the Public Defender's Office to represent. I think we're on our last pleable. And then, we had a lot of pleables, didn't we? All right, Upshaw, Mr. Upshaw?
Yes, ma'am.
Mr. Upshaw, sir, you're here on a charge of petty theft. This is in case number 2022 MM 6247AO. I'll appoint the Public Defender's Office to represent you, sir. I do find probable cause. And was there an offer, or?
No, Your Honor.
Bond will remain the same at $250, and you're not to return to the scene of where this occurred, sir, okay? All right, sir. You have the Public Defender's Office representing you. It's whatever the bond was. I didn't raise it, 250. Yeah, I didn't raise it. No return to the scene. Yeah, and no return, he can't go back. Okay. Your name?
Nelson Ivan Figueroa.
Okay, Mr. Figueroa, sir, you're here in case number 2022 MO 1045AO, and it is a charge, sir, of disorderly conduct. I will appoint the Public Defender's Office to represent you.
Could I have, 1 moment, Your Honor?
Sure. You want me to sign?
Your Honor, so the offer from the state was an adjudication of guilt, 5 days in the Orange County Jail with credit for time served, 2 days credit time served. And I believe the state made that offer because he was just released on the 23rd. My client would like to see if you would be willing to give him credit time served as opposed to 5 days.
Your Honor, it was because he was just recently released and also because he has over 100 misdemeanor convictions.
Okay, I think the 5 days is very reasonable. Mr. Figueroa, sir, I think the state made a very reasonable offer, sir. Okay, I mean, you don't have to accept it, but I think it's a very
I was trying
reasonable.
to go home today and resolve it. I got a job out there and everything.
I know, but it's gonna be a few more extra days if you take the plea, okay?
What's on right here?
All right.
5 days?
Yes, sir, but you got 2 days credit, so that'll add and, all right, but I need to ask you a few questions about the plea form, okay? Did you is this your signature that you signed on the plea form? And you understand, or my understanding is you want to plead no contest to the charge of disorderly conduct. Is that correct, sir? And are you on any kind of probation? No probation. You satisfied with the services of your attorney? She did the best, she did the best she could, considering, I think she did an outstanding job for you. And at this time, you said you're not on any probation, correct, sir? Okay. Do you still want to enter a plea of no contest to that agreed upon sentence? All right, sir. And you shook your head yes. I'll accept your plea. I'll adjudicate you guilty, sentence you to 5 days in jail with 2 days credit for time served. There are court costs, and I'll give you a year to pay those, okay? All right, sir. Thank you.
3 more days, right?
Yes, sir. Your name, please? Want to tell me your name? Mr. Lawrence, sir. Mr. Lawrence, sir, you're here on a charge of an open container, sir. It's in case number 2022 MO1046AO. And I'll appoint the public defender's office. And how is your client wishing to proceed?
Your Honor, the offer from the state is a withhold of adjudication, credit time served. Mr. Lawrence would like to accept and enter a plea of no contest.
Is this the agreement of the state?
Yes, Your Honor.
All right, Mr. Lawrence, sir, it's my understanding you wish to plead no contest to this charge of possession of the alcoholic beverage. Is that correct, sir?
Yes.
And is that your signature that you signed on the plea form? And do you have any other questions regarding the rights that you're giving up by entering the plea today? Have any other questions? All right, sir. Are you on any kind of probation? No. All right, sir. And are you satisfied with the services that your attorney provided you today?
Yes.
All right, sir. And do you still wish to plead no contest to that alcoholic beverage open container charge?
Yes.
All right, sir. I'll accept your plea. I'll withhold adjudication. I'll sentence you to, you had 1 day in jail with credit for 1 day time served. So you'll be released today, and there is the court cost and the PD lien. And what I'll do is give you 1 year to pay that, and if you can go to the clerk's office to get a payment plan, okay? All right, sir. I previously advised you of your right to appeal the sentence. Thank you. Okay.
Yana Logan?
Yes. Logan Bonded. Okay, thank you. Your name, please?
Richard Scarborough.
Mr. Scarborough, sir, you're here on a charge of an open container, sir, in case number 2022 MO1048AO. And at this time, the public defender's office is appointed, and how is your client wishing to proceed?
Your Honor, the offer from the state is a withhold of adjudication, credit time served, and Mr. Scarborough would like to enter a plea of no contest and accept the state's offer.
All right. Mr. Scarborough, sir, it's my understanding you wish to plead no contest to the charge of the open container. Is that correct, sir?
Yes, ma'am.
Is this your signature that you wrote on the plea form?
Yes, ma'am.
And did you understand the rights you're giving up by pleading here today?
Yes,
Do
ma'am.
you have any other questions regarding those rights that you're giving up, sir?
No, ma'am.
Are you on probation for any other charge?
No, ma'am.
Okay, sir. And are you satisfied with the services of your attorney, sir?
Yes, ma'am.
And do you still wish to continue with your plea of no contest?
Yes, ma'am.
And in each of these cases, I've found probable cause on all the pleas that have been given. And at this time, I will withhold adjudication. I will sentence you to 2 days in jail with credit for 2 days. Yes, 2 days' time served. As I just announced to the other individual, there's court cost in the PD lien. They're gonna add them together, and I'll give you 1 year to pay them, 1 year to pay that. If you can or want, and it might benefit you, go to the clerk's office to start a payment plan, because they can do that on a monthly and then reduce it to an amount that you could afford, okay?
Yes, ma'am.
All right, sir, you'll be released today, and I previously advised you of your right to appeal the sentence. Thank you. All right, I think we have our felony cases, correct?
Yes, ma'am.
Your Honor.
Okay,
Bachman,
yes,
you refuse?
all right,
And I will waive, Your Honor.
okay. This time on Mr. Bachman, and this is case number 2022 CF 9804 AO. The court finds probable cause, bond is set at $1,000. Our PC was already found and bond was already set, rather. And is out on bond under 2022 CF 5662 AO.
And, Your Honor, my only argument would be that you not revoke. He was arrested May 18th of this year. No information has been filed to date on any of the charges. So I would ask that you not revoke, and if you are inclined to revoke, you revoke in double. Additionally, I would just ask that we not be appointed on the out on bond. It looks like he has regional conflict counsel.
But I'll appoint you on the new one, and then
Yes.
you all do your withdrawal based on, okay.
Yes, Your Honor.
Okay.
That is correct, Your Honor. Defendant was arrested May 18th, and formal charges have not been filed yet.
At this time, the court does find, though, he's out on bond, similar charges. I will revoke that bond, and I will set bond at 9. That is the purpose of bond, or one of the purposes, and therefore the court finds it is appropriate to revoke that. But I won't appoint the public defender's office. You have great contact with them. Will you let them know?
Yes, Your Honor.
Perfect. Thank you. All right.
Andrew Borges, surety bond.
Bonded, okay.
Christopher Dietz,
Dietz, uh-huh.
Surety bond.
Oh, okay. Thank you. Mr. Duncan, sir? Is that correct, sir? All right, Mr. Duncan, sir, you're here. This is in case number 2022 CF 10642 AO.
I have ties to you.
Sir, it is not me who qualifies.
I paperclip the plea form on the one. I was like, I probably shouldn't have done it.
No, not if you can't post the bond.
All right, Mr. Duncan, sir, this is a charge of petty theft, excuse me, sir, with 2 prior theft convictions. At this time, sir, I've reviewed the charge and affidavit. I do find probable cause. I will appoint the public defender's office to represent you, sir. At this time, bond will remain the same at $1,000. You are not to return to public, sir. You're not to return to the scene.
Excuse me, ma'am. They're saying I have no ties to you.
Oh, okay. Wait, they say you don't qualify for the public defender?
I don't understand how I don't qualify for the public defender's office.
Well, let's see. We're going to try to figure that out.
This doesn't make no sense to me. Give me a second.
Could you please advise why he doesn't qualify for pretrial services? Pretrial release, excuse me. Can you wait? I'm trying to get an answer. Can you?
Mr. Duncan, please stop. Let everybody evaluate what your question is and give them a moment to do so. People can't talk over each other. I mean,
I understand, ma'am.
the pretrial services, you had asked, did you qualify? And you do not qualify, is my understanding. You've got prior theft conviction, sir. That would remove you from qualifications. But I need to go back to the first question I was asking. They had that somebody wrote, I don't know if it was you, but somebody wrote on the affidavit for the public defender that you make $1,500 every 2 weeks. Is that correct? Okay, can you tell me what you do make?
I make commission.
Okay, and what would be your average commission, even if it's by a month or every 2 weeks or however?
Yeah, they're gonna make $1,500 every 2 months.
Every 2 months, okay. Then you would qualify for the public defender, okay? So if we got that taken care of. And,
Excuse me, Your Honor.
mhm.
They're saying that I'm not qualified because they couldn't prove my ties to the community. My ex literally owns a business in downtown Orlando, and I know for a fact she would answer. And it's not making no sense. They didn't give me a chance to get no phone numbers because they couldn't look up no phone numbers. And I don't understand. My family literally has a business right downtown Orlando. I've been going to court over there. I go to the church right there off of Church Street with the big pillar. I go to that one every single month. I'm a Jehovah's Witness. I go to church every single.
That's okay, Mr. Duncan, but you're not going to qualify. You were released from the Department of Corrections also, I believe, less than a year ago. You don't qualify. Now, you've got an attorney, sir, and your attorney can always file a motion to set bond at a.
My job and everything I have over.
Okay.
So I can't get anyone to come up here and sign for the thing 'cause my mom just died.
Okay.
I need to get out.
Well-
They're not giving me methadone here. They're not giving me none of my medication here at all whatsoever. I've been sick. I'm detoxing. I can't breathe.
Okay, your attorney now can start looking into those things because we have them appointed. Thank you. Hang on one second, hang on. Okay, now what? I'm sorry, I can't do the, sorry. And, yeah, and do not return, yes. Sorry, I know, when that, just give me a few seconds and I can usually answer you within seconds. That's okay. All right, and who do we have next?
Well, we have Harp refused, Your Honor.
Okay. Mr. Harp is here on grand theft of the third degree of a motor vehicle. Public Defender's Office is appointed.
I will waive, Your Honor.
All right, bond remains the same at $1,000. And
I've got Mr. Lake.
okay, Mr. Lake bonded. Okay,
We have Mr. Mayor.
and this is Mr. Majors. Mr. Majors, sir, if you want to come on up, sir. All right, Mr. Majors, sir, you're here in case number 2022 CF 7357AO. It was a failure to appear, sir, and the court that issued that has set bond on each of the counts, $2,500 in count one and $1,000 under count two. And a public defender's office is appointed to represent you. Okay, sir? You're welcome, sir. Thank you.
We have Ms. Reeves. She bonded.
Bonded, okay.
And we have Renault Skoll is mental health. Juan.
And I will waive, Your Honor.
All right, he's got a number of out on bonds, I believe.
It's a DUI and a no valid, Your Honor.
Correct.
Pretrial is set for the 19th.
All right, let's go ahead and, Public Defender's Office is appointed, so let's go ahead and go through those case numbers. And at this time, as to the new charges, there are as follows: 2022 CF 10655AO, possession of cocaine. I do find probable cause. Bond remains the same at $2,000, not to possess or consume any drug or controlled substance without a valid prescription. As to case number 2022 CT 5188AO, 5189, 5190. The charges are, and 5191 AO. The charges are refusal to submit, reckless driving, DUI, and driving with license suspended or revoked. At this time, under count one will remain the same at 500. Count two will be 500. I will raise the DUI to $2,000, and driving with a suspended or revoked license will remain at 500. And at this time, I am going to revoke 2022 CT 4317AO, which is a DUI out on bond. That bond will be set at 0. And as to 2021 CT 4318AO, I will revoke that bond, set that at $1,000. Okay? So one got raised, revoked the DUI.
4317 was revoked, Your Honor.
Yes.
Okay, just want to make.
Yes. All right, I have one more person, is that? Yes? Okay, and is that it?
Yes, Your Honor.
All right, everybody, thank you. We will stand in adjournment this time, and, okay.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Okay, and we're going to try to lower the volume a little bit. You sound great, but it's just a little louder up from this end, and which is better than not hearing. And at this time, we have 2022 MM 400AA. Sir, would you state your name, please, for the record?
Your Honor, the interpreter can have a moment to confirm that the defendant can hear through the headsets, please.
Oh, okay.
I apologize, Your Honor. What case number do you have?
I'm going to let Madam Clerk or the clerk.
Sí, lo
I've got to get logged
Sí, lo escucho.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
All right, thank you.
This is Campos.
Campo?
Edwin?
Sir, your name, well, I didn't get that far because the interpreter had.
Edwin Campos.
Okay. So
Edwin Campos.
Are we not talking about the same person?
We have different cases. I have 2022 MM6242A.
They marked through that on ours
Mhm.
and have put 2022 MM 400AA. Suspect it's because it's out of Apopka. They gave the AA designation.
Okay,
So
thank you.
400.
But I'm going to let the clerks look in the system. I'm going to try to get logged on.
Okay.
So it's 400 AA? Okay.
Okay. So is everybody on the same
Mhm.
case now?
Thank you.
Yes.
Okay. I just want to get logged on. All right. Your name, please, again?
Edwin Campos.
Edwin Campos.
Mr. Campos, sir, you're here on a charge, sir, of battery, and this was charged under domestic violence, sir. You do qualify for the public defender. I will appoint the public defender's office to represent you. And at this time, the court has reviewed the charge and affidavit. I do find probable cause. And at this time, is there anything further from the state besides I'm going to have comply with DCF? That was the request, and also no contact and to maintain a separate residence and not possess weapons or firearms.
Nothing from the state, Your Honor.
And, Your Honor, I'm not quite sure, but I would ask for a one-time return with law enforcement to gather any belongings. Because I know in the affidavit it said he stays there sometimes, and then here it says he has nowhere else to go. So I would just ask for a one-time return with law enforcement, as well as he qualifies for pretrial release. So I would ask for pretrial release in this case.
Any objection?
No objection, Your Honor.
Yes, qualify. So, sir, I'll order the pretrial release condition. Is that correct? Correction?
Yes, ma'am.
Thank you. He does qualify for pretrial release, so I will order pretrial release. I'll allow you to return one time with law enforcement to pick up your personal belongings. But when you do that, don't go there and then call law enforcement. You reach out to them first. They arrange the time and the place to meet you. And then from there, they then tell you where and to meet them to go get those items. And you've got personal belongings there. Okay?
Okay.
All right.
Okay.
Thank you. And I've appointed the attorney's office representative. All right.
Your Honor, Ms. Garcia and Tensen Garcia, she's mental health.
Okay.
I will waive, Your Honor.
Okay.
Could we set a bond? I don't see any history. Was she able to be screened for pretrial? release? Okay. Can we do bond or pretrial release if she qualifies, Your Honor? She doesn't have any criminal history and she's currently not working, so I want to at least have her screened.
Okay, I'm just trying to get my. All right. Any objection on behalf of the state if she does qualify?
No objection, Your Honor.
I'll set bond the amount of $500 or pretrial release if qualifies. No contact with the victim, maintain a separate residence, do not return to the scene, and not possess any weapons or firearms. And you'll make sure that information is relayed. Is that correct? Just-
Yes, Your Honor.
Thank you. And also, do you think you need a one-time return just in case?
Yes, Your Honor.
All right, may return one time with law enforcement to pick up personal belongings. And I'll set bond at the $500 or pretrial release if qualifies. With those conditions, no matter though, whether it's bond or the other. Okay?
Thank you.
You're welcome. Let me get, all right. And, your name, please? Oh, I'm sorry.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Okay. And sir, you're Mr. Zappa? Zapta?
Your Honor, the interpreter is attempting to confirm with the defendant.
Okay, just.
Rafael Antonio Zapata.
All right. Sir, you're here in case number 2019 CF 10893. And this is a violation of probation. The court that issued this set the bond at none, sir. So bond will remain at none. And I will appoint the public defender's office to represent you on the case on the matter.
¿Puedo hablar algo?
Can I speak about something?
Your attorney probably will tell you not to speak, sir. Your attorney will tell you, she's going to speak to you right now through the interpreter.
I would advise you not speak about any of the facts of the case or the violation of probation. I did provide a green paper that's circled with the phone number where you can call and speak one-on-one with your attorney about any issues or facts you may have in dispute.
Quiero decirte algo, era personal. Tengo mi padre que está en coma, se está muriendo. Y yo vine a pedir un permiso para ir a ver a mi padre.
Well, I wanted to say something of a personal nature. My dad's in a coma and he's about to pass away, and I wanted to ask for permission.
What will need to happen, sir, is that you have an attorney's office now, so they can file any motion on your behalf to have that heard and in the violation of probation division to address that. So there's certain things that they can be able to do, and I'm sure they're documenting now to speak with you and to have that information. Okay? But you're going to have to go in front of that judge to get that preamble for those reasons.
¿Cómo yo me contacto con él?
And how do I get in touch with them?
Right, she's writing it down. They put that on there. Okay?
Gracias.
Thank you.
You're welcome, sir.
Your Honor, next we have Mr. DeBose, Ricky.
And I'm sorry, what was he
We're not doing the Philippines? Oh.
Okay.
Your Honor, if the court could inquire if you require the services of the interpreter for any other cases?
Not that I'm aware of, but I mean, I don't believe there's any. I think they moved everything up and we're taken care of. Thank you.
Thank you, Your Honor. Have a good morning.
You do the same. Thank you. All right, y'all, I need to send an email out regarding the computer here. It's now saying I'm logged out, so let's figure this out. Let me send it to who was trying to get, who was Tom. I'm now logged out. Now see if I'm logged out. know what it was. This is unlocked the system. All right. Okay. Your name, sir. And Mr. DeBose.
He was reset, Your Honor, for a plea
Okay.
to the open container. The offer from the state was an adjudication of guilt, credit time served, and Mr. Du Bois would like to accept and enter a plea of no contest.
All right, Mr. DuBose, is this the
I
agreement
don't
of
know.
the state?
Yes, Your Honor.
All right, Mr. DuBose, sir, it's my understanding you wish to plead no contest to the charge of alcoholic beverages, with the open container, is that correct?
Yes, that's correct.
And is this your signature, sir, that's on the plea form?
Yes, it is.
All right, did you understand the rights you're giving up by pleading here today?
Yes, I do.
And are you on probation for any other charge? And are you satisfied with the services of your attorney?
Yes, sir. Yes, ma'am.
And do you have any other questions for the attorney?
No, ma'am.
All right, sir. And at this time, sir, do you still wish to continue with your plea of no contest to the charge then?
Yes, I do.
All right, sir. I'll adjudicate you guilty, sentence you to the, I believe you've got 3 days in now. So 3 days in jail with credit for 3 days' time served. You'll be released under this case today. So there's the mandatory court cost and there's a $50 public defender lien. You're gonna add them together, they put them both together. And I'm gonna give you 1 year to pay them. Now, you should go to the clerk's office and try to set up a payment structure well before that time, because they can then work with you on the amount you can afford and the frequency. And if you don't do it, it just goes and causes a circular problem for you, okay?
Okay, thank you.
All right, sir, you're welcome. You have the right to appeal the sentence of the court, must do so in writing within 30 days. If you can't afford an attorney, one will be appointed to represent you, okay? I got somebody out of order or something. Your name, please?
Fredo Torres, ma'am.
Okay, I gotta, what?
She's regular English, so we just keep her in rotation.
Okay, that's fine. They just pulled it, and I keep thinking I've not handed the correct paper, so everybody remind me it's sitting here. I just don't know where it goes in there. All right, Mr. Torres, is that correct, sir?
Yes, ma'am.
All right, sir. Mr. Torres, sir, you're here on a charge of aggravated assault with a firearm, domestic violence, and battery, dating violence. This was the one I believe was needing to be provided yesterday, everyone? Is that correct?
Yes, Your Honor.
And I believe that has now been provided.
Yes, Your Honor.
All right. And at this time, I have reviewed it. There is probable cause on the matter. He is entitled to a bond on that. We did revoke the bond yesterday, didn't we, on the outstanding?
No, Your Honor.
No, we
Okay.
waited to address it today, Your Honor.
All right. Mr. Torres, sir, I've appointed the Public Defender's Office to represent you, sir. Let me So as to the new charge of 2022 CF 10619 AO, I'm going to order at this time the following conditions. I don't believe we have anybody here. I'm going to require you not to have any contact with the victim in this matter. Do you understand that, sir?
Yes, ma'am.
You understand that's directly, indirectly, through a friend. It is absolutely no contact.
Yes, ma'am.
Okay. Okay, and you've signed that form that states that. I also am going to require you, sir, not to maintain a separate residence. You're not to return to the scene of where this occurred. I'm also going to require you not to possess any weapons or firearms. Do you understand that?
Absolutely, ma'am.
All right, sir. At this time, sir, as to, does the state have any further information as to count one? I mean, you agree he's entitled to a bond?
Yes, Your Honor, he is entitled to a bond.
At this time, sir, I'm going to set bond on count one at $7,500. Count two, I will set at $1,000, with those being the conditions of those, of that case. As to the second case, which was 2022 CF 10605, this was possession of a firearm by a convicted felon. That bond is at $5,000 and will remain. You were out on bond on a charge. I don't have that paperwork attached, but I know.
Your Honor, my only argument as to, the state only filed on the possession of a firearm. However, my only argument as to the out on bond, that if you're inclined to revoke, I would ask that you revoke and double. Based on the affidavit that was provided, if you look, it was noted that in her original story, the victim never mentions a gun. And then when they asked her again to retell the story, then she threw in the information about the gun. No bruises were found on the victim, nothing to that effect. It is the inconsistent story of the victim that is of concern, Your Honor. And because of that, I would just ask that you consider revoking and doubling as opposed to holding him at no bond, being that no weapon was recovered, no video was ever recovered of him having a firearm.
We're gonna print that out. The out on bond. At this time, the court's determination is probable cause, not beyond a reasonable doubt that would be required in front of a jury. And the court notes that there is probable cause in this. Also, the court notes that he was, that's what he's out on bond on? He's out on bond for possession of a firearm by a convicted felon and possession of ammunition by a convicted felon. So at this time, the court does find that the order revoking the bond is proper under 2022 CF 6093AO. Obviously, it won't preclude any motions being filed in that division and in that case, but at this time, the court does find, based upon probable cause, that the court does have a basis to revoke that bond, also noting the similar charges. Okay?
Yes, Your Honor, but they only filed on the firearm. I don't know if that matters when you revoke. They never fired on the ammunition.
They didn't, okay. They just have the one case number listed. I'll revoke that case.
Thank you. So you're gonna have to speak to the attorney. She's still revoked.
Just showing. It's no bond. The out on bond is no bond, right?
You're gonna have to do it downtown. I just made the argument. You gotta file.
Was there, I don't think there was there one? Okay, perfect. Thank you.
You can't bond out, no.
Resets, because half the stuff doesn't come in with it. All right, okay. Come on up. Your name, please?
George Warner.
All right. Mr. Joyner, sir, you're here on a charge as follows, and let me get the paperwork. Okay, this out of the way. All right. She's not pulled. Okay, you're here on the following charge. It is a charge of attempted first-degree murder with a firearm, aggravated battery with a deadly weapon, and aggravated assault with a firearm. A warrant was already filed, finding probable cause as to those charges. Are there any witnesses here? There's not. At this time, I will appoint the Public Defender's Office to represent you on the matter. And at this time, is there anything further from the state?
Your Honor, attempted first-degree murder, which is the first offense, is punishable by life, or actually it's a life offense. I would therefore ask defendant be held no bond.
It is a life offense, so at this time, sir, the bond will remain the same at none under count one. I will set bond in the amount of $3,000 under count two and $2,000 under count three. You're not to possess any weapons or firearms, sir, you must maintain a separate residence. I'm also going to require you, sir, not to have any contact with the victim that's directly or indirectly. So even through a family member, no phone calls, you cannot have any contact with the victim. I'm also going to require you, sir, not to return to the scene of where this occurred. Your attorney will file, they will explain to you, I'm sure, if you're signing this, the additional information that they don't want you to say anything to be on the record, okay?
Thank you.
She's going to speak to you.
I thought they said they dropped them charges.
Well, they must have picked it back. Warrant.
Oh, the state?
Mm-hmm.
Thank you.
Call the attorney right there. You can go ahead and do the motion. They already know about it.
All right, and you've signed that no contact order. You signed that, correct? Okay, thank you. Your name, please?
Aquavius Lord.
Mr. Lord, is that correct?
Lord.
Mr. Lord, sir, you're here in case number 2022 CF 1066AO, and this is a charge of battery of a dwelling with an assault, a burglary rather, of a dwelling with an assault or battery therein, battery and a second count, as a second count, and stalking as a third count. At this time, I don't see any witnesses here. I don't
Your
see
Honor, the only argument I had is the PC was to the stalking. Based on the arrest affidavit, it only makes a statement that he saw her driving a Mercedes Benz and advised he had been watching. Nothing in here, even based on the victim's statement, she states that she has not seen him or communicated with him since December of 2021. Other than those two statements, there's nothing here to show that he is repeatedly following, harassing, or doing anything that will rise to the level of stalking in this case, Your Honor.
Okay. I think it's his statement alone. I don't.
Which is, I think, I'm just not sure that's enough, Your Honor.
This statement?
It just states, I see.
Oh, Your Honor, to be completely honest, the first offense is punishable by life. So I'm going to ask defendant be held no bond. I think it's somewhat iffy.
I can ROR him on count
Yeah.
3.
Yeah. Okay.
I agree. I don't think there's PC from his statement alone, you know, that regarding that. And as you pointed out, count 1 would be at no bond.
Yes, Your Honor.
So you're not requesting additional 24 hours for
No.
anything on the stalking. You agree?
No.
At this time, I agree. I don't find PC. I had written that already also. And so, well, I mean, to hear arguments, not that I'd made my decision, but I knew that would probably be the argument. And at this time, Mr. Lord, sir, do you understand, sir, you're not having any contact with the victim, sir? Do you understand that?
Yes, I was just trying to see my kids. That was the only thing.
Okay, you're talking about the case and your attorney's gonna tell you not to do that. She doesn't want you to admit anything, you know what, just doesn't, you don't want to do that, okay? All right, so do you understand the no contact order? And you signed that in open court, is that correct?
Yes.
Okay, sir. I'm also going to require you to maintain a separate residence. Do not return to the scene of where this occurred, and also not possess any weapons or firearms. Do you understand that, sir? I'm sorry.
I said yes.
Okay, and that's okay. I just need to make sure there's a little bit of air conditioning noises behind me. I just need to make sure I hear you and you hear me. And at this time, as to count 1, the bond will remain at none. As to count 2, I'll set bond in the amount of $2,000, and as to count 3, I don't find PC, and at this time, the state's not requesting additional time, and I'll ROR. Okay? Thank you. Under count 3. All right. Sir, you want to tell me your name, please?
Dennis Mills, ma'am.
Mr. Mills? Okay. Mr. Mills, sir, at this time, I apologize, everyone. I'm trying to get logged in on the system here, and I'm just having some difficulties, and they're trying to get some guidance on their end. And okay, got it. Let them know I'm able to get on it now. Okay. Mr. Mills, sir, you're here on a charge of aggravated assault with a firearm, and this is in case number 2022 CF 10651AO. And at this time, sir, I do find probable cause. And at this time, I don't see any witnesses here on coming up out of the area. At this time, is there anything further from the state besides the specific conditions of no
Your Honor.
release? No contact. Mr. Mills, sir, I need to make sure you understand this, sir. I'm appointing the public defender's office to represent you. I'm going to require you to have no contact with the victim. Do you understand that, sir?
Yes, ma'am.
All right, sir. And you understand that's through friends, family members, texting, calling, absolutely 100% no contact.
Yes,
I'm going to
ma'am.
also require you to maintain a separate residence. You're not to return to the scene of where this occurred. And I'll also require you, sir, not to possess any weapons or firearms. Do you understand those conditions?
Yes, ma'am.
All right, sir. At this time, I'll set bond in the amount of $3,500 with those as the conditions of your release. You need to understand, Mills, if you violate any of the court's order, the court will revoke the bond and the bond will be at 0. So make sure you're in full compliance. Stay in contact with your attorney, sir. And I've set the bond with those specific conditions, okay?
Yes, ma'am.
All right. Your name, please?
Giselle Betancourt.
Ms. Bellacourt, ma'am, you are here in case number 2022 MM 6237AO. And at this time, you're here on a charge of battery. I don't see any witnesses. Are there any?
One is approaching now, Your Honor.
Our witnesses. Sir, if you'd raise your right hand to get sworn in, do you swear to tell the truth, nothing but the truth, so help you God?
I swear.
And I'm sorry, I can't.
Yes.
Okay, thank you. You can put your hand down now. Thank you. All right, before I begin, Ms. Betancourt, you do not qualify for the Public Defender's Office. It shows, based upon your take-home income that you wrote out, if this is correct.
It's a monthly income.
It's monthly income?
I tried to change it, but they told me no.
You tried to change it in, but what?
They said no.
Okay, well,
It's monthly though.
okay. I still don't think you're going to qualify. No. You still don't qualify, but we'll address the conditions of the release, et cetera. So
Okay.
just, I just don't want you to say anything to be used against you at a later time is one thing. And so I'm sure the public defender would step in as a friend of the court to make sure that that was done. All right, the state's probably going to ask you, can I have your name again for the record?
Alberto Rivera Soto.
All right, I think the state probably wants to maybe, or they may want to ask some questions.
Good morning, sir. How do you know the defendant?
We've been together for over 5 years on a relationship. We were engaged. That ended.
I apologize, I can barely hear you, but my follow-up question.
Can I take my mask off?
Yes, you can.
Thank you.
Do you live together now?
Yes, we've been living together for like 3 years.
Okay. Has something like this happened before?
No physical aggression.
All right. While this case is pending, would you like to have contact with the defendant?
We have a daughter together, and I would not want to have contact with her myself, but yeah.
If I may, and please correct me if I'm wrong, I believe what you said is you don't want to have contact with the defendant, but you want the defendant to be able to have contact with your child in common.
Yes.
Okay. And I apologize because I believe you answered this. You do live together now, correct?
We do.
Okay.
Yeah. Until this happened, yeah.
I have no further questions, Your Honor. Thank you.
Sir, just so I'm clear, is that the contact, as the state pointed out, you two don't want the contact together. You don't want contact with her, but you don't want the court to prohibit if DCF is involved or there is the Department of Children and Family Services is involved, that she comply with that and be able to see the child, correct?
Yeah. Yes.
Okay. All right, thank you. All right. Does she qualify for
She does, Your Honor.
pretrial release? Got to hear those words, though. Any objection on behalf of the state?
No, Your Honor.
All right. What I'm going to do is, at this time, Ms. Benacourt, you do qualify for pretrial release, but these are going to be the conditions of that. You're not to have any contact except through DCF. You're not to have any contact with him. Do you understand that, with the victim?
Yes.
Do you understand?
Yes.
Okay, I just got to make sure we all are understanding that. I'm also going to require you to maintain a separate residence from him.
Okay.
Are you residing at the house?
Yes, and if she needs her stuff, like her vehicle's keys and stuff like that.
Come back to the house, right?
Yeah.
Okay. I'm
With an
gonna-
intermediary, if that's possible. With somebody.
Yeah, I'm going to order that. I'm going to require you to maintain a separate residence, not to return to the scene of where this occurred, but you may return one time with law enforcement to pick up your personal belongings. But when you do that, don't go there and call. Don't get in, don't sit out there and call law enforcement. You call them in advance. They arrange when and where to meet you, and then they will decide at that time that particular parameters, and then you can pick up your personal belongings, okay? And I'm also going to require you not to possess any weapons or firearms. Is DCF involved? Have they called you?
They have not.
They have not, okay. I don't know if they were, yeah, they were notified.
They were notified and they did not take a case, from what I was told by the police officer.
It does say that within the affidavit, Your Honor. I called and spoke to DCF Operator Angela 574 regarding this case. DCF advised they will not be accepting this call.
So how are, if DCF is not going to get involved with the case, how are you intending to have her see the child? Is there a third party, a family member?
Yes, I could have my father, if that's an option, be.
I'm not, the case isn't with the child, so it's just you
Right.
that if she can't have contact with you, so if you know, if there's an exchange of the child, that's gonna have to be separate, okay?
Right.
So I'm not gonna order, I'm not making any order. I'm gonna put comply with DCF if DCF has a case, okay? If they don't have a case, you know, ma'am, Ms. Benacourt, you know you can't have contact with
Right.
him.
Is there a chance of no hostile?
I can't.
No
hear you.
hostile? Can that be an option? The no hostile instead of no contact?
I don't think he wants any contact with you.
But for the child,
I know you'll have to talk to an attorney.
Okay.
That'll have to file any appropriate motions, but at this time, I'm gonna order the no contact and
I
comply
can't
with
see
DCF.
her.
Okay?
So what do I do next?
You're gonna get out on pretrial release.
Right.
You're gonna comply with the court's order.
Right.
And you don't qualify for an attorney, so you'll have to call around to see if you can hire an attorney. The next court date, the court can reconsider whether you do or don't qualify, but at this point, based upon your salary, you don't qualify.
Okay.
For a public defender, for a
Right.
free, you know, for not free, I don't mean to say that, but for a public defender, okay? All right, thank you.
Thank you.
Thank you. May I ask a question just to?
Go ahead, yeah.
Real quick, would it be possible for my father to bring my daughter to her to let you?
I'm not putting any order on the child,
Okay,
except she can't have contact with you. So when you have the child.
Thank you.
Can't have
Understood.
contact, but you'll have to comply with DCF if DCF is involved, okay?
Understood.
That would work just fine. Hang on one second, let me just, okay, just want to make sure. No, I'm not going to do any order like that, no, because I'm not, don't have jurisdiction over the child. I'm not going to order just your dad only being the one, but you got to comply with these, she has to comply with.
Understood.
Okay, all right, thank you. All right. I don't know if we have a witness here on the Cecil Betty matter.
Yes, ma'am.
Okay, just while that door was open, I thought we'd take advantage of that. All right. Ma'am, if you'd raise your right hand to get sworn in, please. You swear to tell the truth, nothing but the truth, so help you God.
Yes. Yes.
Okay, and, sir, you want to raise your right hand to get sworn in? I'm not sure why. Come on up to the microphone. You swear to tell the truth, nothing but the truth, so help you God.
Yes.
Okay, thank you. And your name?
Cecil Betty.
All right, you're here on a charge of battery. Qualify for the public defender. I will appoint them to represent you on the matter. So you're going to have an attorney on the matter. And I'll let the state go ahead and inquire.
Good morning.
Good morning.
Ma'am, can I have your name, please?
Eileen Thompson Betty.
And how do you know the defendant?
That's my husband.
Do you live together?
Yes.
Okay, I don't mean to interrupt. I'm sorry
No,
when
no,
I said
it's fine.
okay. She could be a co-defendant. They have her listed, Eileen Thompson Betty.
Understood, Your Honor. At this time, she has not been charged.
I know, I just don't want her to say anything to be used
Oh,
against
no,
her.
no,
at a later time.
understood. My questions generally don't go to.
Thank you. I
anything
just
like
wanted
that.
to, I was just gonna stop her if she did, or have the public defender, they're now representing this individual. Thank you.
Understood, Your Honor. Thank you.
You're welcome.
So you are married and you do live together, ma'am?
Yes.
While this case is pending, would you like to have contact?
Yes.
Okay. Has something like this happened before?
No.
I have no further questions, Your Honor. Sir, can I have your name, please?
Cecil Stewart. Cecil Stewart.
And sir, how are you related to this case, this incident?
Very good friend. Well, I wasn't there. I just come with her.
Okay, all right. Thank you very much. I have no further questions, Your Honor.
Okay, I don't know if the defense had any questions.
No questions, Your Honor.
All right, so it's my understanding, Ms. Thompson Betty, that you wish to have contact with him. Is that
Yes.
correct?
Yes.
All right, thank you very much.
You're welcome.
All right. Any objection on behalf of the state?
No objection, Your Honor.
Your Honor, he qualifies for pretrial release. I would ask for pretrial release.
Any objection on behalf of the state? And I believe.
No
he does.
objection.
Does he qualify for pretrial release?
He does, Your Honor.
All right, I'll go ahead and order pretrial release. You're not to have any violent or hostile contact with the victim in this matter, and you must not possess any weapons or firearms. Do you understand that?
Yes, ma'am.
Okay, and you're gonna, I've ordered pretrial release, you do qualify, so you don't have to post the bond, but the conditions are the same that I just ordered. No violent or hostile contact and no weapons or firearms, okay?
I don't have weapons.
But it's now a court order, so you can't now, all right? Thank you. Thank you both. All right, the next case, your name, please?
Nicole Cavalier.
Ms. Cavalier, you're here in case number 2022 MM6243AO. I don't see any witnesses. And so at this time, you do qualify for the public defender. I will appoint them to represent you at this time. And
Victim. I would ask for pretrial release, Your Honor. She
any
does
objection
qualify.
on behalf of the state?
No objection, Your Honor.
I'll order pretrial release, but with the following conditions, and I need to make sure you just understand them. You're not to have any contact with the victim whatsoever. Do you understand that? I'm also going to require you to maintain a separate residence. You're not to return to the scene of where this occurred, and I will also require you not to possess any weapons or firearms, okay? You've got the public defender's office appointed. Make sure you keep all your appointments with the public defender's office and comply with the court's order under pretrial release. All right. Thank you. Your name, please? Ms. Crutcher, you're here in case number 2022 MM6252AO, and the charge is battery domestic violence. I reviewed the charge and affidavit. I do find probable cause. I don't see any witnesses here, and at this time, I will appoint the public defender's office to represent you.
And she does qualify for pretrial release. I would ask for pretrial release, Your Honor.
Okay. Any objection on behalf of the state?
No objection, Your Honor.
I will allow the pretrial release conditions. Ma'am, I'm going to go ahead and grant you your release to be through pretrial release. I am going to require, though, you not to have any contact with the victim. Do you understand that's directly or indirectly? It's no contact. Do you understand? I can't hear you.
Yes.
Thank you. I'm also going to require you to maintain a separate residence. You're not to return to the scene of where this occurred, and you're not to possess any weapons or firearms, okay?
And did you have a one-time return with law enforcement?
Uh-huh. I'll allow you to return one time with law enforcement to pick up your personal belongings, but when you do that, you contact them first. They arrange when and where to meet you, and then you'll go get the items, your personal belongings, okay? Don't go there and call them in advance. They arrange where and when, okay? All right, thank you.
Your Honor, DCF was also contacted regarding this incident.
Oh, I need her back. I need her back. I'm sorry.
Wait.
I'm sorry. Ms. Crutcher, I'm also going to require you and order you to comply with DCF. They're involved. A call was made to them. So any requirements under DCF you have to comply with, okay? All right, thank you. And I'll note for the record, she's shook her head yes. Your name, please?
My name is Jacqueline Keel.
Ms. Keel, you're here in case number 2022 MM6244AO. This is a charge of battery, domestic violence. You do qualify for the public defender. I will appoint them to represent you on the matter. And at this time,
She qualifies for pretrial release. I would ask for pretrial release, Your Honor.
any objection on behalf of the state?
No objection, Your Honor.
She does qualify.
Does, Your Honor.
All right.
Ma'am, I don't know if you want me to talk or not. I keep getting yelled at every time I
Your
talk.
attorney won't want you to talk. I mean, I don't think
The
she.
only thing.
For today.
I'm okay with that because I'm innocent. Okay. And I understand that. I'm okay with the whole world knowing.
Ms. Keel, Ms. Keel, Ms. Keel.
Return.
I'm sorry, what?
A one-time return to law
Yes,
enforcement.
I will. I'm gonna order that. I just need to make sure she's, hearing what I'm gonna order. You're to have no contact with the victim. Do you understand that?
That's not possible. We live in the same home.
You will not be living in the same
I have nowhere else to go.
Ms. Keel, you will not be living in the same home.
I have
am-
nowhere else to go. I take care of his paralyzed animal that he is not able to take care of.
Why does anyone think she's gonna comply with pretrial
You
release?
don't have to put her on pretrial release.
I don't think she is. So if you would
I'm
like
not
to.
trying to be quiet, ma'am. I have to take care of a dog that whose both back legs are paralyzed. The only way she is able to walk is by me holding a harness so that I can walk her outside to go to the bathroom. He is unable to do that because he is over 60 years old and he just broke his knee. That dog would have died months ago had it not been for me.
I'm ordering you to have no contact with the victim. I am ordering you not to return to where this occurred. I
That's
am
my
court
home.
ordering you to maintain a separate residence.
I don't have a separate residence. That's my home. That's what's on my ID. That's what's on all my mailing information. I just had all the moving truck stuff moved there.
Your attorney can apply for a hearing to have the court consider a modification. But Ms. Keel, at this time, I am court ordering it.
Ma'am, do
If
you
you violate,
understand that he was holding me against the wall and all I did was push him off of me? There was no violence.
Ms. Keel, I'm going to, this is a court order, and you're not to possess any weapons or firearms.
I believe that's a
No, there are
victim.
no weapons or firearms.
What, they
Is
just,
that the
where was the victim?
He was sitting.
That's my uncle right there.
Would Ms. Keel, please stop right now. I do not want to reset this case, but I've got to be able to listen to all the parties
I was
involved.
just letting you know who he was.
You may want to step beside your client because,
I'd like to hear what he has to say.
she's going to speak to you for a few moments. Okay. We'll recall the case in a moment, everybody. Excuse me. Was he out there the whole time and nobody knew?
I didn't have him as a victim earlier. I don't know if he came in late or.
I did.
Okay, you got late. You were
Yeah, I
late.
was.
Okay, that's
Didn't
okay.
get here
We
till
just,
9:30.
we usually try to have you there before.
I couldn't find the place. I went to the corrections place first.
Are we going to have her come back in?
I don't know if she'll be able to behave herself, Your Honor.
Okay. What we can do is, we can hear from the victim. We will reset her for tomorrow.
So the officer is speaking with her right now. We're gonna see if she's gonna cooperate. If not,
Okay. I mean, the court order needs to be understood, and we will reset her for behavioral tomorrow if we need to do that.
yes, Your Honor.
Your Honor, I think part of the issue was the no return. However, as the victim is here, your
I
order
know,
may
but
change.
It may change, but the difference is she shouldn't control the change.
Understood, Your Honor.
Courtroom.
Yeah, as long as she's ready.
I'm sorry, I'm cold. Ma'am, I'm sorry if I disrespected you in any way. I did not mean to. I just thought we were having a conversation back and forth. You are the honorable judge, and I respect that completely. Please do not punish me because I don't understand how this works.
Ms. Keel, I have patiently trying to explain to you, and what we're going to do is have a court proceeding, as a court proceeding should be conducted. And part of that is I have to make a decision. And at the time when I was making the decision, we did not know there was a witness here. And based upon that, the court's decision was based on the information provided, and no witness was here. My understanding is now we have a witness here. We will
Yes.
start this at square one, all right?
Okay, yes.
And so you are welcome. And once again, you're hearing case number 2022 MM 6244AO. The charge is battery, domestic violence. I've appointed the public defender's office to represent you. You have an attorney. And sir, if you would raise your right hand to get sworn in, he's going to swear you in.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record.
Kenneth Lissette.
All right. Mr. Lissette, sir, the attorneys may want to ask you some questions, okay?
Okay.
Good morning, sir.
Good morning.
How do you know the defendant?
She's my best friend's daughter. I've known her all her life.
Okay. Do you live together?
Yes.
While this
Not-
case,
And she
While
just
this-
lives with me.
while this case is pending, would you like to have contact with her?
It's almost necessary.
All right. Has something like this happened before?
We have arguments. She gets in a little mood.
I just can't hear you. I'm sorry. I just didn't hear you.
We
So you
do
can
get
pull down
into
your-
arguments.
Okay. That was in response to whether or not this has happened before, Your Honor.
I just want to say,
Were drugs or alcohol involved in this incident?
I do drink.
What about the defendant?
No.
I have nothing further, Your Honor.
When this went down, I was not drunk.
Okay. Does the defense wish to inquire?
No, Your Honor.
Sir, when you stated that, do you wish to have contact with her?
It's just necessary.
Okay,
She doesn't have anywhere to go.
okay.
And I can take care of the dog, but she helps out. She does most of it right now.
I understand. But when you say it's necessary, do you feel like you are safe?
Yes,
Okay.
for the most part, I guess.
Well, you keep adding these additional
sorry.
matters,
Yes, I feel-
which is fine, but I just need to inquire, what do you mean most of the time?
It's just when she goes off on these tangents, it gets a little scary.
Okay,
But I don't really fear for my life.
okay. Let's state.
Oh, I have nothing further, Your Honor.
All right, and Vince does not wish to ask any, I mean, I just want to make sure any questions.
No, Your Honor.
All right. And your position on the contact?
Your Honor, all that I can do is note that every time the victim was asked about contact, he put a qualifier on his response. So it was asked if he wanted to have contact. He said it was almost necessary. You asked for clarification. I asked if something like this had happened before. He said they got into arguments. You asked a follow-up question. There's always been a qualifier, Your Honor, so I am concerned.
Okay. Is it your house?
Yes,
Okay. Is it your dog?
yes.
All right. Does she have any?
Can I ask one question?
Sure, yeah.
Do you know if she suffers from any mental health illnesses?
I don't have any diagnoses of anything like that.
Just a minute.
I can answer the question.
What is the question?
If I have any kind of mental health issues, I was diagnosed with severe anxiety when I was 16 years old.
Are you on any medication? Do you take?
Yes,
any-
I take 2 milligrams of alprazolam twice a day.
And that's prescribed?
Yes.
Okay. And I need to ask you one more question, sir. Are you in fear of her?
No.
Why are you hesitant? I mean, is it because you're just,
I'm not in fear of her.
okay, and it's okay. When I said you just are hesitating, so I think that's the,
No, it's just been so long that we go through this. I'm just tired of it. But I'm not really afraid of her killing me or anything.
I'm going to require no contact at this time.
Me,
All right. I'm going to
can't-
require no contact.
I'm sorry, but that's
that's not possible. I
not
have
possible.
to take care of
I
the
have
dog.
to agree with her on that.
The only time
can
we have
take care of
issues
his
is when
dog.
he is drinking. He does not start.
That's
drinking-
not true.
He does not start drinking until night. So how about this? When he starts drinking, I will go lock myself in the bedroom.
Court order is going to remain, she's got to maintain a separate residence and not possess any weapons or firearms. I will allow, is pretrial release comfortable with her under pretrial release still at this time?
That's at your discretion, Your Honor.
That's what?
I can't say, it's
Oh.
at your discretion.
Okay, does the state still think pretrial release, they might be able to keep a better eye on it?
Yes, Your Honor.
I agree.
Would still like
Pretrial
pretrial
release.
release.
All right. I'm going to,
Ma'am, I have never hurt him in my entire life. He is not afraid of me. I'm not afraid of him. We are family. There is no reason for no contact. I have to be at his house to take care of the paralyzed dog.
court's decision stands.
Is there any way to make it not stand? Even he told
She's gonna, they're gonna probably file a motion immediately.
even he disagrees with it, and it's his home.
What do you want?
Thank you,
So,
Your Honor. I will.
I'm sorry, the conditions were no contact, maintain
Maintain a
separate
separate
residence,
residence.
no weapons or
Are we gonna
firearms,
go, Ken?
just those three?
Correct.
Okay.
Correct. I'll let
So
them
how
figure
much
out the
is my
home.
bond?
Oh, you're gonna get out on pre-trial release. You don't have to post a bond, okay? All right, thank you, sir.
Okay, thank you.
When I said.
All right, everybody, let's go ahead and, Damon LaBoy. I don't know who you are.
Damon LaBoy.
Okay, thank you. I just want to make sure we've got the correct individual. You're here on a charge of battery, dating violence, and at this time, let's go ahead. I can't get it scanned. This is in 2022 MM6239AO. And you do qualify for the public defender. I'll appoint the public defender's office to represent you. I don't see anybody standing up. We have to, we didn't know the other person was there, but I don't see anybody there at this time. At this time, is there anything further from the state?
No, Your Honor.
Okay. I'm going to require you, sir, not to have any contact with the victim in the matter. Do you understand that?
Yes, ma'am.
Okay.
Gotta read first. Don't just sign things.
I'm going to go ahead and get
Make
that
sure it's the
signed.
same thing.
And Your Honor, could you have that one-time return with law enforcement?
I'm going to require you to maintain a separate residence, not return to the scene of where this occurred. You can go back one time with law enforcement to pick up your personal belongings.
What if the person don't live there?
They don't live there. The attorneys, I'm sure, will file a motion for the court to reconsider that portion of it.
That's my mom's house.
Not getting into argument. For some reason, this seems to be an interesting assessment this morning.
And, like,
That's okay. I can hear you. I mean, just feel comfortable. I can hear you. But they'll request a hearing, okay? And I'm also going to require you not to possess any weapons or firearms. And also, victim has moved. I do show the victim has moved out.
Yes,
So what
me
I'm
too,
going to
Your
do is require you to maintain a separate residence. So if they're there, you can't live there. Do you understand?
Yes, ma'am.
Okay, so you must maintain a separate residence, not possess any weapons, and you're to have no contact directly or indirectly with the victim, okay? I'm gonna set your bond in the amount of $1,000 with those as the conditions of your release, okay? All right.
Thank you.
I had written that, and I just need to stop for a moment. Your name, please?
William Austin Mitchell.
Mr. Mitchell, sir, you're here in case number 2022 MM6245. This is a charge of battery, domestic violence. It's not scanning, so we've got a number in there for you. And at this time, you do qualify for the public defender. I'll appoint the public defender's office to represent you. At this time, is there anything further from the state or the defense?
No, Your Honor.
He qualifies for pretrial release. I would ask for pretrial release, Your Honor.
Okay.
In addition, I would ask that he be allowed to return to Georgia. And as long as he maintains contact with the public defender's office and returns for any court dates that
Do
he's
they
provided.
allow pretrial release if they live out of state?
Yes, Your Honor.
Okay, that's fine then. All right. Any objection on behalf of the state?
No objection, Your Honor.
I'm going to require you, sir, to have no contact with the victim directly or indirectly. Do you understand that? I'm going to also require you, sir, to maintain a separate residence and not to return to the scene of where this occurred. Do you understand that? They might have a trespass warning already out. I'm going to also require you not to possess any weapons or firearms. I will allow pretrial release and may return to Georgia. Do you all need that in your order?
Yes, Your Honor, as of now, because we had a little discrepancy, so we need that on the court order.
Okay, so may return to reside in Georgia?
Yes.
May return to reside in Georgia to keep compliant with all conditions of pretrial release and maintain contact with his attorney. Okay?
Thank you, Your Honor.
All right. Are you putting all that in there? Thank you. Got it.
Your Honor, Valerie Perez is behavior, but she does have a victim, someone who's the one to testify.
Okay,
I will waive the appearance, Your Honor.
all right. Public Defender's Office is appointed. This is case number 2022 MM6241, and I'll let you swear.
So raise your right hand. Do you swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record.
Can you tell us your name?
Julian Perez.
Thank you. And the state and the defense may have some questions, okay?
Okay.
Good morning, sir. How do you know the defendant?
She's my wife.
Do you live together?
We do.
While this case is pending, do you want to have contact with her?
Yes.
Has something like this happened before?
Yes.
Were drugs or alcohol involved in this incident?
No.
What about the previous incidents?
Well, when you say drugs and alcohol, I mean, she was trying her pills from the prescriber, and then she was smoking marijuana to try and cope with her anxiety.
So she takes pills for anxiety?
Yeah, well, she tried them from the prescriber. They were prescribed to her, and then she didn't like the way they make her feel, so she stopped taking them.
But she's not on medical marijuana.
No.
And you have a child or children in common?
We have 3.
And
We're a blended family, so we have one together. She's an infant, and then 2 of them they're my stepchildren.
okay. And your stepchildren were present during this incident, correct?
They were.
I have no further questions, Your Honor. Thank you.
Thank you.
No questions from defense, Your Honor.
Any objection to the contact and comply with DCF and no illegal drugs?
No objection, Your Honor.
And so you're not, go ahead.
So she has a mental condition that we're trying to find out and figure out why this is happening to her. But she's afraid to get help because she doesn't want to be medicated. So we need her to get some type of mental evaluation, but we don't want to Baker Act her. We don't want her to, she's been Baker acted before, and that got us nowhere. There was no follow-up. They only hold her for 72 hours. We need to put her somewhere where they can.
Okay, I can't do that today.
Okay.
And Your Honor, if I may, we do have social services with the Public Defender's Office. The judge did appoint us, and social services can provide that. We have contacts with mental health wards like Aspire or any place like that to try to get our services.
Okay.
So I am making a note for the attorney that she may need to be evaluated.
Okay.
And at that point, they can get the appropriate services.
And as far as her being released today, is she going to be released today?
Yes, Your Honor. I would ask for pretrial release. She does qualify, and given the victim's testimony, no hostile contact.
Would she qualify for mental health pretrial release?
You can have her screen.
Okay. Oh, what?
It's just that the odds of them being getting qualified for mental health, she may be in here for more days, and the odds of her getting qualified are slim. Your Honor. We don't get many people on mental health at all. That's the
You used to
only issue.
utilize it a lot, so that's why I just.
Yes, Your Honor.
All right. So you're not in fear for yourself at this time, are you, sir?
Right now, in the mental state that she's in, I'm in fear that she may have an episode with the kids in the home. So for her to be temporarily, for her to live with her dad, and
Okay,
and
so-
then we can't be in the same house at the moment until she gets
That's fine.
she gets on medication. That's all.
So you don't mind her having contact with you, but you think she needs to reside separately and not return to the home?
At the moment, yes.
Correct. Okay, that's fine. That's,
And the kids to be with either with me, or
well, I'm going to put comply with DCF. I
Okay.
can't order,
that's fine.
you know, because DCF's involved, aren't they?
Yeah, I met with them yesterday.
Perfect. There, she's got to comply with them,
Okay.
okay?
That's fine.
Is that acceptable to the state?
Yes, Your
then?
Honor.
All right, so I'm gonna allow her to have contact with you, sir, as the victim, but I'm gonna require her to maintain a separate residence. She's not to return to the scene of where this occurred. If she needs to pick up personal belongings, she can do that one time with law enforcement only.
Okay.
Okay?
And then or her dad, if that's okay. I mean,
Yeah, it doesn't, if you want to give the stuff to her dad and y'all agree, that's fine, but if not,
and-
I'm gonna
and
allow
this
her to
is
return.
this is temporary. I mean, she's still my wife. I don't necessarily. This is going to be temporary. This is not a.
This is the court order until the court order is changed.
Okay, and how does that change?
It'll be a motion through the judge that's assigned to it at the appropriate time.
Okay.
After you can speak with the state, you know, you can, you know what I mean? You can speak with the individuals, the attorneys that are assigned to the case, okay?
All right.
So let's go ahead. Once again, no contact with the victim, maintain a separate residence, don't return to the scene. No illegal substances, not to possess any weapons or firearms, may return one time with law enforcement only to pick up personal belongings. She'll have to call law enforcement first. They arrange time and place to meet her. That's when she can pick it up. But of course, if your father.
Yeah. Well, correction. You said no contact with the victim. You did say.
Oh, I'm sorry, no hostile or violent.
Okay, got it.
No, wait, she can have contact with you, that's correct.
Yep.
No violent or hostile.
Mhm.
I did say that incorrectly, didn't I?
Yes.
Okay, and I'm going to allow her to be released, pretrial release, and also she must comply with DCF.
Okay.
Okay,
All right.
I think that covered it, everybody.
And her dad is here to pick her up. Her dad is here to pick her up.
Okay.
All right. Thank
I
you.
don't know their I don't know.
Oh,
how quick-
so does he wait or like 4 hours? Okay. All right. Thank you.
You're welcome. Okay. Next case, sir, your name, please? This afternoon is
Aaron
not a
Smith.
smoother. All right, Mr. Smith, sir, is that correct, sir? All right, you're here on a charge, sir, of 2 counts of battery. This is case number 2022 MM6225AO. And at this time, we'll go ahead and have you both sworn in.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your names for the record? Can you state your names?
Donna Smith. Alicia Nicole Trajuzzi.
Okay. And you qualify for the public defender, Mr. Smith. I've appointed the public defender's office, and now I'm going to let the state ask some questions if they wish to.
Morgan, please watch.
Good morning. I don't mind who speaks first. If you just step up to the mic.
You want me to? Yes, please. Oh, what? Do you want to go first? Go ahead. Okay. Hello, ma'am. I'm sorry.
It's fine. And if you could just say your name again, please.
Alicia Nicole Trajuzzi.
And how do you know the defendant?
He's my fiance.
Do you live together?
Yes.
While this case is pending, do you want to have contact with
Yes.
him? Has something like this happened before?
Never. Never.
Were drugs or alcohol involved in this incident?
Alcohol.
Alcohol?
Yes.
Okay. I have no further questions for this witness at this time.
I would like to drop my charges against him.
Okay.
I love him. I love our boys and our daughter and our whole family.
Okay.
And he's never done anything like this.
Thank you.
You're very welcome.
Good morning, ma'am.
Hello.
Can you say your name again, please, for the record?
Donna Smith.
And how do you know the defendant?
It's my son.
Do you live together?
Yes, they live with me.
Okay. While this case is pending, do you want to have contact with him?
Yes,
Were drugs or alcohol involved in this incident?
alcohol.
I have no further questions.
I also would like to drop my charges.
Okay, thank you.
And, Your Honor, I have no questions.
Thank you both.
You're very welcome.
At this time, Mr. Smith, sir, I'm going to allow you to have contact with the victims, but it's to be no violent or hostile contact. Do you understand that?
Yes, ma'am.
And I'm also going to require you not to possess any weapons or firearms, and you're to consume no alcohol. Do you understand?
Yes, ma'am.
I believe, does he qualify for pretrial release? Is there any objection on behalf of the state?
No objection, Your Honor.
Thank you, Your Honor. No objection.
I just need his attention.
Oh.
Sorry, I'm a big believer that people fully understand what I say, so. Mr. Smith, sir, I need to make sure you understand, sir, the court's order. I'm going to allow you to be released, pretrial release, but you understand, sir, that if you violate any of the court's order, including the alcohol, you know, obviously no violent or hostile contact, and also the not possess any weapons or firearms, and the alcohol, that if you violate any of the court's order, the court will revoke the pretrial release and you can be in on no bond, okay? So make sure you're in full compliance. You understand, sir?
Yes, ma'am.
All right,
Your Honor,
thank you.
only because it's alcohol, can we also do random urinalysis?
Sure. We'll do random urinalysis also. Okay, thank you. Thank you both.
May I ask a question?
Yes.
We live in North Carolina. Is it okay to go?
Oh, I didn't know that. Could he return to North Carolina?
Yes.
Okay.
Can we?
Pull him back in. And everybody's okay with that? You're in Lenore, right?
Yeah.
Thank you for bringing that up, because
Mr. Smith, sir, it was brought to our attention that you reside in North Carolina, so I'll put on the order for the pretrial release, no objection to you residing in North Carolina and returning, okay? All right, thank you.
Thank you very much. Thank you. Can you get her bottle for me? I'll get it. Thank you.
All right, your name, please?
Feta Messis.
All right. You are here in case number 2022 MM 6248AO, and this is a charge of battery, domestic violence. You do qualify for the public defender. I will appoint the public defender's office to represent you at this time. I don't see any witnesses here. And at this time, I'm going to require you to have no contact with the victim. Do you understand that?
Yes.
I'm also going to require, and you've signed the no contact order and understood that?
Yes, Your Honor.
I'm also going to require you to maintain a separate residence. You're not to return to the scene of where this occurred. And in addition to that, I'm going to require you not possess any weapons or firearms. I will also require, I believe DCF was contacted, is that correct?
Yes, Your Honor.
So I'm going to require you to comply with DCF, all right?
Your Honor, she qualifies for pretrial release. I would ask for pretrial release in this case.
Okay, and does she need to return one time?
Yes, Your Honor.
Okay. I'll allow you to return one time with law enforcement to pick up your personal belongings. Now, when you do that, you contact them first. You know, you call law enforcement and say, the judge has allowed me to go get my personal belongings, but you contact them first and they arrange when and where to meet you. Don't go there and then call them, okay? You understand?
Yes.
Okay, thank you. I just see everybody's head. And you do qualify for pretrial release and also must comply with DCF. I think this is our last DV case.
Yes, Your Honor.
All right. What are we doing with the head?
It's trouble hearing.
Yes,
Oh,
here.
that's okay. I thought we needed to call an interpreter.
No, he understands and he can't hear.
That's okay. We're good. Sir, can you?
Good morning.
Good morning, sir. Can you tell me your name?
My name is Andor Vermesi.
Mr. Vermesi, you're here in case number 2022 MM 540AW.
Ma'am, I didn't hear you. Excuse me.
That's okay. I just don't want to talk too loud with the headset on. Can you hear me okay? I can talk a lot louder.
Okay, let's try this. Oh, no.
You want me to keep talking and then see if you hear? Just let me know when you can hear me. Can you hear me?
Yes, now I hear you. Let me put this one down because this is just as anti-phone.
Okay, can you hear me okay?
Yes.
Okay, I just want to make sure. I didn't want to talk real loud when you had that headset on. You know, I didn't want to hurt your ears with that headset on.
Yeah.
You're here on a charge of battery, and if you'd like to swear the witness in, please?
Do you swear affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record.
Christina Vermesi.
Good morning, ma'am.
Oh, hi.
How do you know the defendant?
He's my husband of 14 years.
Do you live together?
Yes, ma'am.
While this case is pending, do you want to have contact with him?
Yes.
Has something like this happened before?
So he never hit me. Before he grabbed my hand, but he was really drunk, and he's quit drinking since.
Okay. You mentioned drinking. Were drugs or alcohol involved in this incident?
No. He quit drinking since we had a lot of arguments for years, and then he stopped drinking.
Okay. I have no further questions, then, Your Honor. Thank you.
Does the defense have any questions?
No questions, Your Honor.
All right. So you wish to have contact with him and you all be able to reside together?
Yes, ma'am. He's not dangerous in any way. We just had a heated argument, and I feel like I was screaming more than him.
He qualifies for pretrial release, is that correct?
Yes.
And any objection on behalf of the state?
No objection, Your Honor.
I'll allow pretrial release with no violent or hostile contact with her, with your wife, no violent or hostile contact, and also you're not to possess any weapons or firearms. Okay?
Do not possess nothing. I'm peaceful person, Honor.
Okay. Your attorney may not want you to say too much because we're being recorded, but those will be the conditions of your release, okay? So you're going to be released today, but you can't have any violent or hostile contact and no weapons or firearms.
Okay, no problem. So,
Okay.
ma'am.
All right, thank you.
This is yours too. That's it. The release should have done.
All right,
That's it.
thank you.
Thank you, ma'am.
That was it. All right, everybody, I believe that concludes our domestic violence cases. We'll start the out-of-county warrants. All right. Mr. Jenkins, if you want to come on up. Mr. Jenkins, sir, you're here on the following charge. It's it's an out-of-county warrant out of Miami-Dade. And at this time, sir, that court has set bond at none. All right? They'll be notified to pick you up, sir. All right, thank you. Your name?
Mariah Lofton.
Ms. Lofton, you're here in case number 22 MM 941, and this is a charge out of Osceola County. And that court has set your bond at $5,000. And so if you're able to post your bond, you have a bond to post. If you're not, they'll be notified to pick you up and take you to Osceola County, okay?
So what does that mean? I have to pay $5,000?
And that's the bond. You'll have to talk to a bondsman as to the exact, what you have to put up, but the bond's $5,000, okay? I don't know why there we go. You can come on up, sir. I just don't know who the order we've got. Your name, please?
Arnold Marchone.
Mr. Marchone, sir, you're here on an out-of-county warrant, sir, also. This is out of Volusia County, sir. That court has set both bonds at 0. They've been notified to pick you up.
Your Honor.
I've got 6,000 on one. They all say 0. I don't know where you all look. I'm sorry. So is it? I'm looking at the warrant. Okay, count one, count two. They've set bond at 6,000. Does everybody show that?
I don't get those, Your Honor.
Yes, Your Honor.
Why do they type them in like this?
Becca, his fingerprints clear?
Oh.
They do fingerprints or anything?
But why do they put zeros in here?
So, yeah.
This is not correct, though. The bond was set at 6,000, okay? So you do have a $6,000 bond, sir. If you're able to post it, they'll pick you up then, okay? They'll be notified to come and get you from Volusia County. I know I said the same thing yesterday, but it just. All right. Sir, your name, please?
Alexander Patterson.
Mr. Patterson, sir, you're here on an out-of-county warrant also, sir, and it appears this warrant is out of Polk County, and count one and count two, they've said at none. Count three is 200 and, or, I'm sorry, count one is at none, count two is at 250, and count three is at 500, and they'll be notified to pick you up, sir, and take you to Polk County, okay? All right, thank you, sir.
Your Honor, I believe this is the wrong one.
Okay, what?
You're not Patterson.
Alexander Patterson.
Christopher.
Christopher.
No, this is not Christopher Patterson.
Okay, we need What, why am I surprised today, right? That's all.
White male?
I didn't even look. I was looking so much at the bond amounts because some of them are saying no down there and a different up there. You can come on up, sir, the next person. Your name, please?
Cameo Bannister.
Who? Okay, Vetter refused. Bonds.
Will waive, Your Honor.
Okay, I think they're out of counties, so all those bonds will remain the same, okay?
Which is what, Your Honor?
Oh, there's a whole slew of them. 2,000, under the one case number of CF 2022. I'm sorry, everybody, I'm just not, so used to courtrooms not interspersing, and I'm like, what? All right.
Just came in here?
4242 is 2,000 and 2,000. Am I correct on that, everybody? Yes.
Yes, Your Honor.
All right. 2022 CF 93723 is 2211111, according to the warrant. Am I correct on that, everybody? With a total bond of $10,000.
Yeah.
Got, yeah. 1, 2, 3, 4, 5 at 1,000. Is there another one on the top page? There's another one. 6 at 1,000. Correct. And then the other ones were set. All right. Your name, please?
Cameo Bannister.
Mr. Bannister, sir, you're here on a charge of a violation of probation. And there's two cases, sir, 2022 CF 72AO. That court set your bond at none. You have a second case, sir, of 2022 MM. I'm sorry, everybody. I need everybody. I'm sorry. There's just so much going on today, and I'm trying to concentrate on the individual in front of me. In 2022 MM 4170AO, and that court also set bond at none. And I've appointed the Public Defender's Office to represent you, sir. Okay? Thank you. Okay, do y'all have a question?
Let me see.
There was a count on the back side of the. Right, and I announced it. Yeah, I did, I announced it.
We just need another one of our orders.
Okay, I'm sorry. Yeah.
Yeah.
Sorry.
They left
Yeah.
out one of our
Yeah,
orders.
and just so you'll know, though, the 1,000s on him, make sure there were enough, because on the charging affidavit, there was one on the second page of that 1,000, so I think there were 6 at the 1,000. Just, I don't know if there's 6 individually listed. That was the one that one of you asked what the bond amounts was, and so instead of me just, I went, as stated. Well, as stated causes a can of worms, so. All right, your name, sir?
Earl Nixon.
Mr. Dixon?
Earl Nixon.
All right. At this time, sir, you're here in 2020 CF 12902AO. This is a violation of community control. The court has issued a warrant and set bond at none. I will appoint the public defender's office, sir, to represent you on the case, okay?
Thank you.
You're welcome, sir.
Yeah,
Oh, he has
Your
2
He has
cases.
2 other.
You've got one other. You've got also a charge of resisting officer with violence, and a second count of that is possession of 20 grams or less of cannabis. And at this time, sir, let me review one last portion of that. I do find probable cause. Bond will remain the same at 1,000 under count 1 and 100 under count 2.
That's it?
I believe I showed the 2 cases. Yes, sir. Thank you.
Thank you.
You're welcome, sir. All right. Your name, please?
Christopher Santos.
Mr. Santos, sir, you're here on a violation of probation, sir, and the court that has issued is this an on view? No. Where's my warrant? It's an on view. Probation, committed the offense on 9/9. Okay, as evidenced by the arrest, correct. At this time, it's an on-view violation, sir. At this time, I'll set bond at none, but I will appoint the public defender's office to represent you, sir, on this case also. And this is the 2019 CF 6029BO. I saw you yesterday. Right.
I have a private attorney, ma'am. I don't need a public defender.
But you don't?
No, ma'am, I have
You
a
know-
private attorney. Andrew Darling.
Okay, and you've already notified, you'll notify regarding the VOP?
Yes, ma'am.
Okay, all right, then we'll have that, you're hiring your own attorney. Okay.
All right, thank you.
Okay. Sir, your name, please?
Richard Swami.
All right, Mr. Swami, sir, you're here, and let me go ahead and, you've got 3 new cases, and then I'm showing an out on bond case. So let's go ahead and you've got a violation of probation, an on view, and that's in 2021 CF 4658AO. At this time, sir, I do find probable cause for the on-view violation of probation that shows that you're, currently on probation. That bond will be set at none. At this time, as to the second violation of probation, which is, I don't have a case number. Is that? Oh, that's an out-of-county one. And what county was that one out of? Seminole. On-view violation of probation, I see for Seminole County. That'll also be held at none. They'll be notified, though. They'll be notified regarding picking you up. And then the second case is the actual charge, the new charge of driving while license suspended as a habitual traffic offender. Public defender's office is appointed, and that bond will remain the same at $2,500. Now, he is out on bond on a case. Can someone give me some general information regarding that? Or?
One moment, Your Honor.
I'll look up to.
Your Honor, it appears as though formal charges have been filed. That's the easiest way to put that.
filed it under one case number, it looks like. This time, sir, I am gonna revoke that bond under 2021 CF 4678BO, and that bond will be set at none. Okay? But you got the public defender. Did he have the public defender on that case also?
Yes, Your Honor.
Okay, so they've got that information.
Your Honor, we have Christopher.
Okay, thank you. Sir, you're here on something that I might have already handed back to the clerks. Did I hand that to you? Thank you. Your name, please? All right, and sir, what is your date of birth? Okay, thank you. You're here on a out-of-county warrant, sir, and this is from Polk County. Count 1 was set at none, count 2 is set at $250, and count 3 is at $500. Polk County will be notified to pick you up, okay? All right, thank you, sir. All right, everybody, we'll stand in recess till what time?
33-day motion.
Go ahead, and we'll get those brought up, all right? And if I could please once again have the attorneys announce their names for the record.
Taylor Fleming on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
All right, thank you. Try him again.
Hello, Cisco Unity connection.
Not what we want, is it? Were they aware we were moving? Well, I just. They knew that we were calling, okay. If not, we may, switch a few people around, you know. No?
Hello.
We're not able to, I mean, at the moment, just this second. So it may be easier to switch a few people around. Is that okay with everybody?
There's an offer on the out on bond as well. He doesn't have
We're going to go straight to arraignments? Okay, that's fine.
no record.
On the Valley guy?
One of them was, right. Okay, that's okay. Just somebody tell me what we want to go on. I'm fine. Now, you know, as soon as I do this, they're going to come in. They're going to,
He doesn't have anything else.
whatever he says, I'm just,
You just had a high bond on the new one.
sure, yeah, that's fine. Okay, 12:30 for the interpreters. All right, and then they said we're going to do in-jail arraignments, I believe, next?
Yes, ma'am.
All right, sir, if you want to come on up, can you tell me your name, please?
Freddie Donnell Brown.
I'm sorry, what was your last name? Oops.
Brown.
Brown. All right, Mr. Brown, sir, you're here on a charge of driving while license suspended with knowledge in case number 2022 CT 815AW.
Your Honor, and the offer from the state is an adjudication of guilt, credit time served. It's not here. Mr. Brown would like to accept the state's offer and enter a plea of no contest.
Understands that, understands about HTO statuses, understands about the enhancement of a driving while license suspended and not on probation, I presume, for anything. Is that correct?
He is not on probation. Yes, Your Honor, he has he's already H2O.
Okay, and you've explained to him the enhancements, and this can be used, and Mr. Brown's shaking his head, yes. All right, is that correct, Mr. Brown? I don't want to, it seemed like that's what you were doing, is that correct?
Yes, ma'am.
All right, at this time, and is this the agreement of the state?
Yes, Your Honor.
And the Public Defender's Office was appointed, so I do need the Public Defender's Office to
know.
sign that.
My paper said nothing.
Yeah, if you want to, I'll need you
Used
to,
to the pleas, not signing. I'm sorry.
got to have those signed. All right, at this time, Mr. Brown, sir, it's my understanding you wish to enter a plea of no contest to the charge of driving while license suspended with knowledge. Is that correct, sir?
Yes, ma'am.
Is that your signature, sir, that's on the plea form that you just signed in open court?
Yes, ma'am.
Did you understand all the rights you're giving up here today?
Yes, ma'am.
Do you have any further questions regarding those rights that you're giving up, sir?
No, ma'am.
Are you satisfied with the services of your attorney?
Yes, ma'am.
Do you have any other questions for your attorney at this time regarding this charge?
No, ma'am.
Are you on probation for any other matter?
No, ma'am.
And do you think the services of your attorney was worth, do they do the $50 lien out here, or just the court? The $50, you think the services of your attorney was worth $50?
Yes, ma'am.
All right, sir. And you stated you are on probation, and you understand that by entering this plea, this is an enhanceable offense. Do you understand that, sir?
Yes, ma'am.
All right, sir. And do you still wish to continue with your plea of no contest?
Yes, ma'am.
All right, sir. This time I'll accept the plea. I'll adjudicate you guilty. I find the state, can I just get the facts, the driver's license? You show he's on a suspension currently.
His driving record?
Yeah, just, if you'll just represent to the court. But his license is suspended and.
Yeah, sure. He is currently suspended on multiple different suspensions.
Okay.
His latest being a 2020 failure to pay.
Okay.
He also has several 893 suspensions, and he has been HTO'd since December of 2021.
Okay. All right. The court does find sufficient facts to take the plea. I'll adjudicate you guilty. They will be taking your print, sir. I'll sentence you to 6 days in jail, credit for 6 days time served. There's mandatory court cost, and they're going to add everything together, and the PD lien add it together. I'm going to go ahead. I know you've got some failure. You've got to pay these. I'm going to go ahead and give you a year to pay.
Thank you.
And if you want, $323. And if you want, sir, you can go to the clerk's office to start a payment plan. If you wait to the end of it, they won't put you on one. You know, it just causes the whole thing to snowball. So if you take the time, to go, they'll set you up payment structures. And that's where people, I don't understand why they don't do it, because it's such a benefit, to keep a license or try to, you sure don't want to get arrested on it again. All right.
Ma'am.
Any further questions?
No, ma'am.
All right, so
Appreciate
anything
that.
further from the state or the defense?
No, Your Honor.
You have the right to appeal the sentence of the court. You must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed to represent you. Okay?
Thank you, ma'am.
You're welcome, sir. Thank you. All right. The next case is Mr. Lightsey. Is that correct, Mr. Lightsey? Mr. Lightsey, sir, you're here in the case before that, just so I'm not sure I scanned, but that was 2022 CT 815AW. In fact, we're going to go back to Mr. Brown. We don't need him in here, though. There were 2 underlying infractions. Any objection to dismissal by the state since
No,
it
Your
led
Honor.
to the criminal charge? We're going to dismiss 2 underlying infractions, the TRs. Yeah, we are, because he pled to the criminal charge and no reason to keep those open. And those are the TR 2022, I'm struggling with that, aren't I? 12692AW and 12693AW. And without objection from the state, okay? And we put on the order also that he pled to the CT. So that everybody knows why we did it, and it makes hopefully good sense. All right. Mr. Lightsey, sir, you're here in case number 2022 CT 68181. And that is a violation of probation. I'm showing the Public Defender's Office has been appointed to represent you.
And we will enter denial, Your Honor.
Enter a denial, and we'll go ahead. I believe they give the VOP dates in here now.
October 3rd.
Do I throw these away? Okay. Your name, if you want to come on up. What happened with Mr. Bennett? Okay. You want to do a waiver of arraignment on him?
I will waive and enter a plea of not guilty, Your Honor.
Okay. On Mr. Bennett, in case number 2022 MM5609AO, waiver of arraignment rather, and plea of not guilty to be set for pretrial, I believe. And that's not domestic, it doesn't go to the that's not a domestic case then? Okay, all right. You can come on up now, Ms. Daugherty.
Your Honor, Miss Marissa Doherty
Doherty.
is medical also.
And I will waive and enter a plea of not guilty, Your Honor.
Okay, at this time in case number 2022 MM 2810AO, waiver of arraignment, plea of not guilty entered, and
Case to be heard in Division 63. Pretrial conference is October 4th, 9 a.m. I'm sorry, at 1:30. Court 10B.
y'all are having to do that. 'Cause I remember we used to have those sheets up here that I would make a mess of. Ms. Green?
Yes, ma'am.
Okay, Ms. Green, you are here in case number 2022 MM 5226AO, and the charge is battery domestic violence. I'm showing the Public Defender's Office has been appointed to represent you on the matter in this case. And at this time,
We will enter a plea of not guilty, Your Honor.
plea of not guilty is entered, and the matter will be set for pretrial, and we're going to get you that date right now.
Case to be heard in Division 50. Pretrial conference is October 21st at 9 a.m.
Thank you.
Your name, please?
Bradley Smith.
Mr. Smith, sir, you're here on a violation of probation, sir. And this was, the Public Defender's Office has been appointed on the matter.
And we will enter denial, Your Honor.
Division 50. Guilty status is October 17th at 9 a.m.
Your Honor, Amanda Torres is medical.
Okay. It's a battery charge.
I will,
She
Oh.
doesn't? Okay, I'll appoint the Public Defender's Office to represent her. We don't show private counsel or anybody. Okay, and she's been in jail, you know, so I will go ahead and appoint the Public Defender's Office to represent her.
and I will waive and enter a plea of not guilty.
Okay, waiver of arraignment and plea of not guilty, 2022 MM 3633AO.
Division 62.
I mean, their attorneys are very familiar, I'm sure. All right, Wilson? Mr. Wilson, sir, you're here on a violation of probation in case number 2022 MM 255AW. And I'm showing the Public Defender's Office was already appointed to represent you.
I will enter denial, Your Honor.
Division 50. Guilty status is October 17th.
Your name, please?
Maurice Wright Davis.
Mr. Wright Davis, sir, you're here in case number 2022 MM 6149AW. And at this time, sir, this is a charge of an assault, and the Public Defender's Office has been appointed to represent you on the case.
And we will enter a plea of not guilty, Your Honor.
Plea of not guilty is entered and a waiver of the arraignment. And at this time, sir, the matter will be set for pretrial, and we'll get you that date, okay? That concludes. We can try, they said 12:30, it's 12:28. Do you think we might could try it, or should we? What do you all think?
That's fine.
What- They're either gonna answer or not. I just don't want them to go, Judge Clark, you know, give us a second. We're gonna try. I'm going to leave them alone because it rang 3 times. So we'll start the, what's next? The misdemeanor pleables? Okay. All right. Your name, please?
Reginald Anderson.
Mr. Anderson, sir, you're here on a charge, sir, as follows. It's a charge of petty theft. It's case number 2022 MM 223AE. I'll appoint the Public Defender's Office to represent you at this time, and I believe he is out on a bond. Is that correct? But
Yes, Your Honor, for petty theft to prior, I believe.
the plea hearing is set on September 16th, I'm showing. He said he, I believe, must be present for those. Sir, on this charge of this petty theft, I'm going to require you not to return to the scene of where this occurred. Do you understand that?
Yes, ma'am.
Okay. Anything further from the state? Is that on?
No, Your Honor. I don't believe the out of bond and the new law are the same location.
Okay, is that,
No, I was just making sure they were not the same location, because if they were, state would have asked that it be revoked. However, otherwise, state will leave it within your discretion, Your Honor.
I'm inclined to revoke. It's the exact same charge. That occurred on February the 1st. He's got a return date for plea for,
16.
Friday, I believe, right? Friday. So I think I'm going to go ahead and revoke that. So Mr. Anderson, I'm sorry, sir. I'm going to revoke the bond under 2022 CF 1154AO, sir. But you've got a hearing already set, the end of the week. So I'm sure the attorneys are writing, notes that you're incarcerated so they can get you brought over, or whatever that procedure is for that particular court, okay? And sir, at this time, I'm going to require you not to return to the scene of where the new charge occurred. I will keep that bond, though, at $500, but I did revoke the other one. But you've got the PD appointed on both of them now, okay?
Thank you.
You're welcome. Thank you. Sir, your name, please?
Jeremy Dean Cameron.
Mr. Cameron, sir, you're here. Mr. Cameron, sir, you're here on the charge of lording or prowling, resisting officer without violence, sir. You do.
Oh, sorry.
You do qualify for the public defender, and as to,
Your Honor, state did convey an offer to Mr. Cameron to plea to count 2, the resisting of an adjudication, credit time served, and no return to the publics. And in exchange for that plea, state would no info, count 1, the loitering and prowling.
And he would like to accept and enter a plea of no contest.
all right, he's got 2 days in, I think. All right. Mr. Cameron, sir, it's my understanding, I'll let you go ahead and sign that plea form in open court, okay? Don't I? All right, Mr. Cameron, sir, at this time, it's my understanding, sir, you wish to enter a plea of no contest to count 2. Is that correct, sir? From where you're standing, sir, is this your signature that is on the plea form? Did you read and understand the rights on the plea form? And do you have any further questions regarding the rights that you're giving up by doing so? Are you entering this plea on your own free will? And is anyone forcing or threatening you to do this today? Okay. And are you satisfied with the services of your attorney?
Yes, ma'am.
And do you think those services were worth $50, sir?
Yes, ma'am.
Are you on probation for any other charge?
No, ma'am.
All right, sir. And at this time, regarding count 2, the resisting officer without violence, sir, how do you wish to continue with your plea?
No
contest.
It was no contest.
All right. I'll accept your plea. I find sufficient facts to do so, and that you're freely and voluntarily doing so. I'll adjudicate you guilty, sentence you to 2 days in jail, credit for 2 days' time served. There's mandatory court cost and the $50 public defender lien. They're going to add everything together. I'll give you 1 year to pay that. And my suggestion would be to get to the clerk's office to try to get a payment structure that because they can make it small, you know, but what happens is if you wait till the end, that you don't have enough time to get those payment structures started, okay? So make sure you do that, or it's due within 1 year. And as to count one, the state is orally announcing a no information. We'll follow up that with the written, I presume?
I'm following it up right now, Your Honor. State announces a no info as to count one.
Okay. You'll be released on this case today, and you have the right to appeal the sentence of the court. Must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed to represent you, okay? And sir, no return. Was that part of the agreement?
Yes, Your Honor, to the
Can't go
public.
back there. You understand, sir? Do you understand? Okay, sir. All right, thank you. No return. Your name, please? Your name?
Gerald Johnson.
Mr. Johnson, sir, you're here on the charge of trespass on property after warning, sir. I've reviewed the charge and affidavit. I find probable cause. This is in case number 2022 MM6218AO. And at this time, was there an offer or?
No offer from the state, Your Honor.
Bond will remain at $500, and you're not to return to the scene of where this occurred, okay?
Your Honor, may I approach the clerk?
Sure. Thank you. Your name, please?
Jeremy Morrison.
Mr. Morrison, sir, you're here on a charge of trespass on property after warning, sir. And this is in case number 2022 MM6216AO. And is there an offer?
Yes, Your Honor, state did convey an offer to Mr. Morrison of an adjudication of guilt, credit time served, and no return to the Wawa at 5820 Edgewater Drive.
He would like to accept and enter a plea of no contest, Your Honor.
At this time, Mr. Morrison, sir, it's my understanding you wish to plead no contest to the charge of trespass on property after warning. Is that correct, sir?
Yes, ma'am.
Is this your signature, sir? That is on the plea form here. And did you understand the rights you're giving up by entering the plea today? Do you have any other questions regarding those rights that you're giving up by doing so?
No, ma'am.
All right, sir. Are you on probation for any other charge? And are you entering this plea on your own free will because this is what you wish to do?
Yes, ma'am.
Is anyone forcing or threatening you to do this today? And are you satisfied with the services of your attorney?
Yes, ma'am.
And do you think those services were worth $50?
Yes, ma'am.
All right, sir. At this time, now that I've asked all those questions regarding the plea, do you still wish to enter your plea? Or let me ask you, how do you want to enter your plea to this charge of trespass on property after warning?
Accept the plea on no contest.
No contest. I'll accept your plea. I find sufficient facts to do so, and that you're freely and voluntarily entering the plea, and you understood the rights you're giving up. I'll adjudicate you guilty, sentence you to 2 days in jail, credit for 2 days' time served. There's the mandatory court cost and the public defender lien. They're going to add those together. I'll give you 1 year to pay for that. I know you were standing in the back when I said go to the clerk, set up a payment structure. You're not able to pay it, but I've given you that time to be able to set that structure up or to have it paid off. Also, you're not to return to the scene of where this occurred. Do you understand that?
Yes, ma'am.
All right, sir, because if you do, they're going to arrest you again, and the state, I suspect, will ask for a substantially longer time, because you've now been told by the court also, do not go back, okay? Do you have any other questions, sir? All right, sir. At this time, you have the right to appeal the sentence of the court. You must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed to represent you. You'll be released under this case today. Okay? All right. You're welcome, sir. All right. Your name, please?
Daniel Roller.
Mr. Roller, sir, you're here on a charge of providing false identification to a law enforcement officer. This is in case number 2022 MM6223AO. I've reviewed the charge and affidavit. I do find probable cause. Public Defender's Office is appointed.
Your Honor, state did convey an offer to Mr. Roller of an adjudication, credit time served.
We would like to accept and enter a plea of no contest, Your Honor.
Is this the agreement of the state?
Yes.
At this time, Mr. Roller, sir, it's my understanding you wish to plead no contest to the charge of resisting, providing false ID to a law enforcement officer. Is that correct?
Yes, ma'am.
From where you're standing, sir, is this your signature that is on the
Yes,
plea
ma'am.
form? Did you read and understand the rights on the plea form?
Yes, ma'am.
And did you have a full opportunity to discuss these rights with your attorney?
Yes, ma'am.
Do you have any further questions regarding the rights that you're giving up by doing so?
No, ma'am.
Are you entering the plea on your own free will?
Yes, ma'am.
And also, sir, are you on probation for any other charge?
No, ma'am.
And is anyone forcing or threatening you to do so today on this?
No, ma'am.
To plea? All right, sir. And at this time, now that I've asked all those questions, sir, how do you wish to continue with your plea?
No contest.
No contest.
I'll accept your plea. I find sufficient facts to do so, and that you're freely and voluntarily entering the plea. I'll adjudicate you guilty, sentence you to 2 days, credit for 2 days' time served. Mandatory court costs plus the PD will be added together. Now, I'm showing they've got a hold on you, I believe, out of Osceola County.
I just asked, Your Honor, there's bond, so if you can bond out from here, right?
Just so I can
Yep.
still get out, I can still bond out and get out?
From here. Mhm.
They're saying you have a bond on them. So, I mean, I'm not setting a bond, I'm not revoking the bond. Whatever that court paperwork was will still stand, okay?
You have bonds.
And so, but I'm going to give you 1 year to pay these charges. I mean, the court cost of the PD lien. Once again, I don't know if you were standing, I know they bring another person in, so I'm not sure where you were in the line. But if you can't pay it off, make sure you go to the clerk's office to be able to set up a payment structure, because then they can put you on a monthly payment and that can extend. So, but if you wait till the end, they won't be able to do it, and then they revoke your license and everything just snowballs, okay?
Thank you.
You're welcome, sir. You have the right to appeal the sentence of the court, must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed to
Your Honor,
represent.
he does have an out on bond. State would request no action on it.
Thank you.
No action.
You can bond out from here.
The request of the state. And what I prefer on those, if you will, on those, no action requested by state, and then in parens, put pled to, because it kind of makes sense why, I'm just a big believer of looking at a document and knowing exactly. All right, your name, please?
Marilis Lozama.
Ms. Lozama, ma'am, you're here on a violation of pretrial release, and where a warrant was already issued, that bond has been set at none. I will appoint the Public Defender's Office to represent you if they were not already appointed.
I would like to represent myself if that's possible.
I didn't know that, I thought.
Yeah.
Can I have just a moment, Your Honor?
Sure.
I just want to, it doesn't say it can't be modified.
Got it. So she won't.
There's a PD motion to withdraw. She has RCC.
Oh, she has regional conflict. Okay.
Just when the attorneys are ready, let me know, okay?
All right. Get in front of the judge on your case. You're gonna have to speak to the attorney because he has to file a motion.
After when I because my spirit is at 11.
And Your Honor, I I advised, even though she's not my client, I did advise her not to speak about the facts. She has regional conflict counsel. She still wants to talk about the facts of the case. I tried to explain that nothing's gonna change today and that everything is being recorded, so I just wanted to put that on record.
There's nothing this court's gonna do today, Ms.
I
Lazoma.
know, but I just wanna be able to elaborate on.
I know, but I'm not gonna be, let me just explain it. If your attorney was standing here beside you, you know, your attorney that you have, they don't want you to say anything, because while you may not think it'll hurt your case, that it's gonna help your case, I promise you, whatever you say will somehow or another not benefit you. And I'm not the judge. See, I'm handling just the initial appearances, so there's nothing, there's nothing to explain that's gonna help your case, because I'm not the judge assigned. Okay, so you've got your attorney, and that's good, you know,
I don't have a, I defend myself in all my cases.
you do, okay.
I was trying to say that I
Yes.
rather elaborate on my.
That's okay, I'm fine.
I don't consent to nobody to,
Okay,
on my child.
we're gonna get you a date set.
I just wanna elaborate on certain aspect, even if it doesn't help improving it, but at least it's reported and being looked at, or being something that can be searched by the next person, if that makes sense.
Well, I think what we'll do is they're gonna set you for a hearing, okay? You're gonna get some hearing dates, and so at that time, it'll be back in front of that judge that issued it, that issued the warrant, that set the bond at none, okay? So we'll get those dates to you shortly, all right?
Thank you.
You're welcome, thank you. Okay, thank you all. Thank you. Thank you.
Hey,
All right, your name, please?
Shalonda Patrick.
All right. Ms. Patrick, you are here on a charge of a failure to appear. That court has set bond. I'm showing, what is everybody showing for the bond amount?
It says 200 on mine.
It says 200 on what I see, but why does it say zero?
I paid 105,
Okay, wait.
already.
She's not talking.
Just a minute, let me let the,
I didn't get it.
She's not talking to you. Hold on.
I don't want to.
Just have a private.
what does correction show? I mean, the staffing.
We have 200.
You have
I
200?
had 200 as
I
well.
think everyone
Because
does.
on the charging affidavit, it says zero.
Yeah,
On the top right area, do y'all see that? Or am I reading it wrong? I mean,
You do.
Oh, I have two.
it's 200, man.
okay, but just the paperwork shows zero, everybody. Wait. Came to the middle, okay. So by her name, it shows zero. So just so everybody will, you want to see? Oh, you got, okay. Up at the top, it shows zero. In the middle, it shows 200. And then, what did it show on y'all? It shows 200, right. But what did it show on my paperwork? Zero. On the paperwork he's filling out. It did, good. Okay, so you're set at $200. I just want to make sure we get you right. And,
Where I can get pretrial release?
no, ma'am, you'll have to go in front of that court that issued the warrant, because you failed to appear for pretrial release on August the 29th, but we'll get you an attorney, okay? All right, thank you.
So it's $100 to bond out?
I'm not the bondsman. I don't want to represent to you because they have their schedules that they apply. Okay, you want to come on up? Mr. Duke,
Ricky DeBose is outside now.
okay.
Can we reset, Your Honor?
You want to try tomorrow?
Mm-hmm.
Okay, we'll
There's an offer.
reset for tomorrow. Gary Moody, okay. Moody, sir, you're here on a charge in the, let me get this scanned. You're here, sir, in case number 2022 MO1040AO. The charge is alcoholic beverage with an open container.
And the offer from the state, Your Honor, was an adjudication of guilt, credit time served, and Mr. Moody would like to accept and enter a plea of no contest.
Okay. And is this the agreement of the state?
Yes, Your Honor.
All right.
You'll go home.
So are you acting just as a friend of the court?
Yes, Your Honor.
Were you, because this is, the other ones were arraignment, I mean,
Yes, Your Honor, I will act as a friend of the court because he's accepting the plea.
Do you want
Mhm.
to take your name off now?
I'll just do it.
You sure? Okay. I'm gonna do
Yes,
this
ma'am.
then, okay?
Just on here, Mr. Moon.
All right, so she's just act, so we don't need the PD extra.
Doesn't make sense.
Which he didn't fill out a form, did he?
No.
No. He doesn't have to pay any. All right, Mr. Moody, sir, it's my understanding you wish to plead no contest to the charge of possession of the alcoholic beverage by having an open container. Is that correct, sir?
Yes, ma'am.
Got your signature, sir, on the plea form?
Yes, ma'am.
And did you understand the rights you're giving up by pleading here today, sir?
Yes, ma'am.
Are you on probation for any charge?
No, ma'am.
All right. And you understand that by giving up the rights on the plea form, we're going to resolve the case today?
Yes, ma'am.
All right, sir. At this time, I'll accept your plea of no contest. I will adjudicate you guilty, sentence you to 2 days, credit for 2 days' time served. You'll be released on this charge today. There's mandatory courts costs, sir. I can't waive those. So what I'm going to do is give you a year to pay those. And you can go to the clerk's office and try to set up a payment structure, to get you on a payment schedule that would obviously be an amount you can afford monthly or how they designate.
Yes,
Okay?
ma'am.
All right, sir. You'll be released today. I previously advised you of your right to appeal the sentence. Thank you. Okay, do we want, are we gonna do traffic now then, maybe, or what are we doing? I don't care, but. We have Jocelyn White. Bonded. Okay, we then have Alexander Davis. Bonded. Okay. We then have Donald Flashman.
And I will waive the appearance. Your Honor.
Okay. At this time, on Mr. Flashman, DUI, and also violating driver's license restriction, 2 case numbers, 2022 CT 5162AO, CT 2022 5163. Paperwork's filled out, we can appoint then? Okay, PD is appointed, because I think you're going to tell me if they're not, so.
No, we don't have a PD form.
I'll appoint the Public Defender's Office at this time. He is to consume. No, that's okay, y'all are doing fine, I just want to make sure. Consume no, hang on one moment. Consume no illegal drugs. He is to also abide by all prescription medication. The bond will remain the same at 500 and 500. Can you all do a random urines with the bond?
Yes, Your Honor.
Okay, plus random urinalysis under both counts. And he's out on bond. And the state's position on that out on bond, just was out on bond.
Check to see if we filed.
That's 2022 MM 5865AO.
State would request that you revoke at this time, Your Honor. I believe he just picked up that case on August 28th,
Did.
so it's been about 2 weeks.
I'm going to revoke that bond under 2022 MM 5865AO, set bond at none. Obviously, nothing would preclude him from, a motion being filed.
And you did appoint us in that case.
I did. I'm going to appoint you in both of them.
He doesn't have the PD
Yeah, I'm going to appoint, since he's going to be on a no bond on that other charge. Okay, we then, your name, this person, individual, I'm sorry.
My name is Andrea Legree.
Okay, Where is Jasmine Garcia Lopez?
Bonded.
Okay, thank you. And you are Miss Legree, correct?
Yes, correct.
All right, Miss Legree, you are here on a new charge of driving under the influence of alcohol, and that is in case number CT 2022 5164AO. I've reviewed that charge and affidavit. I do find probable cause. Did she qualify?
I said 8181.
Ma'am, that's a separate case. Let me get the public defender's office appointed, okay? So as to the DUI, the court does find probable cause, and I've appointed the public defender's office to represent you.
No need, Your Honor, for that.
No need?
No, Your Honor.
Okay.
I didn't know what, I didn't, under the circumstances and waiting in the booking, when I was addressed about this, I was completely tired at that time, and I wasn't in a position to make financial decisions upon this case.
So you do not want the public defender?
No, I was able to reach my, but the reason for the hold of about the,
Okay,
this bar is for pretrial.
I know what I'm not trying to cut you off or be rude. I just don't want you to say anything that might be used against you. So you're going to get your own attorney on the DUI case also, correct? Are you going to hire your own attorney on the DUI, or do you want the PD of Public Defender's Office appointed on the DUI case?
Oh, okay, now I understand. No PD.
No PD. Okay, that solves that. All right. As to the charge she's out on bond on, does the state have a position on that? Looks like it was from January 21. And it looked like it was a pretrial diversion, so.
Was it pretrial diversion?
Is this
However,
one a pretrial diversion?
I believe it got kicked out. It was rejected in early August. So she's no longer in PTD, so state would ask that you revoke. If you're not inclined to revoke, we would ask that you at least revoke and double.
Has she had anything else in the last 2 years under that when she bonded out? You don't show anything else other than?
No, the last thing I see is just her not showing up for contract signing for PTD.
Okay, for the contract signing, and that's what got her out of the pretrial diversion. So
Yes, Your Honor.
Wasn't a new charge, she just didn't, I don't mean just, but didn't show up.
Yes, Your Honor.
So I'm not going to take any action under the 2021 case. Court will take, or rather, it's a 2020 case. I keep saying 2021. I'll take no action under 2020 CF 14927AO. As to the DUI, though, I will raise that bond to $1,250, and you are not to consume any, I think this was one, let me just check one thing. I just don't want you to say anything. Don't, just a moment.
There was a blow, Your Honor.
Yeah, and then there was a request for urine. Okay. You're not to consume any illegal drugs, okay? All right. All right, so you're able to post your bond on it. I didn't take action on the other one. Make sure you keep your dates for your other case, okay?
Okay, so with that being said, Your Honor, so did you still have to make the decision to raise the?
Yes, because you had you were out on a, yes, ma'am, I did. Okay?
Okay.
All right, thank you.
Okay, so who's giving me paperwork for that?
You'll get it when you go, the corrections will get that paperwork to you. Right, you now can post the bond.
500.
Right.
Are you raised to 1,000 now? Okay, thank you.
1,250. Right. 1,250. Okay. You're welcome. You too. All right, your name, please?
Jose Moreno.
Mr. Marino, sir, you're here in case number 2022 CT 5165AO. And at this time, sir, this is a charge of not having a valid license. And you have another failure to appear. I guess you had another operating a motor vehicle without a valid license. You qualify for the public defender. I'll go ahead and appoint them to represent you on the cases. And
Your Honor, state didn't convey an offer. I believe he has a total of 5 open no valids, including this new one. So state did not convey an offer at this time.
Okay.
I was gonna get my driver's license this week. I just find out that, 'cause I just don't.
Yeah, I wouldn't say anything because you might say something that might be used against you, like, just, I don't want you to say anything. And your attorney's right here, so she'll advise you too. So she's, got some open cases and,
What county are they in? I'll give you case numbers. 20 CT.
It's not in orange, right?
There are several in orange. There's the 3039 in orange, 20 CT 3039. There's a 20 CT 4597 out of orange. There's a Seminole
I don't see any attorneys on.
22 CT 1740 out of Seminole.
Are these not-
Another Seminole, and then another orange.
okay.
Yes, Your Honor. Your Honor, I would ask that, I don't see any attorneys appointed. We do have a program that assists in helping, can assist in helping him get his driver's license. I don't see an attorney on any of the cases. I don't know why. But I would just ask that we be appointed. If you, are inclined to revoke the out on bond, I would ask that you, revoke and double. I don't see any other history other than the no valids. He was attempting to get his driver's license on his own. However, we'll be able to assist in making sure he obtained that. So I would just ask that you give him a chance to obtain his driver's license. If we hold him here at no bond, he's not gonna be able to do that. He's just gonna sit here.
Any position on behalf of the state?
No, Your Honor. Okay. Only within your discretion.
At this time, what I will do is on the new charge, I'm going to keep that bond at $500. You're not to drive without a valid license. Do you understand that?
Yeah.
And on the charge that he's out on bond on, I will revoke that and set that at $500 also. Once again, you are not to drive without a valid license. I've appointed the Public Defender's Office to represent you on those 2 cases. Is that satisfactory to the state and advising not to drive without a valid license? Traffic today. Okay. Your name, please?
Carlos Venegas.
Mr. Venegas, sir, you're here on the following charge, sir. You're here on a charge of driving while license suspended in case number 2022 CT 1229AE. I've reviewed the charge and affidavit. I find probable cause. You are out on bond for a Dwillis. I guess it's a status date on that you've got set.
And Your Honor, as for the new law case, the offer from the state was an adjudication credit time served. Mr. Venegas would like to resolve that case. He has us on the out on bond. We are working on helping him get his driver's license.
It will HTO him.
Will HTO him, then
He has this one. He has another 22 from June. He has a 21 Dwillis from December of 21. He has a 2021 from April, also in orange. So there's at least 4, 5, 6 within the past 4 years, 2 years. I don't think it.
That's what I'm saying.
I don't think it automatically, but he's.
Interpreters? Yeah. Then maybe after this one, oh, never mind.
No, through a bail bondsman. Your Honor, there was an offer to resolve the new law with an adjudication credit time served. He is actually our client. We've been working with him to get his license. He is paying, may we approach?
Sure. Any objection going off the record?
Your Honor, so we're going to ask that you set a $1,000 bond on the new law, increasing it from 500 and taking no action on the out-on bond. He's currently working to get his driver's license. He has fees to pay. And so if he's incarcerated, he will not be able to pay those fees being here. So I just ask that you double the bond on count one and take no action on the out-on bond.
The state's position?
Your Honor, state has no objection to that, with the understanding that if Mr. Venegas is potentially caught driving again, he'll likely be held no bond, or his out of bonds be revoked and he'll be sitting here no bond.
Mr. Venegas, sir, do you understand that the attorneys have worked together for this resolution on your behalf? But you drive again without a valid license, you know, you're going to ruin any opportunity you do have to try to get your license. And in addition to that, you're going to be sitting in jail on a no bond. Do you understand, sir? Okay, sir. At this time, without objection from the state, I won't revoke the bond or take any action on the out-on bond. So that case will remain the same. That's the 2021 CT 1325AE. And as to the new charge, I will, on that case, I will set that bond, I will increase it, double it to $1,000. You are not to drive without a valid driver's license. Do you understand that, sir?
Yes, ma'am.
Not only now is it, you know, driver's license, you know, from the DMV, you can't drive. It is now a court order. You cannot drive without a valid license, okay? So you've got the public defender appointed on both of the cases. It sounds like everybody's working toward the right resolution of you getting a license. But sir, you get a charge and it just backtracks, you know, a number of steps back, okay?
Okay. All right. Thank you.
Hunter Pierre Brinson is mental health.
All right.
And I will waive, Your Honor.
All right. Court does find probable cause. I'll appoint the public defender's office. Bond will be set at $3,500, okay?
Your Honor, state would ask for a no contact, no return.
No contact and no return to the scene. Okay, your name, please?
Calhoun.
You're here on a charge of possession of methamphetamine. This is in case number 2022 CF 10603AO. You are also out on bond for another.
No, I'm not.
She's not out on bond on that, is she?
No.
She's on
Pretrial
pretrial diversion.
diversion.
Okay, that's true. At this time, as to the new charge, I will appoint the public defender's office to represent you. The bond will be set at $1,000. You are not to possess or consume any illegal substance. Do you understand that?
Yes, ma'am.
And as to the other case, she's in a diversion program, correct? That'll, I'm sure, be potentially
I saw
sent back.
that was
Closed?
conveyed, and then there were issues with contact.
Okay.
So I don't know what happened with it after that.
Make sure you keep all your court dates, because you do have that other case too, okay, that it may be coming back. I mean, I know it'll be coming back. Does she have the public defender's office on that case?
She does.
She does, okay. Stay in contact with your attorney, because you got two cases. Could be in different courtrooms, I don't know, but I'm just saying, stay in contact with your attorney, okay?
So that was no action, Your Honor?
Well, she's not out on a bond. It's a diversion, is my understanding.
Well, she was released ROR and then on PTD.
Still considered.
It's still
Still
considered.
revocable, however, state would ask that you don't.
No action. And in fact, but what I do want to do, Ms. Calhoun, I needed to address the first charge. I'm sorry. When I said the bond remained at 1,000, I had put that as 2,000. So I am going to increase that to 2,000 on the new charge. And once again, you're not to consume or possess any illegal drugs, okay? But I won't take action on the ROR case. State's not requesting it, and you were in the diversion program or pending a diversion contract. I'm not sure where that will end up going. All right? But you got the PD on both of them. Sure, whatever they want to do. Are you all ready for Spanish? Or are they out of order? Are we gonna?
We're ready.
Okay. You want me to do this one first, or you want me to?
Oh, sorry, Your Honor, this is, he was already seen.
Okay.
I just needed to relay a message.
Okay, no problem. Okay, are we gonna try to do the interpreter then? Okay?
Good afternoon, Your Honor. This is Laura Arroyo, State Certified Interpreter and previously sworn.
Thank you. This is Judge Clark. How are you doing?
How are you, Judge? It's been a while.
I know it has. I wish I could see you all, but I know, but I can hear you, so that's great too. All right, we have just a few, I think, from this afternoon, so we'll go ahead and have the first individual state their name, please, for the record.
Yo soy José Yatius.
Sorry, I'm just going to ask the deputy to help him move closer to that mic or push the mic to his face.
José Yatiul.
Jose Yatul.
No.
Mr. Yatul, sir, you're here in case number 2022 MM539AW. The charge is resisting officer without violence. I will appoint the public defender's office to represent you on the case.
Sí.
And so the public defender's office has been appointed. And at this time, is there anything further from the state or the defense? I don't know if there was an offer.
There wasn't.
There wasn't. Okay. At this time, sir, the bond will remain at $500. You understand, sir, the following though.
$5.
You under-
¿Y eso cliente cuándo lo entrego?
Where do I go to give those 500?
You'll have to speak with a bondsman about that.
And Your Honor, state would ask for no return to
Sí.
the scene.
Right, thank you. Okay, I'm going to also order you, and I need to make sure you understand this, sir. You are not to return to the scene of where this occurred. Do you understand that?
Ajá, cierto, gracias.
Yes, correct. Thank you.
You understand if you go back or violate any of this court's order, the bond will be revoked and set at 0. Do you understand?
Ajá.
Your Honor, may the interpreter just have a second to confirm language pairs?
Sure.
Sí, yo tengo otro dialecto. Kekchi. Kekchi. Ajá.
Your Honor, he speaks an indigenous language called Kekchi.
Okay. Is he able to understand?
I will confirm. I was getting the impression maybe not, but let me try again.
Okay, thank you.
No, yo entiendo, yo entiendo. Sí, sí, unos 30, por ahí.
I asked him if he was understanding me. He said yes. Then I followed it up by asking him percentage-wise, how much are you understanding? And he said 30.
Okay. What's important is that he understands what I'm gonna say. So I'm gonna ask anything I order, if he's understanding.
Sí.
Yes.
All right. You are not to go back to where this occurred. Do you understand that?
Sí.
Yes.
Do you understand that you have the public defender's office appointed as your attorney?
Sí.
Yes.
Okay. I'm going to set bond in the amount of $500, and you have the public defender's office appointed, the attorney's office appointed. Stay in contact with them and keep all your court dates, okay?
Sí.
Yes.
Okay. All right. Thank you.
Okay, gracias.
And I'll note for the record, he just shook his head also.
Your Honor, for the record, just in case the public defender needs the language, it's QEQCHI. And we do have interpreters for that language pair.
I'm sorry, Madam Interpreter, could you spell it
Yeah,
one
could
more
you spell it one
time?
more time? Because the clerks
Yes.
need to write it on their order too. Can you?
No problem.
Get that
Yes.
paperwork out? All right, perfect.
Yes. It's QEQCHI. It's a Mayan dialect, and the interpreters we have would be available remotely only. They are not here in Orlando.
Okay. So we know this, I want to make it clear for the paperwork that he understood the initial appearances, but his dialect, preferred dialect is that, as you just stated. I just want it very clear because I ordered very concise order, and so we're going to put on our order that defendant understood the court utilizing Spanish interpreter, but the dialect and preferred is the QUI, what you just stated, okay? All right, thank you. I just want that very clear on the order. Thank you. All right, you can come on up. Yeah, I found it. Your name, please?
Geraldo Ríos Pérez. Geraldo Ríos Pérez.
Geraldo Rio Perez.
Mr. Perez, sir, you are here on case number 2021 CT 5702AO. This is a failure to appear, sir, on a status hearing. That bond has been set in the amount of $1,000. I will appoint the public defender's office to represent you. Oh, they're already, okay. They're already appointed. So you will keep those attorneys, okay? Thank you. This is the pleables. I mean, I think this is the arraignment. Your name, sir?
Trinidad Leiva Cuagua. Trinidad Leiva Cuagua.
Trinidad Leiva Cuagua.
You're here, sir, in case number 2022MM 319AA. Charge is trespass on property other than a structure or conveyance, criminal mischief, and trespass on property other than a structure or conveyance.
And, Your Honor, we will enter a plea of not guilty.
Plea of not guilty will be entered. We'll set the matter for pre-trial. We'll put on the order that you do need a Spanish interpreter. I don't know who's on all those. The date, okay? thank you. All right, and I believe that's all the interpreter cases we had. Thank you so much.
You're welcome, Your Honor. It was nice seeing you again.
Yeah, you too. Have a great one.
Bye-bye.
All right. You wanna come on? All right, now I believe all we have left is the felonies, correct, everybody? All right. Your name, please?
Gregory DeRisti.
Mr. DeRisti, sir, you're here on a charge, sir, as follows. It's in case number 2022 CF 10620AO. Possession of cocaine with intent to sell or deliver, possession of cannabis less than 20, possession of methamphetamine, count 4, Xanax, and count 5, controlled substance. I will appoint the Public Defender's Office to represent you at this time, sir, on the case. And at this time, sir, the bonds will remain the same, $15,000, $150, $150, $150, and $150. You do have the public defender appointed, sir, and I will add as an additional condition, sir, you're not to possess or consume any illegal substances, okay? And I'm showing it's a Division 20 case. Your name, please?
Anthony Davis.
Sir, at this time, you are here on, Mr. Davis, on the charge of failure to appear. This is in case number 2021 CF 1228AO. This, an information has been filed, I'm showing. And, let's see, oh wait, is there two cases? Yes, I'm showing on the, there's two cases. On the one was failure to appear, and that bond has been set at none, sir. I'll appoint the Public Defender's Office to represent you. And there's a trafficking also case, and that's in 2022, or 2021 rather, CF 3377AO. That bond has been set at $50,000. I will require you, sir, though, not to possess or consume any illegal substances, but you do have the public defender appointed on both of the cases, okay? All right, thank you, sir. Your name, please?
Gordon.
Mr. Gordon, sir, you're here on a charge, sir. The new charge, sir, is 2022 CF 10610AO. I've reviewed the charge and affidavit, sir. I do find probable cause. You're not to possess or consume any illegal substances. The bond is set at $1,000 under count 1, $1,000 under count 2. And you do have the Public Defender's Office appointed. I show he is out on bond on another case.
I have it as closed, do you?
You have it as closed?
Weird. Okay, so I have, he was arrested December of last year, but no information has been filed. But then I saw correspondence.
Yeah.
I don't know.
So
I think it was a reassigned to a division.
I don't know what happened.
Maybe when they were closing a division down. I don't know. I'm just,
That was put in June.
I think just nothing occurred.
The correspondence is a transfer to circuit court.
That was all that.
Oh, it's a transfer to circuit court or a transfer from one court to another circuit to circuit, different divisions?
Notice of transfer of case to circuit criminal 22.
But read the order. Was it?
The blank.
From Division 19 are canceled.
It's 2021 CF 15452AO. That's 52?
I'm not sure. I see.
So what do you all show? I'm sorry, I can't.
I just show under that case number that he was arrested December 5th of 2021, but nothing has been filed. It looks like nothing has been done. I don't know.
In my system, which I don't know if it's correct since the clerk's is not lining up, it appears a no information was filed on April 6th of 2022, which was before that correspondence transferring it.
Okay.
So I do not know. Say we just ask for no action and they can work that out.
And then maybe you all can follow up to get that uploaded, you know.
I don't know.
So I won't take any action on that, okay? Looks like it was wrong. But sir, you understand the court's order. I mean, you understand, sir, and stay in contact with your attorney. So no action requested by state, okay?
Did she stay the bond, said that was a no?
All right, Graves. All right, Mr. Graves, sir, you're here on charge of possession of methamphetamine, sir. I'm showing that you qualify for the Public Defender's Office. I show you're out on ROR on 2 cases of the same charge. At this time, sir, I will appoint the Public Defender's Office on 2022 CF 7221AO and 2022 CF 5970AO. Were those 33-day motions, or were they just, what were they?
Your Honor, however, in 2022 CF 5970AO, state did file. However, in 2022 CF 7221AO, the state has not made a filing decision.
But were they 33-day motions, both of them?
Yes.
So there's nothing to,
So he's out on ROR, so I mean, you could revoke, or you could revoke and set a bond. Because state, as defense already stated, state has filed on the 5970.
on the 5970
Mhm.
AO. All right. But no, has not made a charging decision on the other one, right?
Not on the 7221, no.
I'll take no action on the 7221 AO since state has not filed an information. No action. There's been no action, on that by the state, so. Sorry, I know. You're doing what I'm doing, aren't you? You got too many little pieces of paper up here. Does he have a date on the 5970 yet? Oh, return date is 9/29, right? They've written something on the documents up here.
Yeah, he has arraignment on 5/20 or 9/29.
One other matter up. At this time, sir, as to the charge that you were ROR'd on, sir, the state has filed an information, sir, it's for the same charge. I am going to revoke that ROR and set it at none. I am going to raise your bond on the new case, sir, to $2,000, and once again, no illegal drugs possessed or consumed. Okay? All right, thanks. Your name, please? You want to come on up?
Is mental health.
Mental health, okay.
And I will waive, Your Honor.
This time as to 2022 CF 10601AO. There is a waiver. Bond will remain the same at $2,500 under count 1. Court does find probable cause, battery on a law enforcement officer, 2 counts, and trespass. $2,500 under count 1, $2,500 under count 2, and $500 under count 3, and no return to the scene. Your name, please?
East Henderson,
Mr. Henderson, sir, you're here on a charge, and your date of birth?
05/29/1992.
You're here, sir, on a charge of third-degree murder with a firearm and possession of a concealed weapon firearm by a convicted felon. A warrant has been signed on that, finding probable cause. You are also out on bond on the following case number 2021 CF 883AO. At this time, sir, I will appoint the Public Defender's Office to represent you on both of the cases.
You have.
Your Honor, he is entitled to a bond. It is only an F1, not a PBL or life.
Correct.
So state would ask that you set a bond on count 1 and 2. However, state would request that you revoke his out on bond. as I believe that also came in with a possession of a firearm by a convicted felon, and they are substantially related. So they would ask that you revoke his out on bond. Is that reasonable bonds on 1 and 2?
At this time, sir, as to the felony third-degree murder with a firearm, sir, I'm going to set your bond at $25,000. On count 2, the possession of a firearm by a convicted felon, sir, I'm going to set your bond at $5,000. Public Defender's Office is appointed to represent you, and once again, that is in case number 2022 CF 10621AO. As to the charge that you are out on bond on, I will revoke that bond, sir, at this time and set bond at none, and that is 2021 CF 883AO, and I have appointed the Public Defender's Office to represent you on that case also.
Thank you.
Thank you, sir. I do. Okay.
No, it's attempt.
Okay. I will waive the appearance, Your Honor.
It's an attempt. They've changed the bond. I've got a inmate bond correction form to 0. I've just got a white piece of paper on top. Do you all show that?
We don't get them.
I don't.
They wouldn't
Yeah, we don't
have
ever get them.
I'm sorry?
They wouldn't have that form.
They don't, okay,
Yeah,
they
we don't
wouldn't
get
know that it's been, it's set at 0. This is in 2022 CF 10606AO, and at this time, title to a bond, do we all agree?
Yes.
Yeah, Shauna, due to it being an attempt, it knocks it down from the PVL.
One other matter. All right, and at this time, I'll set bond in the amount of $3,500. No contact with the victim, no weapons or firearms. Is there anything else requested on behalf of the state?
Your Honor, state would ask for a no return to the subway at 8098 South Orange Blossom Trail.
Also require him not to return to the scene of the offense. Was there anything further requested from the defense? I did appoint your office.
No, Your Honor.
Okay. All right. Your name, please?
Alexander Ignatov.
You're here on a charge as follows. It's possession of cannabis greater than 20 grams, possession of a cannabis with intent to sell or deliver, and possession of drug paraphernalia. There's also a violation of probation for out of county from a Seminole County case that you are on probation for. You do qualify for the public defender, so I'll appoint them to represent you. And at this time, bond will be set at none on the violation of probation from Seminole County. They'll be notified, and that information will be relayed to them. I do find probable cause. As to count 1, bond will remain the same at $1,150 under count 2 and 100 under count 3 for the paraphernalia, and you're not to possess or consume any illegal drugs, okay? So what will happen is if you post this bond, they'll come pick you up and take you to Seminole County.
Seminole? Go to court there for the,
They won't take you until the bond is posted here, is my understanding.
so I have to pay for the bond here to get moved to Seminole?
Yes.
That's my understanding. I mean, I think, is that correct?
Yes, that's correct.
Okay,
DeAndre Jackson review.
okay.
I will waive, Your Honor.
Yeah, all right, let's go ahead and go through all of Mr. Jackson's cases. And at this time, he's got a number of out on bonds, I believe. Quite a few. All right, so let's go ahead. We've got the new charge of 2022 CF 10599AO. And at this time, the court has reviewed the charge and affidavit. I do find probable cause. I'll set bond at 10,000 under count 1, 150 under count 2, 150 under count 3, and 100 under count 4. Public Defender's Office is appointed. He's not to possess or consume any illegal substances. He is out on bond on the following cases: 2022 CF 6020AO.
State has filed and would ask that you revoke on that one.
I will revoke the bond. Public Defender's Office is appointed, set bond at none. We then have 2022 CF 4434AO. And that,
State has also filed on that one, so would ask that you revoke that
I'll
one.
revoke the bond, set bond at none on that case. He also has 2022 CF 6021AO.
6021. 6021, I thought we did,
Oh, is there two of them?
You said 6020, the first one.
Yeah.
oh,
20.
6020 we have not filed on.
Okay.
6021 we have.
Okay, I'm still fine with revoking that 20. So that will remain the same. The one that is now 6021, you're saying you have filed on.
We have filed.
I will revoke that bond. Bond will be set at none. He then has another case of 2022 CF 7812AO. And that was, similar charges.
7812, we have not yet filed.
I still will revoke that bond, similar charges. In fact, possession of cocaine with intent to distribute and possession of methamphetamine with intent. He then has another case, 2022 CF 5161AO.
And we have filed on that.
I'm sorry?
We have.
You have filed. I don't have a bond amount on that one. Is he ROR'd? I think he was ROR'd.
It came in possession of cocaine with a weapon, firearm by convicted felon, grand theft, motor vehicle, and resisting without. We ended up filing on the firearm by convicted felon, the F2. And I believe it was an ROR motion that was granted, and then we filed a few days later.
Okay. I will revoke that ROR and set bond at none. He's got no bond, so he might as well be getting credit for time served on.
Your Honor, he also has a traffic case.
Okay. He also has a traffic ticket. Thank you. And that is 2022 CT 5166AO. That is a charge of driving while license suspended. At this time, I do find probable cause and set that bond at, that'll remain the same at $500. And public defender is also appointed on that one.
Thank you.
Yeah, everybody. I mean, on everything, rather. Not everybody, but all the cases. Okay. Your name, please?
Devin Jackson.
Okay. Saw the Jackson, and I didn't think it was the Jackson I just handled. Right. All right. At this time, you are here on the following charges, Mr. Jackson. This is in case number 2021 CF 1111AO. And this was a failure to appear, and that court set bond at none. You do have the public defender's office appointed. Bless you. You do have the public defender's office appointed. Okay? Thank you.
Yeah, man. I tell you why I didn't come.
Your attorney, the judge that issued it's going to have to hear it. I gotta clean some stuff up. I feel like it's.
They have to file a motion. To file a motion, so.
We don't.
That's the number. I already left the number. Okay.
Masonette Bonded, okay. McGee. Your name, please?
Lakeithan McGee.
At this time, Mr. McGee, sir, you're here in case number 2021 CF 9107AO. This was a failure to appear for a case management conference. The court that issued that warrant set bond at none, and I will appoint the public defender's office to represent you on the matter, and they can file any appropriate motions, okay?
I don't even know, can I say something?
No.
probably don't, because anything you say could be used against you. Your attorney's there and can answer, I mean. Okay, and it's Division 14, so they'll know to get in contact with that division, okay? You want to come on up?
Nicholas Middleton is mental health.
Okay.
I will waive, Your Honor.
All right. Public Defender's Office is appointed, probable cause, bond will remain at $1,000.
State would ask for no contact with the victim.
And no contact, thank you. Your name, do you want to come on up? Your name? Ms. Plant, you're here on a charge of aggravated assault with a deadly weapon and battery. At this time, I've reviewed the charge and affidavit. I do find probable cause. You do qualify for the Public Defender's Office. I will appoint them to represent you. At this time, you're to have no contact with the victim. Do you understand that? And you're not to possess any weapons or firearms. And at this time, the bond will remain at $2,500 under count 1 and $500 under count 2. You do have the Public Defender's Office to represent you on the case. It is assigned to Division 10. Okay. Thank you.
Alyssa Sawyer refused.
And I will waive, Your Honor.
All right. It's failure to appear, case number 2022 CF 3657AO. Bond will remain the same, or bond will remain the same as set at 0. We have, your name, please?
Jeremy Sherritt.
Mr. Sherritt, sir, you're here on a charge, sir, of trafficking in amphetamines, possession of cocaine, possession of cannabis, and possession of drug paraphernalia. You do qualify for the public defender, so I've appointed the Public Defender's Office to represent you. At this time, bond will remain the same at $50,000 under count 1, $1,000 under count 2, $500 under count 3, and $500 under count 4. If you are able to post your bond, sir, you are not to possess or consume any illegal substances. Do you understand that?
Yes, ma'am.
It's not for you. Just for the record, in Sawyer, the one we waived, it's not for you. You're fine.
Sorry.
She has RCC, I believe, so I just asked that we not be appointed. I just realized. We had
She
to,
already had them appointed?
Mhm.
Okay, so on Elisa Sawyer, 2022 CF 3657AO, that's this one. They had it, thank you, thank you. Thank you, because we got it, so, that's okay. I mean, just, your name, please?
David Arthur Smith, ma'am.
Mr. Smith, sir, you're here, sir, on a charge as follows, sir. It's a charge of driving while license suspended, revoked, and this is in case number 2022 CF 10613AO. I will appoint the Public Defender's Office to represent you, and at this time, and you have a new charge that you've got a bond on. I mean, I say new, you're out on bond on a charge. And your return date is very soon, in fact, Wednesday, I think. And does the state wish for the court to take any action? I don't think he's got,
I believe the state only filed the possession of Utilone.
Yes, Your Honor, state only filed the possession of Utilone. However, state would ask that you revoke. It's alleged in that case that it was dealing in stolen property, however, we did not file it. And in this case, the vehicle that Mr. Smith was allegedly driving did come back stolen. So state would ask that you revoke his out on bond and set bond on his new law.
and I'm sorry, what was the reason for the, I mean, I just didn't hear you. That's okay. I mean, it's not that it didn't make sense. It just, could you said he was the case that was charged.
His out on bond, it originally came in dealing in stolen property, MDMA, and resisting without, and we only filed the possession of Utilone. And this new law offense, the officer only arrested the driving with a suspended license. However, it's alleged that the vehicle that he was driving did come back stolen. So there is a small tie between the out on bond and the new law. So state is requesting that you revoke the out on bond.
Your Honor, I'm asking that you take no action, given that the state only moved forward on the possession of Utalone. If charges are brought up for the theft of a motor vehicle at that time, his out on bond can be revoked, but being that the officer did not charge him with grand theft of a motor vehicle and the state did not charge him with dealing in stolen property, I would ask that you take no action on the out on bond, and if you are inclined to revoke, you revoke in double, being that they never filed on the stolen property.
Let me just check one other matter. I want to just look at,
There's also 7 failures to appear and a pretty lengthy criminal history.
at this time, Mr. Smith, sir, I am going to revoke the bond under the possession of methamphetamine. Well, no, that's not on
Utalone.
the charge, sorry. On the charge that was charged, I am going to set that bond, sir, in the amount of $4,000 at this time, and your bond remains the same at $5,000 under the driving while license suspended, okay?
You're gonna have to follow up. You have bonds on both.
I think that's sufficient for the court to feel satisfied on the failure to appears as the state brought out.
She revoked and set a new bond. She could have revoked and held you at no bond, but that's what she did. That's why you have the 4,000.
And I'm not sure if you heard, I just addressed the state. I think that can address the failure to appears.
Yes, Your Honor.
And for the bond to be, that bond to have been considered that amount. You want to come on up? Your name?
Kendrick Navarro bonded.
Okay. And is this Mr. Wilson then? All right. Mr. Wilson, sir, you're here on a charge of driving while license suspended with knowledge, sir?
No.
Is that what, okay?
No.
No, not you? What is your first name?
It's one.
Yes, you are.
Okay, well, that's what I'm showing. What's your date of birth?
6380.
Okay, that's what the officer wrote. It's a, oh, you've got another one too.
It's 2
There's
cases.
2 charges, okay. Possession of cocaine within 1,000 feet of a convenience store or business, possession of cocaine, and possession of drug paraphernalia. All right, sir. At this time, I will appoint the public defender's office. So they did charge you with the other charges, so you'll know on that. At this time, sir, I do find probable cause. And at this time, sir, bond will remain the same, $10,000 under count 1, $150 under count 2, and $100 under count 3. And as to the driving while license suspended, $500. On the drug case, sir, you're not to possess or consume any illegal substance, okay? And you've got the public defender's office appointed on both of the cases to represent you.
Your Honor, just a moment.
Okay?
I don't know if I missed something, but I didn't see anything. Oh, I see. Never mind. I saw that. I missed that part.
You okay?
Yes, Your Honor.
Okay,
Sorry.
all right.
And then just one question, Your Honor. What was the bond on the driving while license suspended?
It was 500.
Thank you.
You're welcome.
Yeah.
I believe that concludes our afternoon session. Was there anything further on behalf of the defense?
Nothing from the state.
Okay, anything further from the state?
No.
Okay, everybody. All right, thank you all. Have a great afternoon. Well, we don't even know if she's there. She was here. You can go over.
Can you,
Okay.
can you hear me now?
Yes, we can.
You cut off, I was hearing you and then you cut off.
Okay, well, we're good now. So thank you for being on the speaker so everybody can hear.
Okay.
We're going to go ahead and have the victim sworn in. And so if
Okay.
you raise your right hand to get sworn in, please. Victim.
Yes. Est-ce qu'on est capable de lever mes doigts doux pour capable prêter serment?
Do you swear affirm the testimony you're about to give today is going to be the truth, the whole truth?
Yes. We're not hearing the interpreter. Yes.
Est-ce que vous sermentez que témoignage la baille la vérité, toute la vérité, rien que la vérité?
Tout c'est la vérité.
The whole thing is the truth.
Okay, and you'll need to the interpreter, if you'll please stay on the speaker since we have, the defendant needs the interpreter and so does the victim, okay? And
Okay.
your name, please, sir?
Monsieur qui j'en relais?
La Pomeroy.
Carl Lapomeray.
All right, so you're hearing case number 2022 MM 538AW. You qualify
Monsieur
for-
Ouissia pour K22 MM 538 AW.
You qualify for the public defender, so I will appoint the public defender's office to represent you.
Ou qualifié pour défenseur public, donc ma bon défenseur public qui pour représenter.
I have reviewed the sworn charge and affidavit. I do find probable cause. I will appoint the public defender's office to represent you.
Moi réviser attestation, moi joindre que gain assez cause probable pour accepter li, ma bon défenseur public pour représenter.
And at this time, does the state wish to inquire?
Est-ce que l'État voulait poser question, Kounia?
Yes, Your Honor.
Oui, juge.
Good morning, ma'am. Can you please state your name for the record?
Madame qui j'en relais, s'il vous plaît?
Moi, c'est Chantal Michel.
My name is Chantal Michel,
And what is your relationship to the defendant?
qui est souillé pour accuser.
C'est Marim.
He's my husband.
Are you afraid of him?
Est-ce que vous peur li?
On a un moment, oui.
At this moment, yes.
Has anything like this ever happened before?
Est-ce que bagage arrivé jamais déjà?
Ça fait déjà.
It happened before.
Approximately how long ago would you say the last time was?
Combien de temps comme ça qui passait depuis dernière fois ça t'est fait?
Ça fait 3-4 mois passés.
Combien, pardon?
Ça fait 3-4 mois passés.
It's been 3-4 months ago.
And do you want to have contact with him while this case is pending?
Est-ce que vous voulez gagner contact avec monsieur pendant que cas ça en suspens?
Non.
Non.
That's all I have, Your Honor.
All right.
OK. Il n'y a pas d'autres questions.
Thank you, ma'am.
Merci, madame.
At this time, sir, I'm going to require you to have no contact with the victim. Do you understand that, sir?
Monsieur Kounia m'a dit que ou pas capable de gagner aucun contact avec victime là. Est-ce que vous comprenez ça veut dire?
Oui, Your Honor.
Yes, Your Honor.
And do you understand that's directly, indirectly, through a friend?
Et vous comprenez que contact là, c'est directement, indirectement, à travers les amis?
Oui, Your Honor.
Yes, Your Honor.
And that means no phone calls, no texting, no, you understand, no contact flat out means no contact.
Ça veut dire que vous pas capable de relever dans le téléphone, ou pas capable de envoyer texte par lui, ou comprendre que nos contacts veut dire no contact, point barre.
Oui.
Yes.
All right. At this time, and you've got the no contact order in front of you, is. Oh, my goodness. To the interpreter, did I hang up on you? Yep. We did.
Hello. What happened?
Me, I'm trying to get all these computers that they give us connected, and I disconnected you, unfortunately. We're still trying to get computers connected. But you understand, sir, the no contact order, and you signed that, is that correct?
Vous comprenez l'ordre de nos contacts là, monsieur, et vous signez li, pas vrai?
Oui.
Yes.
All right. Is there anything further from the state? I'm going to require
que
no
l'État-
contact, no weapon. I'm going to do standard orders, but is there anything further from the state?
No, Your Honor.
M'a fait un lot standard, mais est-ce que gagne l'autre bagaille de l'État? L'État dit non.
Nothing other than standard conditions, Your Honor, with separate residences.
Okay. At this time, sir, I'm going to require you to have no contact with the victim directly or indirectly. Maintain a separate residence.
M'a demandé monsieur pour ou pas gagner aucun contact du tout avec victime là, rester dans une caille différente de lui-même.
Oui.
Yes.
do not return to the scene of where this occurred, and you're not to possess any weapons or firearms. Do you understand that, sir?
Ou pas capable retourner côté bagarre la t'est arrivé et ou pas capable gagner aucun arme ou bien aucun arme à feu. Est-ce que vous comprenez ça, monsieur?
Oui.
Yes.
At this time, sir, I will set your bond in the amount of $1,000 with those as the conditions of your release, sir. You need to
M'a mettez
understand.
bon, monsieur, pour $1,000 kounya avec condition ça yo.
And you need to understand, sir, that if you violate any of the conditions of this bond, that bond will be revoked and set at none. Do you understand, sir?
Et ou comprendre, monsieur, que si ou t'a violé n'importe qui est en condition yo peut le révoquer bon là, ok? Et yo peut le remettre à zéro. Vous comprenez?
Oui.
And Your Honor, could he have a one-time return with law enforcement to gather his belongings?
Sir, I will allow you to return one time with law enforcement to pick up your personal belongings.
Monsieur m'a permis de aller une grande fois la caillou avec la police pour capable prendre affaire.
Oui. Merci beaucoup.
Yes, thank you very much.
But you understand, sir, you don't go there and then call law enforcement. You contact law enforcement first.
Mais vous besoin comprendre, monsieur, que vous pas capable aller là et puis relayer la police. Vous besoin relayer la police avant pour être capable escorter.
Oui.
And
Yes.
they will arrange the time and the place and where to meet you, and then you are able to go pick up your personal belongings. So don't
C'est
go
mon-
there.
C'est moun yo capable ranger tout bagay, y a pas ranger qui le y a rencontré ou qui côté y a rencontré pour capable prendre affaire, OK? Ou même ou pas gen droit aller dans kay là et puis relayer la police pour yo vinn joindre.
Okay,
Yes.
thank you.
Thank you very much.
All right, was there anything further from the state or the defense? Was there anything further from the state or the defense?
No, Your Honor.
Okay, thank you. All right, thank you to the Creole interpreter. We'll go ahead and connect with the Spanish interpreter.
All right. Thank you very much. Bye-bye.
Bye-bye. Yes, so we will now call them. Oh, I got this. I can't deal with all this. I'm just gonna, I think this is it. but-
Hello, Cisco Unity Connection Messaging System. From a touch-tone telephone.
Okay. All right, we're gonna try again. Thank you for helping me on that. Okay, let's try this. And then interpreter. Call. It's interpreter.
Good morning, Your Honor. This is Laura Bretaña, certified Spanish interpreter, previously sworn.
All right. This is Judge Clark. Good morning.
Good morning, Your Honor.
All right. We're here in case number 2022 CF 10616 AO. And sir, would you state your name, please?
Pablo Lavoy.
Pablo Lavoy.
Sir, this time you are here on a charge of burglary of a dwelling with an assault or battery therein. Count 2 is criminal mischief. Count 3 is battery, domestic violence, and count 4 is resisting officer without violence. You do qualify for the public defender. I will appoint them to represent you. And, ma'am, do you need a Spanish interpreter?
No, ma'am.
We're gonna have you sworn in. Would you raise your right hand to get sworn in? Do you swear to tell the truth, nothing but the truth, so help you God?
Yes.
And your name, please?
Julie Leon Aponte.
Okay, does the state wish to inquire?
Good morning, ma'am. Can you please state your relationship to Mr. Lavoy Torres?
Ex-boyfriend.
Are you afraid of him?
Yes.
Do you want to have contact with him while this case is pending?
No.
And has anything like this ever happened before?
Yes.
Approximately how long ago would you say the last time was?
Months ago.
Is there anything else you'd like to tell the court?
I just don't want to have no contact at all. It happened in May, and then he got Baker active. This time he was so aggressive with my neck, trying to kill me in front of my kids. So I'm totally afraid. I don't even want to live in the apartment because he broke in still try to, when he broke in, pull me by my hair and try to choke me. So I'm very afraid. I don't even want to live in the apartment.
Thank you. That's all I have, Your Honor.
Anything further, anything from the defense?
You mentioned, Baker Act, does he suffer from mental health issues?
Alcohol.
Okay, no further questions, Your Honor.
Okay. Thank you, ma'am.
You're welcome.
Anything further from the state?
Yes, Your Honor. Count one is a first-degree felony that's punishable by life. Given the degree of felony and the victim's testimony, so the asset would be held no bond pending an Arthur hearing and reasonable bonds on 2, 3, and 4.
All right. I agree with the state on this time. Count one will be held at no bond. Count two, I'll set bond in the amount of $1,000. Count three in the amount of $2,000, and count four in the amount of $1,000. Sir, you're on a no bond under count one, but you do need to understand this, sir. I'm ordering you to have absolutely no contact with the victim. Do you understand that, sir? That means no phone call, no through a family, friend, anyone to have any contact with her through you. In addition to that, sir, I'm also going to require that you make sure that you fully understand that and you've signed that no contact form. You signed that, and did you understand, sir, what that form contained?
Yes.
All right. And at this time, sir, count one will remain at no bond. All right. Thank you, sir. All right. Thank you, ma'am.
Thank you.
So he'll be held no bond. There'll be another hearing, just possibly set a bond, but you'll be called, and there'll be another hearing downtown at a later time. So for now, he cannot get out.
Okay.
Okay?
Thank you, ladies. Have a great day.
I believe, sir, your name, please? Does he need an interpreter? Okay, but Spanish? Okay, we have the interpreter on. If I could get the individual to announce their name, I just want to make sure I've got everybody in order. He doesn't have a headset on because we need you for both the victim and the defendant.
Señor, por favor, diga cuál es su nombre completo.
Antonio Aaron González Baires.
Antonio Aarón González Baires.
All right, sir, you're here in case number 2022 MM6220AO, and it's a charge of battery, domestic violence, and at this time, you qualify for the public defender. I will appoint the public defender's office to represent you. And ma'am, if you would raise your right hand to get sworn in.
Señor, usted se le acusa de agresión física por violencia doméstica. Usted cumple con los requisitos para que se le designe el abogado de oficio y se le ha designado. Señora, por favor, levante la mano derecha.
Do you swear or affirm the testimony you're about to give today is the truth, the whole truth, nothing but the truth?
Jura y promete que el testimonio que va a prestar será la verdad, solamente la verdad y nada más que la verdad.
Sí.
State your name for the record.
Yes. Diga su nombre completo para que conste en acta, señora.
Iris Noelia Rosa Monroy.
Iris Noelia Rosa Monroy.
Good morning, ma'am. Can you please state your relationship to Mr. Gonzalez?
Señora, por favor, buenos días. Dígame qué relación tiene usted con el señor González.
Era mi pareja y el padre de mi hijo.
He was my partner and he is the father of my son.
Are you afraid of him?
¿Usted le teme?
Sí.
Yes.
Has anything like this ever happened before?
¿Algo como esto había ocurrido anteriormente?
Sí.
Yes.
Approximately how long ago would you say the last time was?
¿Hace aproximadamente cuánto tiempo diría usted que fue la última ocasión?
Él estuvo preso hace como aproximadamente un año.
He was in jail, I would say, a year ago, approximately.
And do you want to have contact with him while this case is pending?
Mientras este caso esté abierto, señora, ¿usted desea tener contacto con él?
No.
No.
No further questions, Your Honor.
No tengo más preguntas, su señoría.
Does the defense have any questions?
No, Your Honor.
¿La defensa tiene alguna pregunta? No, su señoría.
All right, thank you. At At this time, sir, I'm going to require you to have no contact with the victim. Do you understand that, sir?
Señor, en este momento se le prohíbe a usted tener todo tipo de contacto con la víctima. ¿Esto lo ha entendido?
Sí.
Yes.
And have you read the no contact order, sir, and understand that?
Señor, ¿ha leído usted la hoja de prohibición de contacto y la entendió?
Sí.
Yes.
And you understand, sir, no contacts means directly, indirectly, through a friend, through a family member. It means absolutely no contact.
Señor, y entiende usted que la prohibición de contacto es total. No se le prohíbe el contacto directo, el contacto indirecto, el contacto a través de familiares y de amistades. Es una prohibición de contacto absoluta. ¿Esto usted lo ha entendido?
Sí.
Yes.
I'm also going to require you, sir, to maintain a separate residence. You also are not to return to the scene of where this occurred. And in addition to that, sir, I'm going to require you not to possess any weapons or firearms.
Señor, se les prohíbe la convivencia, se le prohíbe a usted regresar a la escena del ilícito y se le prohíbe la tenencia de todo tipo de armas y armas de fuego. Okay.
Does he need a one-time return?
¿Él necesita regresar en una ocasión?
Yes, Your Honor.
Okay.
Sí, su señoría.
I will allow you to return one time with law enforcement to pick up your personal belongings.
Señor, se le permitirá regresar en una ocasión acompañado de las autoridades para recoger sus pertenencias.
Perfecto.
But don't just go there. You have to call law enforcement first, and they'll arrange the time and the place to meet you. And then you go pick up the items with law enforcement.
Pero no se presente allí. Tiene que llamar primero a la policía y coordinar con ellos la hora y el día en que van a ir a recoger las pertenencias y entonces, cuando vaya, tiene que estar acompañado de las autoridades.
Do you understand that, sir?
¿Esto lo ha entendido, señor?
Perfecto.
All right. All right, sir. At this time, once again, you're to have no contact with the victim. You're to maintain a separate residence. You're not to return to the scene of where this occurred, and you're not to possess any weapons or firearms. And at this time, sir, I'll set bond in the amount of $1,000 with those as the conditions of your release. Okay?
Muy bien, entonces para resumir, se le prohíbe todo tipo de contacto con la víctima, se le prohíbe la convivencia con la víctima, se le prohíbe regresar a la escena del ilícito, se le prohíbe la tenencia de todo tipo de armas y armas de fuego y la fianza con las condiciones anteriormente mencionadas es de $1,000.
Una pregunta.
I have a question.
You may want to have your, you may want,
Madam Interpreter, could you please advise the client, if he has a question as far as his release conditions is concerned, he can feel free to ask that question, but if it has to do with the facts of the case or what transpired, I would ask that he wait until he get one-on-one with his attorney in private before he speaks about the facts of the case.
Señor, su abogada le está recomendando lo siguiente. Si la pregunta que usted quiere hacer está relacionada a las condiciones de su puesta en libertad, entonces esa pregunta sí puede hacerla. Pero si la pregunta está relacionada a los hechos del caso o a lo que sucedió, entonces su abogada le está solicitando que no haga esa pregunta aquí y espere hasta que tenga la consulta con su abogado.
thank you, sir.
Okay.
All right. Do we have another interpreter case? Yes. All right. Sir, your name, please?
Over the headphone.
Oh, I'm sorry. Let's see that. Oh, and I did have one.
John
Sorry.
Francis Guillama Dater.
Oh, okay, that's going to be our, got it. That's going to be our.
John Francis Guillama Dater.
Sir, you're here in case number 2021 CF 107BO and case number 2022 CF 10598AO. At this time, sir, the case of 2021 is a violation of probation, sir. That court has set your bond at none. I will appoint the public defender's office to represent you. As to the second case that was under the 2022 case number, I do find probable cause At this time, sir, you are not to have any contact with the victim in the matter under that case number, and also, sir, you're not to return to the scene of where this occurred. Public Defender's Office is appointed under both of the cases. Bond remains at $3,500 and $100 under count 2. Thank you, sir. Put on the order you need, public defenders on both of the cases. And that concludes the Spanish cases.
Thank you, Your Honor.
Thank you. Have a great day.
Thank you, you as well.
Okay.
And I will waive, Your Honor.
You'll waive appearance?
Yes.
Okay. All right, at this time, Mr. Dela Cruz, the court does find probable cause. I don't see any witnesses here on the matter. Let me just get this. And I do find probable cause at this time, and bond will remain the same at $500, okay?
They would just ask for a no return, Your Honor.
And no return to the scene. Okay. Let me just, everybody, sorry, I'm getting a few things in order here that okay. All right, the second case we have is Mr. Timothy Lafferty.
And I will waive, Your Honor.
All right. Understand. All right, on Mr. Lafferty, court does find probable cause. Public Defender's Office is appointed. No return to the scene of where this occurred. Bond remains the same at $500. Okay. Same thing on behalf of the Public Defender's Office?
Yes, Your Honor, I will waive.
Okay, Public Defender's Office is appointed. Once again, probable cause is found. At this time, bond will remain the same at $500 and no return to the scene of where this occurred. Sorry, there's your both of your, I'm slowing you down, aren't I? Okay, we then have Mr. Stouter.
And I will waive, Your Honor.
Okay, on Mr. Stouter, I think these have been said a couple times, haven't they? This will be about the third, yeah.
Yes.
At this time, probable cause is found, and Public Defender's Office is appointed. Bond remains the same at $500. No return to the scene of where this occurred. There's you, and there is this. Okay. You want to come on up, sir? Your name, please?
Rajkumar Saknandan, ma'am.
I'm sorry, what was your last name?
Saknandan, ma'am.
Okay, so you're here on an attempted felony murder and fleeing and attempting to elude and throwing a deadly missile at or to an occupied vehicle. And at this time, probable cause has already been found as to count 1 and count 2, is my understanding. We were only here, and those will remain the same as previously ordered by that court. And as to count 3.
Your Honor, the state was not able to obtain an additional affidavit, so state would just ask the ROR as to count 3.
All right, as to count 3, sir, per state, we'll put on the order, unable to provide additional information as to PC, just so we know, why, and I'll ROR you under count 3, okay?
And Your Honor, to be clear, that's 9 on 1, 4,000 on 2?
Correct, they remain the same. All right, thank you, sir. And PD's appointed on that case. All right, sir, your name, please? What's your name? Okay, Mr., what's your last name?
Johnson.
Mr. Johnson. Okay, Mr. Johnson, sir, you're here on a charge of aggravated battery and aggravated battery and battery. This is in case number 2022 CF 10608AO. Do they scan out here when they do this? Do they? Yeah, I forgot, so, all right. At this time, sir, I will appoint the Public Defender's Office to represent you on the matter. I do not believe there is there's no witnesses here. I don't see anybody here. Let me find the Johnson. Let's get rid of this piece. Is there anything further from the state?
No, Your Honor.
At this time, sir, I'm going to require you not to have any contact with the victim. Do you understand that, sir? And I see you shaking your head, yes, but we're being recorded, and I need to make sure you completely understand that no contact with the victim. Do you understand that, sir?
Yes, Your Honor.
Okay, sir. I'm also going to require you to maintain a separate residence from the victim. In addition to that, you're not to return to the scene of where this occurred, and you're not to possess any weapons or firearms. Do you understand that, sir?
Sure.
Okay. I'm going to have you sign the no contact order.
Yes. Did I send you here? Go to the hotel.
Is your belongings still there?
Yes, ma'am.
Okay.
I'm not she.
It's fine, just in there. That's dealt with later.
She blood up.
It's fine.
The picture can she tear off all my clothes.
Okay. And you sign that, and that's your signature on it. Is that correct, sir?
Yes, Your Honor.
Okay, sir. And at this time, those will be the conditions of your release. At this time, I will set bond in the amount of, let me check one other matter.
And Your Honor, was it hotel that your stuff is at?
Yeah.
Could he have a one-time return with law enforcement to gather his belongings? I believe he left it at the hotel.
Okay. I'll allow you to return, well,
I don't know if he,
they may have a trespass against him.
which is why I said with law enforcement,
Okay.
so he can gather his belongings, usually if he's accompanied with
They'll
law.
allow him, all right. I'll allow you to return one time with law enforcement to pick up your personal belongings. But when you do that, make sure you don't go there and then call law enforcement. You contact law enforcement first. They tell you when and where to meet them to then go and get the items. Don't go out on the property and call them and say, I'm here. The judge said I can pick up my items, my personal belongings. You contact them well in advance. They arrange where and when to meet you to get those items. Do you understand, sir? Okay, sir. At this time, I'm going to set bond in the amount of $1,500 under count 1 and $500 under count 2, with those as the conditions of your release. Okay? Okay. Oh, there's that. All right. Sir, if you want to come on up, your name, please? Mm-hmm. Okay.
And Your Honor, I will waive the appearance, but I did have just a PC challenge on the strangulation charge. I would just argue no PC as to the battery by strangulation. But in the four corners of the arrest affidavit, it does not mention that the victim's breathing was restricted at any point in time. It just says he grabbed and choked. However, she was able to get a broom and knock him off, but it doesn't say she had any problems breathing or that her breathing was restricted, which is a requirement in order to have a battery by strangulation. So I would argue no PC as to that charge.
Okay. State?
State has no argument, Your Honor.
Okay. So do you believe it should be battery, a separate count than of a simple battery then?
Your Honor, state would just ask for ROR on 1 and to set a bond on 2, the BAT DV.
Okay.
I
So
think
you
it
don't
kind of
want
cures
additional
itself as there's
time?
already a BAT DV.
I'm sorry?
I think the situation already kind of cures itself because they also filed a BAT DV.
Right.
So state would just ask for an ROR on 1 and to bond on the following 3.
As to count 1, per state's request, ROR, got it? Okay. As to count 2, I will set bond in the amount of $2,000, count 3, $1,000, and count 4, $500. No contact with the victim. maintain a separate residence, do not return to the scene, and do not possess any weapons or firearms. And counsel to the Public Defender's Office, you will make sure that that information is relayed?
Yes, Your Honor.
Okay, thank you, because if not, I would reset, but I will go ahead and do that at this time. Okay? And, Public Defender wasn't appointed, were they?
You-
I'll go ahead and appoint at this time, okay? Because I think that's part of the problem with not being able to contact. Do we have the warrant on the next case? It was the 2022
There's another.
CF 10619AO.
I don't know, she may revoke your out on bond because you have this. This is a new charge with the firearms.
Okay. Okay.
Doesn't matter. Listen, one condition of being a statute is law. The moment you picked up the firearm, so when the charges are similar in nature, they revoke.
All right, your name, please? He's got,
It does not matter.
well, he's gonna get a no bond anyways because he's out on bond.
See,
Mr. Torres, I believe?
Yes, ma'am.
All right, so you're here, and I'm sorry to the court reporters, I'm failing miserably on my scanning of our code. 2022 CF 10619AO, that's the new charge where probable cause was already found, aggravated assault with a battery, with a firearm, or rather, aggravated assault with a firearm, and then count 2 was battery, dating violence. He's out on bond on case number 2022 CF 10619AO.
and Your Honor, were you able to see the facts of that case, the warrant?
No, we're not.
I was not as well. If you're inclined to revoke his out on bond, I would ask that this be reset so we could actually get the facts of that warrant.
Yes,
Um,
I am very inclined.
Thank you. So I would just ask that it be reset for tomorrow so the state can provide the facts in that warrant.
Okay, so at this time, we'll reset, PC's already been found.
Yes.
So PC's already previously been found. We're gonna reset both cases for tomorrow for the actual affidavit for arrest warrant to be provided, okay?
Thank you, Your Honor.
You're welcome.
See about fighting not to revoke.
I mean, we know there's PC to hold.
Yes, Your Honor, I do.
Thank you, Your Honor.
So, and to the state, if you can start working on that, they've attempted to try to reach the officer on that, and they've not been able to get that affidavit uploaded, okay? PC was previously found. All right, your name, please?
Your Honor, Frankie Borges, mental health.
Okay,
And I will waive, Your Honor.
okay.
And I'll just point out that he has mental health history, Your Honor, multiple Baker Acts.
Let me just go ahead and read. I've got the warrant now. They've, I wasn't able to upload it in the office, but we've been able to get that.
The last case, Your Honor?
Yeah, this one, we have the warrant affidavit. I was not able to get it in the office, but I'm hoping now, I'll be able to pull that up. Okay, all right. Obviously, PC's already been found on case number 2022 MM6226AO. An affidavit for an arrest was already filed. And at this time, is there anything further from the state?
Your Honor, state would just bring your attention that he does have prior convictions of violent offenses, as well as, it appears, multiple open cases. At least 2 other Georgia cases that are currently open, an active injunction out of the state of New York that's non-expiring, and then I believe an open competency case here in Orange. State's just concerned regarding his willingness and ability to show back up to court to handle these charges. the state would just ask that you take that into account when setting his bond.
What bond would the state, was the state requesting?
Your Honor, with his history, I believe the AgBat DV, prior VOPs, another BAT DV, and given that this is also DV related,
So you're requesting a higher bond then?
yes, Your Honor.
Okay. Let me just look at one other matter here.
And Your Honor, my only argument is that, even though he has a significant history, the state's concerned about his appearance for court, but he has no failures to appear here in Orange County, and we've had multiple cases with him. I believe there's competency issues, as well as you can see the Baker Acts that he's recently had. So I just ask that you consider all those factors when setting bond.
What's happening with the open competency case, the MO 2022-667?
It's a city, so I don't know.
It's a what?
The city case.
Can you give me the case number one more time, Your Honor?
They're showing, I mean, I'm just looking at the information that's
22
on
MO 667.
the sheet here. MM 2022, MO, I'm sorry, 2022-667AO. He was found incompetent to proceed on that one. 2 active cases for warrants out of Georgia. And we don't have any extra, okay, they're interstate only, in-state only.
He's been evaluated by, looks like Dr. Aries, found incompetent, and it looks like it's in proceedings. They have a status for competency.
When is that status?
Let me see. It looks like.
Will you let the city know, or are you gonna let the city?
Month hearing. So it says, he was found incompetent July 19th. He had a 6-month hearing in January. So I am not sure if there's another one. That was the last.
That was the last one?
Yep, that was put in, August 9th. That was the last note that was put in, Your Honor.
Okay, so does he have he's got a status hearing in January?
He had one in
Oh.
January, and that was the 6-month hearing,
Okay.
so I'm not sure when the next court date is.
And you may just want to let them know I don't know what's occurring on that status date.
Oh, actually, it is, Your Honor. It's next year, January.
Oh, it is
11th.
January,
11 to
okay.
23.
They may want to pull that up then and move that up also. All right, at this time, Public Defender's Office is appointed. I will set bond in the amount of $5,000 under count 1, $1,000 under count 2, no return to the scene, no contact with the victim, no weapons or firearms, maintain a separate residence. Okay?
Thank you.
And in the meantime, I'm sure you will take, when I say I'm sure, I just suspect that you'll get that brought up and they can start that information also. Okay?
Thank you.
You're welcome. Your name, please? All right, Ms. Cassidy, you're here on case number 2022 MM6214AO. Now, a question we have for the appointment of the Public Defender's Office. You've marked off, or at least the mark shows the amount is a month. Is that a month or a year that you make $20,000?
Okay, so it's to pay my bills at home. I pay myself $20,000 a month.
Okay, you don't qualify for the Public Defender.
Yep, I figured not, but.
Okay.
She's like, you either go in by yourself or public defender. Like, it's $50. Okay. I've never done this, so I don't know.
Okay, that's fine. It's just, so you make $20,000 a month. You say you pay yourself, that's your income. Yeah, you won't qualify. Okay, but let's go ahead and evaluate your case. At this time, I reviewed the charge and affidavit. I do find probable cause. I don't think there's any witnesses here, is my understanding. Or I don't see anybody standing up. And let me get the sheet that I need here. this is where all my pieces of paper went crazy wrong. Because I did not have them set correctly. All right, at this time, I do find probable cause. I will set the bond, first of all, you're to have no contact with the victim, do you understand that?
Yes.
And that's directly or indirectly, it's absolutely no contact. You must maintain a separate residence, do you understand that?
Yes, I guess I need to hire an attorney to handle this for me.
Um,
I'm a stay-at-home mom, and my kids are homeschooled, so.
Probably, yeah, I
okay.
suspect you, yeah, I suspect you do, but I need to make sure that you understand this court's order is you must maintain a separate residence. Do you understand that?
Yes.
I'll also require you not to possess any weapons or firearms, and you've signed the no contact order, I believe, and you understand those conditions of that release. Okay, at this time, I'll set bond in the amount of $500 with those as the conditions of your release. And was there anything further from the state?
No, Your Honor.
Thank you. Just make sure you're in compliance with the court's order, because if not, the bond would be revoked,
Your Honor.
okay?
Your Honor,
Hang on 1 second.
Your Honor.
she does qualify for pretrial release.
What is the state's position on pretrial release?
There's no objection.
Okay, without objection from the state, I'll order pretrial release, okay? So you don't have to post the bond amount. You'll get out of jail through the pretrial release program, okay? All right, thank you, but make sure you're in full compliance with it, because if you don't, they will violate that pretrial release, so make sure you're in full compliance, okay? All right, thank you. All right. Your name, please?
Tyrone McGee.
All right, Mr. McGee, sir, you're here on a charge, sir, of violation of pretrial release conditions. You do qualify for the Public Defender's Office. I will appoint the Public Defender's Office to I'm sorry. You don't qualify. So how much are you, well, he may be gonna qualify if you're $1,500 a week, is that what you bring home?
Yes, sir. Yes, ma'am. Tax and stuff.
Okay. What's the state's position on the out on bond case?
Your Honor, given the allegations, they would ask that it be revoked. If Your Honor is uninclined to revoke it, they would ask that you at least revoke in double.
Mr. McGee, sir, I'm going to appoint the Public Defender's Office because I'm going to revoke the bond under that other case, and they're going to have to file an appropriate motion in that, and that's in case number 2022 MM 6227AO. I'm going to go ahead and appoint the Public Defender's Office on both that case, in case you're out on bond on, that you just got out on bond on.
Yes, ma'am. Classify myself about that.
I think your attorney probably would ask you not to do that, and I'm gonna let her, she's gonna explain why. I mean. These pieces of paper are just so.
Or do you have the out on bond as 10585?
105858, you're correct, I'm sorry. I said the wrong number, didn't I?
Understand what I want to do. And everything was going so fast today. That, you know, I want to give you a chance to take everything on what's going on. I can't even see what I'm
You're not here for the purpose. So I would recommend you not talk about.
Okay.
Thank you, Your Honor.
You're welcome. Again, in case number 2022 CF 10585AO, the bond will be revoked. That bond will be set at none on both counts. As to the new charge, 2022 MM 6227AO, the violation of pretrial conditions. Sir, and Mr. McGee, you don't need to say anything about the facts of the case, sir, because I think that's what your attorney was advising you not to do, sir. I need to make sure you completely understand this. You are to have no contact with the victim. Do you understand that, sir? All right, sir. That's directly, indirectly, through a friend, writing, a phone call. It's flat out no contact. Do you understand, sir? Okay, sir. I'm also going to require you not to possess any weapons or firearms, and you're not to return to the scene of where this occurred. And at this time, as to that new case, sir, I will set your bond in the amount of $5,000 with those as the conditions of your release, but the bond's revoked under that other MM case or CF case and set at none. But I did appoint the public defender's office on both of the cases so they can file any appropriate motions regarding the matter. Okay?
Tori, do we have a bond?
No, only on count one. You're out on bonds, no contact.
Okay. The next case we have is, sir, your name, please?
Sherrick Mesidor.
I'm sorry, what was your name, sir?
Sherrick Mesidor.
Mr. Mesidor, sir, you're here in case number 2022 MM 397AA. At this time, sir, I reviewed the charge and affidavit. I do find probable cause. At this time, I will appoint the public defender's office to represent you on the matter. I don't see any witnesses here. At this time, sir, I need to advise you, do you understand you are not to have any contact with the victim in this matter? Do you understand that, sir? All right, sir, I'm going to have you sign the no contact order at this time. Okay, and you understand, sir, no contact means absolutely no contact. Do you understand that, sir? Okay, sir. I'm also going to require you to maintain a separate residence. You're not to return to the scene of where this occurred. And I'm also going to require you not to possess any weapons or firearms. At this time, sir, I will set your bond in the amount of $500 with those as the conditions of your release.
And Your Honor, could he have that one-time return with law enforcement to gather his belongings?
Yes. I'll allow you to return one time with law enforcement to pick up your personal belongings. But when you do that, sir, make sure, I think you might, I'm not sure if you were standing here when I announced that. Make sure that you contact law enforcement first. Do not go there and then call law enforcement. You are to contact them first. They arrange the time and the place and where to meet you. And then you will follow their directions on where to, at that time, to pick up those items, okay?
Awesome.
And you understand, sir, if you violate any of the court's order, the court will revoke your bond. Do you understand, sir?
No.
Okay, sir. Was there anything further from the state?
No, Your Honor.
All right, thank you, sir. Your name, please? Ms. Santana, you are here in case number 2022, MM 6215AO. And let's see, I don't know if you qualify for the public defender. Don't believe you do qualify for the public defender. How much do you make every week or every other week?
Between 1,600 and like 1,700 every 2 weeks.
So around 1,600, which and how many dependents do you have? One. No. Okay. You don't qualify for the public defender at this time. You just don't qualify for the public defender's office. So, but I need to set the conditions of your release, okay? So at this time, do you understand that you're to have no contact with the victim in the matter? And that's directly or indirectly, through a friend, through a family member, texting, phone calls, no contact. Do you understand? Okay, and you signed the no contact form, I believe, in front of you. All right. You also are to maintain a separate residence. You are not to return to the scene of where this occurred. Do you understand that? Do you need to go back one time and pick up personal belongings? All right, I'll allow you to go back one time to pick up personal belongings, but when you do that, you contact law enforcement, they tell you when and where to meet them, and then they proceed to give you direction where and when you will meet them to go pick up those items. So don't go there and call people, you know, just don't. I mean, that'll be a violation of the court's order, so you understand that. Okay. I'm also going to require you not to possess any weapons or firearms, and at this time, I'll set the bond in the amount of $500 with those as the conditions of your release, okay? Was there anything further from the state?
No, Your Honor.
Your name, please?
Good morning, Ernest Lee Thompson.
All right, Mr. Thompson, sir, you're here in case number, sir, 2022 MM6224AO. I don't see any witnesses coming up. At this time, sir, you do qualify for the public defender. I will appoint the public defender's office to represent you. And at this time, Mr. Thompson, first of all, sir, do you understand you're not to have any contact with the victim?
Yes, I read it at the bottom of a paper they gave me when I came in.
Okay, but you understand, sir, that I'm now court ordering you to have no contact with the victim whatsoever. That's through a family member, friend. I know you were standing back there when I was making those announcements.
Yes, ma'am.
And you understand that's through texting. That is absolutely no contact.
Yes, ma'am.
Okay, sir. I'm also going to require you, sir, not to return to the scene of where this occurred. Do you understand that?
Yes, ma'am.
Do you further understand, sir, that you are to maintain a separate residence from the victim? Do you understand that?
Yes, ma'am.
And in addition, you're not to possess any weapons or firearms. Do you understand that?
Yes, ma'am.
Okay. At this time, is there a request to return one time the public defender's office has been appointed?
Yes, Your Honor.
Okay. Mr. Thompson, I'm going to allow you to return one time with law enforcement to pick up your personal belongings.
Yes, ma'am.
And once again, when you do that, sir, don't go there until you contact law enforcement. They will tell you when and where to meet, and then they will make sure that you are there at a proper time with them, okay?
Yes, ma'am.
All right, sir. At this time, sir, I'm going to set bond in the amount of $1,000 with those as the conditions of your release. Do you understand, sir?
Yes, ma'am.
All right, sir. Thank you. And the PD's appointed. Ryan Wilkinson, you want to come on up? All right. Mr. Wilkinson, sir, you're here in case number 2022 MM6219AO. The charge is battery, domestic violence. And ma'am, would you raise your right hand to get sworn in? Do you swear to tell the truth, nothing but the truth, so help you God?
Yep. Yes.
And would you state your name for the record, please?
Alice Jansen.
Okay, and the state may wish to inquire.
Good morning, ma'am. Can you please state your relationship to Mr. Wilkinson?
Ex-boyfriend.
Are you afraid of him?
I was.
You're not now?
No.
When you say you were, do you mean
At the time it
yesterday?
happened.
Okay. Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future where you felt threatened, would you feel comfortable calling 911?
Yeah.
And do you want to have contact with him while this case is pending?
Yes.
State has no further questions, Your Honor.
No questions from defense.
All right. Mr. Wilkinson, sir, I'm going to require you to have does the state object to the no violent or hostile contact?
No, Your Honor.
I don't see any history. I know he's out of the country, but I don't see any history. All right. I'll allow you to have contact with her, but you understand, sir, that there can be no violent or hostile contact. Do you understand? Okay, sir. I will appoint the public defender's office to represent you. I'm going to also court order you not to have any weapons or firearms. Do you understand that also? All right, sir. At this time, I will set bond in the amount of $1,000 with those as the conditions of your release. Okay? Anything further from the state or the defense?
No, Your Honor.
That's it. That's just the attorney's number.
sir, your name, please? Mr. Williams, sir, you're here on a charge, sir, as the following, and the charge is in case number 2022 MM6221AO. The charge is battery, domestic violence. I've reviewed the charging affidavit. I find PC. In fact, I found PC to all the cases. I know I have noted. I will appoint the public defender's office to represent you, okay? You've got an attorney. She's gonna probably want to speak to you before you say anything out loud.
Thank you, Your Honor.
Okay, you're welcome. At this time, sir, you're to have no contact with the victim. Do you understand that, sir? And I've got to have you answer out loud.
Yes, ma'am.
Okay, and the reason is we're being recorded, and I can see everybody shake their head yes, but I need to make sure the record's clear,
Yes.
you know, as to the conditions. I'm also going to require you, sir, not to return to the scene of where this occurred, that you are to maintain a separate residence also. Do you understand that?
Yes, ma'am.
And you are not to go back to the residence to where this occurred. I'm also going to require you, sir, not to possess any weapons or firearms. Do you understand that? And
The one-time return, Your Honor.
I will allow you, Mr. Williams, to return one time with law enforcement to pick up your personal belongings. But when you do that, sir, don't go there. You know, you contact law enforcement first. They arrange the time and the place to meet you, and then they proceed to meet you there. Don't go there and call and say, I'm here to pick up my items. The court gave me permission to do so. You contact them first. They arrange when and where. Do you understand, sir? Okay, sir. At this time, I will set the bond in the amount on count, well, it's one count. I will set, well, he's out on bond on a Dwellis.
Your Honor, state would just bring your attention, there's pretty significant history between this same victim and the same defendant. I believe there's been at least 4 with this same victim and at least 4 other bad DVs with another victim. I think the most recent with the current victim, Ms. Mitchell, that I see is April of this year. So state we just ask that you take that into account when setting bond, as this seems to be an ongoing issue between the same victim and the same defendant.
Your Honor, as to the out on bond, given that it's unrelated, nonviolent offense, I would ask that you take no action. But I also would ask that you appoint us to see what we can do to help him get a driver's license so he does not continue to pick up these driving while license suspended charges. I don't see that anyone is appointed on that out on bond.
Okay.
So we have a program that could assist.
Okay. He qualifies, so I will appoint the public defender's office under the out on bond case of 2022 CF 10019AO. And as to the new charge, is there any request on behalf of the state on the Dwellis or just a higher bond on the new charge?
Your Honor, state will leave it within your discretion, but state would ask for a higher bond on the BAT DV as there is a significant history.
Has the state charged the Dwellis yet? Maybe not.
Usually they file the citation.
Well, I think it was charged
It's
as
a
a felony,
felony.
so it would require a,
That arrest was August 28th, so it's been 15 days. We have not yet filed on it.
okay. At this time, I won't take action on the out on bond case, but I am going to raise the bond on the new charge at this time. And Mr. Williams, you do need to understand, sir, that you violate this court's order, the bond will be revoked under both cases. You understand, sir? All right, sir. At this time, and you understand what no contact means. I mean, I think I've made it abundantly clear, but I need to make sure you completely understand.
Yes, ma'am.
And you understand you are not to go back to that residence, and you understand you're to have no contact, and you must maintain a separate residence, and you can only go back one time with law enforcement.
Yes, ma'am.
Not on your own. Do you understand, sir?
Yes, ma'am.
All right, sir. At this time, I will set bond on the new charge at $3,500 with those as the conditions of your release. Okay? Was there anything further from the state?
No, Your Honor.
In that bond amount?
We'll be in contact with the case, okay? See what we can do.
And one last matter, on Mr. Williams's case, did the state charge on those, or were they dropped?
She declined to prosecute.
Okay, that's, all right. I just wanted to make sure there wasn't something pending.
No, Your Honor, there's not.
Do they point on the, out-of-county cases now? Do they appoint? Yeah, they don't appoint? Yeah, right, okay. Your name, please? Ms. Ortiz, you're here on an out-of-county warrant. That bond has been set at $4,026. Pinellas County will be notified or has been notified to pick you up, okay? If you bond out, make sure you attend your court appearance date. If you don't are not able to reach the bond, they're notified to pick you up on the matter, okay? All right, thank you, ma'am. I don't mind, are those my sheets to sign? I'll start signing. Your name, please?
Landy.
What's your last name?
Landy Novoa Reyes.
So you're here on the following charges. It's an attempted burglary of a dwelling, possession of cocaine, possession of a concealed weapon by a convicted felon. The, let's see, you also have a violation of, let me go ahead and give the case numbers, 2022 CF 10611AO. That's the new charge. You then have a violation of probation under case number 2020 CF 154AO, and then an on-view violation of probation for that same number, 2020 CF 154AO. All right. As to the new charge, sir, as to all the charges, I'll appoint the Public Defender's Office to represent you on the cases. So I've appointed the Public Defender's Office to represent you. On the violation of probation, sir, your bond has been set at none. The officer did an on-view, but there was also a warrant already signed.
Your Honor, given that there was a warrant, instead would ask that hold and just do an ROR on the officer's on view.
So how are they going to be able to distinguish this? Because they both have the same case number. That's what worries me. I'm showing they're crossed out 154.
Is it better just to no bond both? Okay.
Yeah, I'd hate to, if they switched.
I will put a note.
Yeah, just put a note. We all know that it's under one case number. I mean, they're both going to merge because they're one case, even though they came in separately as a third arrest affidavit, just so everybody knows. That'll be stated no bond, okay? You have the Public Defender's Office appointed to represent you on the case. And as to the new charge, probable cause, bonds will remain the same, $3,500, $1,000, and $4,000. You're not to possess any weapon or firearm. You're not to possess any illegal drugs. And also, sir, you're not to return to the scene of where this occurred and no contact with the victim. Okay? Okay, everyone. I think now we have 33 days. And, oh, good, they're paper clips, so I don't have to dig, right? Okay. Go ahead and get paperwork done here. All right, we have the following 33-day motions. And so here we go on them, everybody. We have case